set. Good morning, all. I wanted to say that today is already September 8th. We are meeting virtually, and so a part of the process is that we must take a roll call of my fellow commissioners. Good morning, Commissioner O'Brien.
Good morning, I am here.
Good morning, Commissioner Hill.
Good morning, everyone. I am here.
Good morning, Commissioner Skinner.
Morning, I'm here.
And good morning, Commissioner Maynard.
Good morning, Madam Chair. I'm here.
Okay. Today is, as I said, September 8th. It is the public meeting number 390 from the Massachusetts Gaming Commission. We'll get started, but if you allow me, I just would like to make a few opening remarks, and I will invite my fellow commissioners to weigh in afterwards before we turn to Treasurer Goldberg, and we're very honored to have her presence today and members of her team joining us on our first agenda item. As we get underway today, I want to offer a thanks to the team at the Gaming Commission and to my fellow commissioners. For those of you who may not be familiar with the Gaming Commission's work, I wanted to just offer a little bit of an explanation that we are a public body that is required to do all of its work in public. We're bound by the open meeting law, and we take that seriously. Commissioners can't get together outside of a public forum to discuss or work on any matter. We simply must perform our work in public. Today's meeting is called a public meeting, which simply means a meeting of the Gaming Commission held publicly. We stream these meetings for easy access to the public. The discussions you hear in these meetings is a product of each of us having worked to understand the issues in front of the commission. And sometimes these meetings include experts and other invited guests. Like today, we are fortunate to hear from Treasurer Goldberg. Public meetings like today's are different from public hearings. Those hearings offer the public the opportunity to weigh in on our work. We will be scheduling soon public hearings to hear from the stakeholders and the public at large. Also be inviting written comments. Our process will not be complete without the public's input. All of our meetings are posted to our website and YouTube channel. I want to thank our team for the work put in to prepare the items we'll discuss today, and of course, at future meetings. I appreciate the attention on these meetings and passion for the topics we plan on discussing today. We plan our meetings with the intention to have impactful discussions and deliberations that move issues forward. Today's agenda is focused on sports wagering. You will hear discussion that focuses on critical internal work needed to stand up this new industry. Our goal with this process is to make sure that such sports wagering is introduced correctly, operationally, and legally for the benefit of integrity and consumer protection. We accomplish this goal by working diligently to develop policy, establish a regulatory structure, and equitably, fairly review and license potential operators. We know that the NFL kicks off tonight, and that due to the nature of sports wagering, interest is peaked. We are rooting for the Pats. Our process will play out as it would have whenever this law came to the Gaming Commission to regulate, and we will not compromise getting this right for anything. With that said, we also are aware of the import of timing. But there's also a great deal of work to do, not just on the issue of sports wagering, but also prioritizing the integrity of gaming across the Commonwealth and continuing the impactful programs across our divisions, such as community mitigation, responsible gaming, and our other essential teams. I want to thank you all at the Gaming Commission for that continued commitment. I want to thank our Executive Director Wells for her leadership on that. I just want to turn to my fellow commissioners to add anything else before we turn to our esteemed guest. Good morning again, Commissioner O'Brien.
Good morning. Thank you, Madam Chair. Yes, I'm thankful that you made that statement on behalf of this body and pointed out how we function as a body. There are people on the staff who went through this process with the casinos and the launching of the brick and mortar casinos that we have. And I, for one, intend and think everyone here intends to uphold that standard of excellence in terms of executing our statutory responsibility to launch sports wagering in the Commonwealth, but to do it in a way that is responsible, fair, and inclusive of all of the interests. And while we are mindful of the fact that there are people out there who are very anxious to start being able to place the wagers in the Commonwealth, I do want people to understand that looking at the various states as well outside the Commonwealth who have done this, I believe the median is about 8 months from the signing of the legislation to the actual placement of the first bet. I think Maryland itself took a couple of years before they even had the application ready. Our staff has done a tremendous amount of work in anticipation of the possibility of this being put on our plate. I think they are doing a fabulous job. They're putting their heads down and they're getting the work done to do this. But as you said, we intend to do this correctly and as quickly as possible, but correctly is the priority. Thank you.
Thank you, Commissioner. Commissioner Hill.
Thank you, Madam Chair, and thank you, Commissioner O'Brien, for your comments. And I want to just share a little story of something that happened to me this morning as I was driving into Boston, a 40-minute ride that took almost an hour and 45 minutes to get in, a lot of traffic, which allowed me to be able to listen to sports radio longer than I normally do. And as I was tuned into 98.5 today, I was listening to the Tetra and Rich show, which is usually is a very entertaining show. But today I actually got a little frustrated with it because they had a guest on and they were talking about sports betting. And they made a comment that some think that we might be able to make a bet in 3 weeks at our brick and mortar casinos and our simulcasting facilities. And obviously that's not going to happen. And it was frustrating because of the hundreds of thousands of people that listen to that show and think that they might be able to place a bet here in Massachusetts. Was frustrating. So, Madam Chair, I was very happy to hear your comments and to share with Commissioner O'Brien and her comments that other states who have done this, it has taken a while for them to be able to put regulations together, and in some cases, as was mentioned, up to 2 years. And I'm not saying that's what's going to happen here, obviously, but I hope that the media can understand that putting information like that out to popular shows is very harmful, to the process, I think. And if they want the information and correct information, they can tune into us almost weekly from this point on and get updates of what's going on. And I share with Commissioner O'Brien and her comments, our staff and certainly the commission is working very, very hard to get this up and running in a very timely way. I'm very impressed with what I've seen so far. And I think the discussion that we're going to have today will enlighten a lot of people where we are and what we're going to be doing in the next few weeks. But, it was a little frustrating to hear a popular radio show put out information that I think was, sadly, not even close to being the truth. So with that said, Madam Chair, I'm looking forward to today's meeting, and I'm certainly looking forward to our treasurer and her remarks as we start this meeting. Thank you.
Thank you. Commissioner Skinner.
Good morning again, and thank you to my fellow commissioners and to the staff who have been working so hard over these past several weeks and months to prepare for this new law. Commissioner Hill and Commissioner O'Brien and Chair Judge Stein have laid the foundation, really, the expectation for the going forward. I know, I'm eager to get this statute implemented, but I want, folks to understand that there is a lot to understand in the gaming world, from things like consumer protection, to responsible gaming, to the technology standards, some of which, we'll hear about today. But I want to make sure that we are informed about what it is we are undertaking as an agency, that we are diligent in implementing the statute, that we are upholding the same level of integrity and licensee operations that the Commonwealth has come to know in the gaming world. That will take some time. We are putting in that time, over time to make sure that we are in a good place. We'll get there. It was said yesterday that we will have fun while we're doing it. We are in this together, and we just ask for the public's patience as we move forward. Thank you.
Thank you. Commissioner Maynard.
I love having the benefit of going last, Madam Chair, because usually all the good things have been said. But I do echo you, Madam Chair, and the fellow commissioners. We take our charge very seriously. We want to ensure that sports wagering happens swiftly, but safely. The team here is taking every measure to ensure a fair process for all applicants, and we appreciate all the interest in this topic. I truly believe that the more input we get through roundtables and through other forums, the better. I also appreciate that Madam Treasurer is joining us today, and I'm excited to hear her thoughts on this important topic.
Thank you. Thanks so much. And for that, we thank the public for its patience on just our trying to clarify our obligations as this agency. And we again thank the legislature and the governor for its trust in us to do this right. And now we turn to Madam Treasurer. Good morning, Treasurer Goldberg. It is just a delight to have you here today. And we thank your members of the team too. And if you want to maybe introduce them, that would be great.
I'd be happy to. First of all, thank you, Madam Chair and commissioners. It's a delight to be here with you. Obviously, I would love to have seen you all in person, but we're at least able to do this kind of public meeting. And in fact, what we are finding, which I'm sure you are too, is that you get increased attendance by including remote options, less difficulty having quorums. It allows people from across the state to join in. And so I am hopeful that in the future, we will support the combination of hybrid meetings because it invites increased participation, and particularly for the public. So I'm delighted to be here with you today. And I appreciate your deliberate and transparent approach to the regulation of sports betting, which you just shared with us, which I very much concur with. In fact, as we sort of worked our way through looking at the potential regulations and we're trying to understand some of the ambiguities, we were working on clarification, and I'm sure that you are doing absolutely the same. And since many of us on this call in these kind of roles understand process takes time, I'm a little surprised by what you heard Commissioner Hill on the radio this morning, but I'm not completely surprised because I at times am on with those folks and they're open to correction. They sometimes are having fun. So I'm joined by Mark William Bracken, who is not only the interim executive director of the Massachusetts State Lottery and doing a superlative job, I might add, but he also serves as assistant treasurer and executive director of the Unclaimed Property Division. My policy folks are on the line, among others, and we have some just watching from your YouTube channel. But today, questions can be directed to myself and to Mark because we look forward to discussing the many points of intersection between your work and our work, which includes the lottery, financial education, and prior to jumping on the line, you heard me talking about baby step savings plan and savings for the future being one of the best ways to avoid debt. and that is an issue in terms of when people are doing responsible gambling. But this might surprise you. There are actually unclaimed property issues that have come up as we've looked through the regulations. So turning first to the obvious, the lottery. One of my primary responsibilities as treasurer is to ensure a consistent and growing source of unrestricted local aid for all 351 of our communities, our cities and towns. And as you draft sports wagering regulations, I urge you to look at and incorporate provisions that will enable the lottery to continue in that vein, to deliver consistent revenue as a direct result, valuable resources for every community in the state. Just for some perspective, lawmakers project that sports wagering will generate $60 million in state revenue annually. Only 16.5 million, which is 27.5%, will be earmarked for unrestricted local aid. By contrast, the lottery produced approximately $1.1 billion this past year for our cities and towns. Simply put, the lottery plays a very vital role in generating unrestricted local aid for our communities, and it is imperative that we work to ensure it continues to do so. We already are facing mounting headwinds. In fact, we're actively monitoring a concerning trend. Sales of the lottery's top two product categories, scratch tickets and Keno, which together make up nearly 88% of all lottery sales, were down 6% and 5% respectively last month. When I looked at the numbers for this past week, that trend was continuing. Combined with new entertainment options soon to be available to consumers who have increasingly limited resources, I'm concerned that this trend will negatively impact the lottery's ability to deliver the levels of unrestricted local aid that it has grown to do so. To help hold local aid harmless, I seek sports wagering provisions that mirror the regulations governing the existing gaming licenses, specifically requiring that prior to receiving a license, applicants present a plan to mitigate any impacts on the lottery, and requiring that licensees partner with the lottery on cross promotion, both in person and online. So far, that we have found that this framework has resulted in a productive, not to mention profitable, relationship with existing licensees. For example, the Plainridge Slot Parlor is one of the lottery's top performing retailers, and we are building towards similar results at MGM in Springfield and Encore in Everett. I am confident that implementing the same framework for the lottery's relationship with respect to sports wagering will prove beneficial both for operators and for the local communities that depend on the lottery. Looking further down the road, I strongly encourage the Commission to include the team of experts at Lottery and at the Treasury as part of the required study of the feasibility of allowing retail locations to operate sports wagering kiosks. Many of the interested locations are licensees of the lottery and or the Alcoholic Beverages Control Commission, which also falls within the purview of my office. So as you can see, I feel we can really add to the conversation. I would also like to note how much I appreciate and value our partnership when it comes to financial education. My team at the Office of Economic Empowerment has enjoyed working with you to train Game Sense advisors on all of the tools and resources that we have available to benefit players. We also look forward to incorporating casino gambling and sports wagering modules into our Credit for Life Fair programming. And for some perspective on that, Prior to COVID, we had already reached 50,000 high school students in those fairs, and we're developing different ways of reaching them via online and in-person programming as we move forward. Critical time for kids to be learning about these things. I welcome the opportunity to build on this and expand this partnership to meet needs as they change. Finally, I encourage you to look at the example of other states, Iowa in particular, when it comes to abandoned accounts. I recognize the legislature specified that unclaimed winning sports wagers shall be deposited in the Sports Wagering Control Fund if no claim is made for the winning wager 1 year after the relevant game or event. However, the legislation does not speak to abandoned or stagnant accounts. Currently, the leading sports wagering firms do not treat these accounts as unclaimed property when unregulated. Instead, they take them into revenue after a certain amount of time through drawdowns and fees. While my office would consider these accounts miscellaneous accounts and reportable as unclaimed property as defined by state statute, clear definitions and administrative rules will protect consumers, enabling enforcement through the Treasury's Unclaimed Property Division. Left unaddressed, I am concerned that operators will continue to implement business practices that we here in Massachusetts would deem inappropriate and in violation of state law. So with that, I thank you again for the opportunity to speak with all of you today. I am certain that it will be the first of many conversations, and we are happy to answer any questions that you may have. And now you see why, in particular, I have Mark Bracken on the line, because he has two hats on, both of which I'm sure you have questions about.
Thank you so much, Treasurer Goldberg. I'm going to just open it up for, in no particular order, who wants to lean forward and address it? Okay, Commissioner O'Brien, there we are.
Hi, yes, thank you, Treasurer Goldberg. I was pleased to get the letter, pleased to hear you speak today, and also wanted to reiterate, I had raised that question in terms of ADW accounts, which, as you point out, there's the winnings that aren't claimed, and then there's sort of the preloaded value on those accounts that are currently not treated like abandoned property. It's a practice in the industry, as I was told, that's been going on for quite some time, but particularly going through the regulation draft process right now, it's an opportunity, I think, for the Commonwealth to once again lead in terms of protecting the consumer in this industry. So I thank you for taking the time today on that topic, as well as the others that you talked about today. Looking forward to working with the lottery going forward.
Thank you, Commissioner. What's interesting, just another aside, not to make Mark blush, but Mark led the Unclaimed Property Administrators nationally. So he is not only aware of what we do here in Massachusetts, and not surprising, Massachusetts leads in this space, but he also has an understanding of what that was why. How often do we cite Iowa when we're talking here in Massachusetts, but why we know what is being done in other states across the country. And I think we can add to a lot of these conversations.
That's excellent. Commissioners, any questions or comments for the treasurer?
No questions, but a comment. Thank you for coming this morning. And I too look forward to working with you and your administration as we put our regulations together. These are very important issues, and we recognize that. And for you to come on personally, meant a lot to all of us.
Thank you, Commissioner. I want to reiterate when I was referring to the study group, I'm sure you are aware that we have thousands upon thousands of retail operators, and we're very, very engaged with them. The lottery has made a meaningful difference in a lot of mom and pop operations and a lot of operations across the state. We're anxious to grow their business always. And so I think that we have a unique understanding of them and them in the wagering world. So I want to reiterate that I believe we can add a lot to the conversations as you look at that kind of opportunity.
Commissioner Skinner.
Thank you, Treasurer Goldberg. Mark, I didn't get a chance to say hello earlier. Good to see you.
Commissioner.
Madam Treasurer, your comments are very important. I think this is the right time to be considering your proposal as we move forward to draft regulations. It's a no-brainer for me. And I hear from at least two of my fellow commissioners that they also think that this is the right direction that we should be heading in as an agency, as a body. I did get a chance to review the Iowa processes, those rules. I think that's a good model for Massachusetts to look at, and certainly other jurisdictions. But I thank you for providing at least the foundation, the basis for us to start thinking about these very important consumer protections.
Well, what's interesting is, I brought up Iowa, but of course we in Massachusetts always want to do it a little bit better.
Absolutely.
What would you add? Is
Mark?
there something in particular you would add in terms of versus Iowa? Is there anything, Mark, that you note?
I'm sure Mark has ideas.
Yeah, so we can revisit. I'm not putting you on.
Yeah, I mean, no, that's fine. I think more specifically, it's because it's not enumerated exactly inside the state statute. We're doing it through the reg. Obviously, Iowa does it in 4 sentences. New Hampshire does it in 2, and they just kind of punt it off to the unclaimed property law. I think it would be nice to have a couple specific action points inside the regulation, not just referencing Chapter 200A, but also just putting on notification some of the consumer protections as we spell out, because then a lot of times in our state statute, we then kick some of the stuff into our regulations. So it could be confusing for a licensee to go from their regulation to statute to our regulation, where I think it can possibly be done directly through the gaming regulation. And we'd be happy to send over a couple of those bullet points if you're open to that. One of them would just be notice to consumers, because that's really kind of the impetus here. And I know Commissioner Skinner kind of, she used the terms that the 2 words that we like to hear best, consumer protection, in her opening statements. And that's really what this law is about. A lot of people don't realize this law was enacted in 1952. So we're celebrating 70 years of unclaimed property consumer protection. Annually, we're returning over $150 million directly to the hands of people in Massachusetts, and we're taking into custody anywhere between $200 and $250 million to protect that money, so it doesn't get lost out in the business world. So we're very proud of what we do with the Unclaimed Property Division. We're diligent in returning money, and also, we have been able to work with some of the casino, the current licensees of the brick and mortars, especially Plain Ridge Casino, has been very generous to us about giving us space to put, when we do our tangible property auctions, we get to go, they give us space to put our stuff out on display at the casino because it's high traffic and you get a lot of great eyes on it. And we've been in conversations with MGM out in Springfield to do the same thing. So we already have a symbiotic we already have this relationship with some of the casinos, much like the lottery does, as the treasurer mentioned. And we just want to make sure that both it will be less the brick and mortar and more the online licensees, because these will be actual accounts that we're talking about. We already understand 23N already contemplates the uncashed tickets, but these are really players' accounts where if they had a winning or deposited money, that money's sitting inside their account. So we want to make sure those accounts are protected. And like I said, we'd be willing to send a couple bullet points over that we think could strengthen Iowa's law. But like I said, in the end, New Hampshire did theirs in 2 sentences, Iowa did theirs in 4, and they both work. So, once you get past the concept of this is what we want to do, it's not a difficult feat to, I'm sure this will be one of the easier parts of the regulation.
Thank you, Mark William. I can attest to that mission, because the first time I met Mark, he looked me up, and I I did have unclaimed property and it was over $1,000 and I felt like I had won the lottery. So thank you.
Interesting connection between the two.
Yeah, very, I repeat that often and promote that program because of it. I wanted to just get back to a couple of your points. Well, I want to first turn to Commissioner Maynard.
Thank you, Madam Chair. Thank you, Mark, and I am happy to learn of your leadership at a national level. I know that we've had an opportunity to speak before, but I also knew of the Treasurer's leadership at a national level. And when I was looking at the letter yesterday, it hit me that you would have all sorts of insights, Madam Treasurer, on what's going on throughout the country. So I appreciate you highlighting Iowa for us. And to echo Commissioner Skinner, I look forward to this partnership continuing in a new way and welcome it. So that's all I have, Madam Chair.
Thank you, Commissioner. And one of the things that I want to reiterate is when you talk nationally, and I tell people about the Massachusetts State Lottery being the source of unrestricted local aid and the numbers that we do, and on a very, people are shocked at our tiny operating overhead and how much actually goes back. It's highly unusual for it to be going so in unrestricted local aid. Now, for those on the call who aren't aware of why this is the case and why it's unusual, is when Proposition 2.5% was instituted in the 1970s, there was enormous concern, particularly on the part of Treasurer Robert Crane, that local communities would suffer dramatically. And so the lottery, who is celebrating their 50th anniversary this year, was created specifically for that goal. And it is, I'm a former chair of the Brookline board of what is now called the Select Board, but at the time was Selectmen. And I said, just don't worry about it, just select me. I will tell you, those were essential dollars. Just thinking back quickly to 2015, when we had 110 inches of snow, there was no local community that hadn't, we have snow and ice removal funds. It's a line item. Nobody had that kind of money. And that's exactly what it was used for. So it's a really, you have to sort of have a tactile sense of what the lottery means to our communities and our state to understand why we need to protect the Massachusetts State Lottery. And particularly given that we are not online and some of our competitors are increasingly online, we need to develop some relationships that ensure that the lottery is able to sustain itself. And when we come to those conversations about what happens within our retailers, it's important because we're all public servants here. At the end of the day, we have to think of what's in the best interests of the people in our local communities. And that's what the Mass State Lottery is about, as is returning unclaimed property. And just so you know, Madam Chair, I rush to the new list and call everyone I know, and I become the most best friend and most popular person they have in their Rolodex for quite some time.
It was a very exciting moment. I think Mark probably saw me jumping out of my seat. So, so thank you. Just a couple of quick follow-ups. We will follow up with respect to the lottery piece. I want to just note that, and Karen, Director Wells, you can correct me, perhaps Commissioner Skinner or Director Lilios, but we were in Nevada for a seminar on sports betting. And I learned what was, I thought, a remarkable fact that the casino industry, and it doesn't include their entertainment and hotel and restaurant, just the gaming business raises $1 billion annually. Treasurer Goldberg, make sure I'm right on that, but that's a fun fact for you to know because I said, oh, that's really interesting. Massachusetts State Lottery actually raises 1.1 billion. So, I did think they might want to reconsider their tax rate, perhaps, right? But just as a note, is that your memory, Commissioner? And were you there
That
for
is my
that?
memory. Yep, that is exactly my memory. Yep.
Yeah.
Well, it
yeah.
is why I'm trying, that is also why when I began my remarks, I wanted to, explain that, and I always explain publicly, my profits at the Mass State Lottery belong to the people of Massachusetts. We're not a private profit-making enterprise. We're a profit-making enterprise, but that is for revenues to go to the people in our state. And that's a very, very different mission. And so when we're looking at numbers and actual business operations, it's really critical to keep that hat on, keep that perspective on. And I believe, Commissioner Hill, you were working on the original gaming legislation, and I know how deeply you care about your own personal local community, that was one of the reasons why holding the lottery harmless was a phase that was always highly esteemed in those deliberations. And it's more complicated today with things being online, the Mass State Lottery not being online, but we believe we could develop ways of cross promotion, and potentially, hopefully we will be online someday, in order to fully be able to compete and exist in the world as it has evolved.
Thank you. Just a couple closing remarks. We do, for those who aren't familiar with our regular day-to-day business, we have quarterly reports from each of our current licensees, casino licensees, and they do, in each quarterly report, always report on their lottery sales. And that is a reflection of that mandate under 23K to hold the lottery harmless, and to make sure we protect that valuable asset for the state. It's noted that it wasn't in 23N, and we'll be exploring, what this implication is for us. And we're very pleased you brought it to our attention. And I'm also pleased to say that we're delighted with our current licensees' collaboration on that effort. So the second part I wanted to note is that I think our Director of Responsible Gaming is on, Mark Vanderlinden. He's been working as well as Commissioner Hill and I with your team. We're very, very appreciative of their work on the financial literacy. I had been hopeful for that. It took another great state public servant at Pulaski to connect us all together, and I appreciate his work to do that. And I know Emily is on. We just are very appreciative of that work. We would love to be able to give those tools to new gaming members, and also those who are on the other end, who are at some point where we can give tools for those, or really credit reforms, whatever, for those who have gotten into trouble. So we appreciate that partnership. It's been very exciting. But I wanted to close with Mark. Mark Vanderlinden's just joining us, but Mark will be addressing the two studies that we need to do by statute. And I had already mentioned to him the need to work with the lottery on the kiosk question. So your letter only reflects our intention. So we'll make sure that absolutely your team is included. That's those establishments. I know how much they enjoy Keno at so many of those establishments. We know that it will be critical to understand the impact on those establishments and the lottery. And finally, I think we've all talked about the abandoned properties. I think that that's going to be something that will be quite simple to address. So thank you. Any other further comments?
Madam Chair, I appreciate you touching on the other points. I know a lot of the focus of the discussion was around the abandoned accounts. So thank you for kind of tying it all together. And I do look forward to working with you, Madam Treasurer, you, Mark, and I know Emily is on. Hi, Emily. But looking forward to working with you in these very important initiatives.
Anything else, Treasurer?
No, I really, of course, it's very helpful that, Madam Chair, you have a great deal of understanding about the operations within the Treasury and how they interrelate. as do your other commissioners. So I was delighted, Commissioner O'Brien, when you were the first to respond about your concern about that type of consumer protection. So with that, I think that we have a really good start on, and we can work together on ensuring that we ultimately have the best product of sports gambling for the people within our state, while at the same time making sure that in the future we protect the other things that help support our local communities. And I always tell people, local communities aren't bricks and mortar. They're the people who live there. So thank you for your time.
And thank you. And this, I think, was a perfect way to convey this important message. Thank you so much, Treasurer.
Thank you for having all of us. And we're here to work with you.
Yeah, thank you. Okay, so we will now turn to, I guess, our next item, which really is a general item under Director Wells. We'll get started. Good morning, Karen.
Morning, Madam Chair and members of the Commission. So we have a number of items on the agenda, and I'd like to just note that these really all impact the timeline. I know, obviously, you heard from Commissioner Hill, a lot of people interested in moving this forward. I understand that. So there are a lot of items on today that will help move the process forward. We've got some discussion on the reg structure. Certified independent test lab regulations will help us move more quickly. House rules, staffing internally will obviously help us set this up. The licensing criteria discussion, and then technology approval. So it's quite meaty, and there are a lot of substantive issues this morning. So I'm going to turn it over to our General Counsel, Todd Grossman, to get started.
Thank you, Karen. Good morning, Madam Chair, Commissioners, and all who are joining us here today. We are, of course, about to embark upon a journey that will see the Commission review a sizable number of regulations in the coming weeks and months. And as we've discussed in the past, the regulations will ultimately serve as the framework which will guide many of the critical decisions that the Commission will be called upon to make, ranging from temporary to initial licensing, the approval of the commencement of operations, all the way through to ensuring the lawful operation of both in-person and digital sports wagering operations. So before we jump into looking at specific draft regulations, we thought it would be beneficial to address a few important legal issues and principles that may help inform that decision-making. We'll first ask Lon Povich, who has joined us, and there he is, from the firm Anderson and Krieger. And he's actually, we have a number of attorneys from the firm joining us here today. You'll see Mina Macarius and Dave Mackey on as well. They've been offering us tremendous assistance and counsel to date, and will continue to do so throughout this process. But today, we'll ask Mr. Povich to address two issues for the Commission. First is the role of regulations versus policies, and then to get into the promulgation of regulations by the use of emergency promulgation provisions of the law. Then I'll address some of the administrative issues related to the filing of regulations with the Secretary of State's office, including the assignment of section numbers. We'll then move into two actual sets of draft regulations for your review. We're not intending necessarily to review the entire regulation promulgation process here today, as we've done in the past, but we can certainly touch on some of those laws and principles as well. So then I'll present that first set of regulations. Those relate to independent test labs. After that presentation, we'll turn to our Associate General Counsel, Judy Young. We'll be joined by Burke Kane and Sterl Carpenter to present a draft of the House Rules regulations. So with all that as just kind of a preview of coming attractions, I'd like to turn things over to Lon Povich to jump right in to those matters I just mentioned. Good morning, Lon.
Thank you, Todd. Good morning, Chair Judge Stein, and to the commissioners and to all of you who are joining us. It's a pleasure to be with you this morning. I've really been asked to discuss two issues, sort of the scope of when regulations are a better choice to use to put in place governance matters versus just a standing policy. And second, the issue of using the emergency regulatory powers in Chapter 30A as opposed to the regulatory process that we're most familiar with, whereby a public hearing is held before the regulations. Turning to the first question, you know, the Administrative Procedures Act, as interpreted by the SJC, provides a broad definition of regulations and should be interpreted accordingly. The leading case is Carey v. Commissioner of Corrections, which, as I said, was decided in 2018. And it basically said that if policies relate to the organizational structure of the agency, they can be in policy form, but anything that substantially affects the public should be in the form of regulation. And obviously, this is one case. It's been followed by a Superior Court case also around the Department of Corrections with the same type of language. But basically, although they're just words, it does lay out a pretty strong preference for regulations and the use of the Chapter 30A regulatory process when such rules are being established by a commission, this commission. In addition, and I apologize if there's a little background noise, sorry. In addition, the Gaming Commission has a long precedent of issuing lots of regulations governing the brick and mortar casinos, as you've discussed. And one would think that things that were covered by regulations as to brick and mortar casinos might equally be governed by regulations relating to the sports wagering process that you're undertaking. So, you know, there's a mosaic of what's going to go on here. There's some temporary licensees, which we can discuss in a minute. There are more permanent licensees. These things will have to get rolled out over time, I assume. But generally speaking, as we put together a plan for the regulation of this industry, one would think that there would be a strong role for regulations following the precedent of the commission before, but also in some appropriate cases, the use of internal policies, all consistent with Chapter 30A and the guidance from the SJC. So that's a medium level overview of the first issue, which is regulations versus internal policies, referencing the guideline between things that affect the public broadly and things that are more directed to internal management affairs. So I'll just pause there for a second to see if there are any questions from the commission or the staff on that first point.
Any questions? Good morning, Juan.
Morning.
Okay.
Okay, the second issue which we were asked to look at is the appropriate use of the promulgation of emergency regulations. And at the highest level, the difference between emergency regulations, which can go into effect immediately upon the adoption by the commission under a standard that I'll discuss in a minute, versus the traditional 30A process, is that the public hearing in emergency regulations takes place after the regulation goes into effect, instead of before the regulation goes into effect. So emergency regulations can be adopted immediately upon a finding by the commission that the regulation is necessary for the preservation of the public health, safety, or general welfare, and that observance of the requirements of notice, or the delay to allow the requirements of notice, would be contrary to the public interest. So that type of finding would have to be made by the commission at the time that regulations were adopted as an emergency regulation. And the commission is, under the relevant case law, given every presumption in its favor and not questioned by the judiciary about the emergency nature of the proceedings, unless, in the key language from a SJC case dating back, the language dates back to the 60s, talks about the commission being palpably wrong in determining an emergency. under the statutory scheme. And once the emergency is determined, the regulations or the regulation is promulgated as an emergency regulation, it stays into effect for 3 months, during which time, if nothing is done, the regulation expires. And more typically, what is done is the public hearing and comment period takes place. And if any changes are necessary, they're made. And then the regulation becomes permanent, not an emergency regulation, but a permanent regulation at the conclusion of that 3-month period. There's a lot of mechanics around all of this, around the notice to the secretary and other required notices. But the real question is, when does the commission believe it's necessary that a regulation goes into effect as immediately upon its promulgation and then takes public comment later? I should say that there are ways to take public comment without a public hearing informally during a regulatory process. I've done recent work with another commission where regulations were discussed publicly. Comment was invited, not necessarily through a public hearing mechanism, but it was, well known what the commission was up to, and members of the public did have an opportunity to send in comments. So there are sort of hybrid-like models that are allowed. And again, turning to what you're dealing with in this case, one, the new sports gaming statute does specifically say that the commission can, as necessary, promulgate emergency regulations in section 4A. And at the same time, as we were discussing and Commissioner Hill reported from sort of public perceptions, there is some sense of timeline contained in the new law around sports wagering that would seek to easily create a situation where, in the best interest of the goals of the commission in fair gaming and public safety and the public interest, while moving expeditiously on certain aspects of the new law, regulations should best be in place, and that would seem to be ones that might be promulgated by an emergency construct under Chapter 38. But again, these are all tools available to the commission, as the General Counsel Grossman talked about, as the commission puts together its regulatory scheme for this new industry in various phases and aspects, and moves things along. So as with many things in the law, both of these principles, it depends, but I think they are tools that the commission should and can consider. And of course, we're happy to support you in this as the mosaic of sports gaming regulation rolls out. So again, I'm happy to take questions on emergency regulations or anything else from the commission or the staff, as you wish.
I see, Commissioner Hill, you leaving first?
Actually, I think Commissioner O'Brien did, and I would.
Okay, Commissioner O'Brien, my apologies. Thank you.
Sure. Just a couple of questions for you, Lon. One, do you happen to have the case site from the 1960s case that talks about the assessment of the exercise of discretion on this?
Yeah, the 60s Pioneer Liquor Mart versus the ABCC, 350 Mass 1 at page 10. And it was cited in American Grain Products versus DPH, which is 392 Mass 309 at 323, which is a 1984 case.
Okay, great. And then a question that I had in terms of the process, if we were to proceed normally, we face with a circumstance where we as a body say that this does not qualify as necessary to preserve the public health, safety, and welfare. If after that time circumstances change, that we as a body now determine things have changed such that we now feel like that particular reg now falls within that category, how is the process affected at all in terms of, I'm assuming we still have the right to then say, we're putting these into effect as emergency regs?
Yeah, I think you can make that determination at any time and you're not bound by a prior determination, especially given your predicate, which is something's changed.
Right.
So if nothing's changed, there is great discretion in the agency to do this. So while challenges in any event is always, just like litigation, is always possible, you start in a pretty strong position. But a long discussion and a finding that there is no emergency immediately followed by a lack of discussion that there is a more suspect circumstance than to, make a good record in any case at any time you find an emergency to support that determination.
But assuming, as I said, the circumstances have changed to the point where now the body determines that there's nothing that bars you from using the emergency process, having started under the normal process. Is that a fair statement?
That is a correct statement.
Okay, thank you. Thanks, Commissioner Hill.
Commissioner Hill, thank you.
So I've been juggling with this for the last couple of weeks, and when we're looking at possibly putting together emergency regulations, obviously it's not something to be taken very lightly. And I was looking at the criteria that allows for us to be able to put forth emergency regulations, and you talked about it briefly with public health, safety, public welfare. Can you talk a little bit more and enlighten me about public interest? Like, what would fall under public interest as I'm trying to decide what avenue we want to go down for regulatory promulgation?
Let me do my best to answer that. When I think about what the commission is facing in this case and where the exigencies come from, I really, and my colleagues and I really focused on the temporary license space first. I mean, there's a pretty strong imperative in the legislation about granting temporary licenses and getting the sports wagering operations up and running. And, that legislative imperative, frankly, a little bit less than the sort of public imperative, but they do sort of go together, demonstrates that the undercurrent, there's a strong presumption in this bill that the commission should move expeditiously to start this type of gaming and make it available to the public. And, there have been some other cases in which, the legislature has given an indication that it wants things to move quickly. And that has been a basis to support an emergency regulation finding. And at the same time, given the fact that the commission, as you've all discussed, wants to balance providing this gaming option as instructed by the legislature, while at the same time protecting the citizens of the Commonwealth, seem to create a situation where the public welfare would be protected both by having a decent regulatory scheme in place when the temporary gaming is launched, and at the same time temporary gaming is supposed to be launched in an expeditious fashion. So I think you have to take things as a whole. You have to think of look what the legislature is asking the commission to do, understand there is some sense of expeditiousness created in that. And the way to create regulatory schemes expeditiously is to do it by an emergency basis. I mean, I want to reiterate that the difference in emergency regulations is when the public hearing takes place. So before the regulation is a permanent regulation, there is a full opportunity for the public to comment through the process laid out in Chapter 30A. And as I said before, you can get some public comment even in an emergency regulation system by, discussing it publicly at these kind of meetings and, providing for comments by email or whatever you wish to do. So, I think in a situation where the commission is tasked with moving promptly, the prompt way to do regulations is an emergency basis and can be supported by the language in the case law.
Thank you.
Commissioner Skinner?
Oh, sorry, Madam Chair, I just wanted to clarify one point, if I may. Just to be clear, Commissioner Hill, the language in the statute refers to the general welfare and not the public interest. And, it'll ultimately be up to the commission's discretion, as Mr. Povich just mentioned, as to what the distinction between those two things is and whether there's a distinction between them. But it's important just to recognize the law talks about general welfare for the adoption of emergency regulations.
Thank you.
It's hard. First, Lon, it's very nice to meet you. We haven't met until now, but the virtual introduction is just fine. Really good to meet you. It's hard for me to get my head wrapped around the notion that there is a threat to, general welfare of the public or the health of the public or, a public safety issue. If the commission doesn't act to promulgate emergency regulations so that it can issue temporary licenses to sports wagering operators. So those cases that you referenced that cite specific examples of where this kind of a situation has passed muster under the emergency regulation process is going to be, those cases are going to be really important for me. And also, I think the timing of the public hearing and the public comment period is going to be important. If we do decide to go the emergency reg route, I would be looking to have those processes proceed as expeditiously as possible. Either after the emergency reg is promulgated or simultaneously.
And any,
I mean, I think it all has to be taken together in a systemic approach. So I think the timeline around temporary licenses and the timeline around regulations concerning temporary licensees, the commission should look at, holistically, and even more holistically in the permanent license process. And I think once the discussions proceed around timeline and preferences to the commission, these issues should be considered and revisited, but or just discussed in the context of whatever timeline you come up with. I think my goal today was to discuss the tools that were available to the commission and the level to which we think they would be supportable, subject to the commission's decision, of course, or the framework under which they would be supportable as preparing for commission's discussions on those points. So everything is very important. It's very important to put all these things in context. And, we have a general scheme of the context. That is, the temporary licenses should go before permanent licenses. But and I know we may talk about this in the coming weeks, but the extent to the regulatory scheme which you want to put in place in the temporary license scheme, which would probably be the first question, and the timing around all of that and the timing around the granting of such temporary licenses will be the factual basis on which we'll have to put these general principles that I discussed earlier to the test.
all set, Commissioner Skinner? For now?
All set for now. Thank you.
Thank you, Commissioner
Oh, it's
Baker.
very nice to meet you too. I'm sorry, I should have started with not. It's not started and not ended with that.
Commissioner Maynard.
Thank you, Madam Chair.
Two of you.
Counselor, isn't it true that, in the what we will call the normal regulatory process, these regs are opened up a lot, right? I mean, there's continuous change, continuous hearings, reg reviews. It's pretty standard, right?
Yeah. Well, yes and no. The answer is yes, it's standard, but one of the reasons people discuss what's a policy and what's a reg is, anytime you change a reg, you need the public process associated with it. But, I'm less familiar with your early work because I wasn't in private practice at the time, but I know that the regulations governing the brick and mortar casinos have been reviewed, revised, and updated. And I think most regs should be reviewed, revised, and updated. But, it takes some process and it takes some learning. But, obviously, this commission and every person gets smarter as things go on and time goes on. And I would anticipate that whatever is done to get this industry off the ground is modified as people get wiser, as real world experience in Massachusetts plays itself out. So I agree with that.
I appreciate that. And I think, I'm a simple person, and the way that I look at this issue is, the options are, as you've laid out, pretty, there's no perfect option, right? If we do the regular notice and comment period and review process, then the timeline's elongated. If we do the emergency regulations, and I'm just talking this out, and you can jump in where I'm wrong, which I often am. If we do it at the front end and we let the comments happen on the back end, there could be some, as Commissioner Skinner has pointed out, some wrapping your head around the fact that we're doing that. But then, to me, the worst option is to allow temporary licenses to go forward with no regulations in place, which is, another minuet of options if you look at it logically. So my point in asking that first question is getting emergency regs out the door and then having a situation where the notice and comment period comes after isn't too much different than if we did the regular review process and then had to amend those regulations later down the road. So it's just something I'm thinking, and feel free to pick up on anything. I just gave you a whole lot there that I'm wrong on.
No, I don't think you're wrong on any of it. And I think Commissioner Skinner's point, or one of Commissioner Skinner's points, that, to get as much public comment in as early as possible, no matter what, however the commission might decide to do this, is a valuable way. It's not totally yes or no, green or red. It's if the timing works out in the way that it all rolls out, if you have 2 or 3 discussions of a set of regulations before they get issued as an emergency regulation, and you allow public comment on those, you haven't fulfilled the 30-day public hearing process, and you'll have to go back and do that after the emergency regulation. But you'll get some input into it. And the post commission, which I have represented since its start, did some of that on some emergency regulations that they needed to get done because they had a statutory mandate. They had a date. You don't have a date. They had a date by which they had to get some things done. So it could be seen as and then they had to start. They were in a startup phase. So it supported an emergency regulation, but they did take comments before the regulation went into place. And frankly, they took so many comments that when we had the public hearing on to make that regulation permanent, maybe there was 1 person or 2 people who showed up, but my general recollection is like no one showed up to make comments. That was just that case. That may not be this case, but I align with Commissioner Skinner's point that getting as much, no matter how you proceed, getting as much commenting as possible, as early as possible, within the realm of getting it done, seems to make a lot of sense.
Commissioner O'Brien?
Yeah, I did just want to point out a couple things. One, in response to what was just said in terms of launching something without regulations. We have a statutory obligation to implement certain regulations prior to sports wagering launching, independent of the temp license issue that we're talking about. And I did also want to point out, I like Commissioner Skinner, struggle with the concept that this alone would satisfy the 30-day requirement on the emergency reg, and a finding that in the broad sense, without a deeper discussion on a particular reg in the particular circumstances, that the failure to do so would then be against the public interest. So I'm in the camp that Commissioner Skinner is in, which is I want to hear what people have to say. And I do want to point out that there is also a resource question in terms of emergency, because as you point out, we would then have to go through a formal comment process with a staff who would still be under a lot of stress trying to get everything else done. And so I think that is not without its negatives in terms of being able to move expeditiously across the board on what our regulatory drafting and implementation obligations are. But as Commissioner Skinner said, I want to read the cases also that you cited today to sort of inform me as we go on a case-by-case, reg-by-reg basis where this question is going to be before us. So I thank you for those cases.
Yeah, and I'll send you a couple more sites
Great.
after the meeting, if that's all.
I appreciate that. Thank you.
I'll offer my insights on Mr. Povich. Thank you so much for your presentation, it's been really helpful for me. It looks like from my perspective that we have a lot of very great legal support to allow us to use this emergency regulatory tool. We have other tools available. I led today with the statement that we're not going to do anything to compromise the integrity of the industry that we stand up. Consumer protection is always at the forefront of our minds. The health and welfare of the patrons are at the forefront of our minds. But I did forget to say one thing. I meant to remind the public that right now there is no legal platform in Massachusetts to bet on any sport event. There are nefarious organizations who are trying to reach out to those individuals because they've heard sports wagering has been legalized. You won't get the consumer protections that we're going to offer you through the system that we're planning on organizing right now if you bet today on one of those platforms that is not regulated. They may suggest it is pursuant to law. The law is in place. Our regulatory framework is not yet in place. So I really do think that there is a public safety and a public welfare issue here. It may not be exactly what the mission is of Post, right? It's a little different, but it is certainly something that we can legitimately lean on. And I would love to be able to defer to our team. They come in with recommendations. This is where we really need to use those emergency tools because I'm mindful of Commissioner O'Brien saying it's bandwidth, although we absolutely are hoping to make sure that our team is given all the resources they need to be able to accomplish their work so that bandwidth isn't an issue. I'm also mindful, and I've led with this, public input is absolutely essential to our work. We will be, we've already started roundtables with stakeholders. We will have public hearings to get public input. And it may be in connection with a particular regulation, but I happen to get the chance to speak with Commissioner Skinner earlier today, but it will also be full hearings where we get input, written statements and comments on various issues or on the entire statute. We have to figure that next step out. But I do think, particularly given what Commissioner Hill started with today, the word is out that you can bet. No, or you're going to bet in 2 weeks. And I want to be able to provide those consumer protections to our public residents of Massachusetts who are interested in sports betting in a way that can be timely and again without sacrifice. So Lon, I thought it was an excellent presentation. I appreciate your work today. So I turn it over, I guess, if there are any other comments, perhaps Attorney Grossman, Attorney Povich, what's next? What do you need from us?
I don't think, I defer to your general counsel, but my intent was to provide just an overview of the tools to set a context, as Todd said before, for the discussions that will follow. There's obviously, to state the obvious, there's a tremendous amount of work for the commission and staff and those of us who are happy to help around this. But I think, once as the plan comes together, we can refer, and I will circulate the other cases as your colleagues suggested. But as the plan evolves, as the mosaic, as I call it, comes together, we'll have to look at what tools are available and when and how it all makes the most sense to do it. So this is more by way of primer than by way of asking for any kind of determination at this point.
I think I have the executive director leaning in. I'd like to defer to her.
Yes, so the part of the reason we also asked for this agenda item to be on this morning was we are moving forward with the drafting of regulations, and we did identify 2 of them, the item 3B and item 3C, which would help move the process forward. So we have those ready to go. It's just the commission's discretion how you would like to handle that this morning. We wanted some kind of, as Attorney Povich said, some kind of primer. So you had some kind of educational tool in the meeting, but it's your call how you would want to go forward with those regulations. But we do have them available should the commission want to take one action or another. They're just available.
Okay. And so I'm seeing that's certainly the case, and it was my understanding. Councilor Grossman, you're leaning in.
Actually, I was just
but
thank you. Anyway, right back over to me. Thank you, Lon. Much appreciated. That was very helpful. We're gonna, before we dive into some of the regs that Karen just mentioned, there's one other procedural issue I wanted to bring to the commission's attention. You may be wondering why the drafts have the numbering of the sections that they do. So I just wanted to address that quickly before we jump into the actual drafts. We have been in touch with the Regulations Division of the Secretary of State's office, And as you all likely know, the Secretary of State is the state entity charged with the oversight of the Code of Massachusetts regulations and the entity with whom we file all the forms after the commission approves the promulgation process. And we wanted to connect with them to ensure that they were certainly aware of the fact that we will have a pretty decent volume of regulations coming their way, and just to understand what the framework will look like for the numbering process. And while we feel like we have a really good understanding of that and we're both on the same page, we are still working our way through it. And so what you'll end up seeing is that we identified the preferred model, if you will, being that we would mirror the framework of the sports wagering regulations after that, which is already in place for the gaming regulations, on the theory that there will be a lot of overlap, topically speaking, not substantively necessarily, because of course there are different bodies of law that govern both sets of regulations. So as you'll see as we go through this, in some cases we may be able to just amend a gaming regulation and add in the words something to the effect of "and sports wagering." There are other places where we can't do that based on either the way that the construct works with the filing of regulations or the enabling statute. So just by way of example, the first regulation that will come your way that we'll talk about momentarily relates to independent test labs. On the gaming side, we have a series of regulations that talk about independent test labs. They're codified at 205 CMR 144. So the theory was, since we're going to have regulations about independent test labs on the sports wagering side, we will put those at 244. So there'll be a mirror version of regulations, at least again, topically on the sports wagering side, similar to those that presently exist on the gaming side. But instead of being in the 100s, they'll be in the 200s. So that's why you're seeing what you're seeing. What you'll also observe is that since we're not going in order from 1 to 50, if you will, section 101, 102, 103, and we're jumping in at different points, that we need to reserve certain section numbers with the idea that we'll come back to those as the process unfolds. And for example, again, coming back to the independent test lab regs that we're about to talk about, you'll see that we've numbered that one 244.06. And the reason why we didn't start at 244.01 is that in 144.06, it talks about how the labs themselves get certified on the gaming side. So we've lined that up on the sports wagering side with the idea that we'll follow up in the near future with another series of regulations, 244.01, 0.02, 0.03, that talk about similar provisions related to independent test labs. So if that wasn't too confusing, that is the reason why we have set everything up the way we have. Hopefully it'll come into clearer focus as we start moving through this, but we're trying to kind of build out the framework out of order in some ways, and that's why it was important that we identify the proper numbering system in advance. The last point I just wanted to make on this, and then if there are any questions, as I'm sure there are, I will certainly pause there. Though we feel confident in the framework we are presenting to you, and I'm just talking about the numbering system primarily, it is possible that upon filing, the secretary will identify some issues with things like that. So what we will ask for, and what you'll hopefully include in your motions when we get to the point that we ask for votes on these drafts, is the flexibility to adjust the numbering and the sections and things along those lines that don't affect the content of what the commission has approved, just so we don't have to come back before you for formal approval to change a number or a section, a labeling or something along those lines. So we'll deal with them.
We're all set with that, right? Yes. In terms of changing the numbers, yeah.
So that, I mean, we'll see that in some of the motions I anticipate we may have coming our way even today, but that's why that is in there. So with that, let me pause for just a minute before we jump right into the first regulation. Are there any questions about anything I just mentioned about that?
I may just interject before we move on. It is already 10 of 11. I want on anyone's need to stretch their legs. At this juncture, if you'd like to continue, we're mindful of the fact that Zoom meetings can be really taxing. Commissioner?
I would like a break if we can, Your Honor, very quickly, Madam Chair.
Yeah, I think I did too. So Todd, did I cut you off at the wrong point, or did you have a short point, right? Before we
No,
go break?
that's a perfect time for a break.
Okay, excellent. Thank you to all those who are attending. Well, it's 10:54. We'll reconvene at 11. Okay, excellent. Thank you. Hi, Dave. Dave, I think we're probably all set to take it down.
Okay, sounds good.
Thank you. People are rejoining. Okay, good. Good morning again to all. Because we're using this virtual platform to conduct our public meeting, I'm going to take a roll call again. Commissioner O'Brien,
I am here.
Commissioner Hill,
Present.
Commissioner Skinner,
I'm here.
Commissioner Maynard.
I'm here.
All right, we're all set to continue on. I'll return back to on our agenda. We were just really starting our item number 3. Thank you again to Lon Povich for his presentation. And now, Councillor Grossman, I'll return to you. Thank you.
Great, thank you, Madam Chair. So we'll jump right in and look at a draft regulation in light of everything that was just discussed. In your packet, there's a brief memo, a draft of 205 CMR 244.06 and a small business impact statement accompanying the draft. As I briefly mentioned moments ago, we do intend to bring additional sections of the new 244 to the Commission at a future date, but today we're really just focused on 244.06 related to independent test lab certifications. By way of background, as you may know, the Commission's existing regulations, 205 CMR 144, require that an entity be certified by the Commission as an independent testing lab prior to being permitted to perform compliance testing of electronic gaming equipment that's used at the gaming establishments. And to become a certified independent testing lab, the entity must be able to test the equipment for compliance with various GLI standards that we've talked a little bit about, and we'll talk more about in the coming weeks, relative to those electronic gaming devices. An entity applying for certification as an independent test lab has to go through an approval process and ultimately be certified. And that process is detailed in section 144.06 of the regs. At present, there are 2 labs that are certified by the Commission. One is GLI itself, and the other is the lab called BMM. And they have received that certification under section 144. So the draft that's in the packet of 244.06 would authorize essentially those 2 entities, or really any entity that's certified as an independent testing lab for electronic gaming devices on the casino gaming space, to automatically be certified as an independent testing lab for sports wagering related devices. This would allow for a couple of things. It would first of all kind of allow for sports wagering vendors and operators to have an understanding of where the commission stands as to how that will work. They can begin commencing their relationships with these labs in the sports wagering space. And secondly, given the unique nature of the work that these entities perform and the limited universe of companies that do this type of work, it would allow the commission to directly contract with those either of those two entities to assist in adopting and amending these industry standards related to sports wagering. It would help us to stand up the regulation drafting process a little bit quicker. That is kind of the overview of what this regulation talks about. We can certainly walk through it, but I think the essence of it is essentially just that, again, it would allow the existing labs to be certified automatically as sports wagering's independent test laboratories. Ultimately, what is before you is certainly at the threshold would be to allow the staff to commence the promulgation process in the ordinary fashion. But the specific request is that you consider authorizing the emergency adoption of these in order to help expedite the process. Of course, we just talked about all of those principles. So if that isn't something that the commission is inclined to do today, we can still, if there's a comfort with that, move them through the regular promulgation process.
Let's ask questions about the substance first, and not about the emergency versus regular promulgation. Questions about the substance of this regulation?
I have a question, Madam Chair. Later in the agenda, Karen's going to talk to us about testing options. Is this regulation needed regardless of which option the commission adopts?
Yes, that would be a different section of the regulations. It's in, sorry, I don't have the site right in front of me. It's in the 140, it might be 143. It's a different section that talks about approval of the equipment for use. Okay. So the way it would work, because they are all connected, so it's a good a point to have a good understanding of. In order for the equipment that Karen will talk about to become approved, whether it's the commission or the operators themselves or the vendors of the devices would have to bring the equipment to a certified independent test lab. So the lab itself would have to be certified under the process we're talking about now. But it's not directly related to the process that will be used later on. What we're talking about now will need to be done one way or the other.
Okay, thanks.
And we do have our CIO, Katrina Jagger-Gomes, on for any technical questions. And we did consult with her and that team on the comfort level and having this reg brought forward with you today.
Questions for Katrina? Or I have one follow-up. Katrina, can you remind me, it is an independent testing process. Do we perform any kind of audit function, or how do we assure that they're doing their job?
Yeah, so the two independent testing labs that General Counsel Grossman referred to, BMM and GLI, they're currently certified, obviously, to do our regular gaming testing. They go through a pretty rigorous process initially to have been allowed to do testing in our jurisdiction, along with other jurisdictions like us that do regulatory category 1, category 2 regulations. So on an annual basis, we do an audit of the facility itself where most of the testing happens. We get a walkthrough with that. We do have a compliance checklist that we go through with both labs to ensure that they are adhering to and meeting our requirements as well as industry standard requirements.
So they have a pretty good, or hopefully it's an excellent compliance history on the regulatory side for gaming.
Absolutely.
So, Madam Chair, actually, if I could follow up, I had question on this earlier, and Katrina, maybe if you could answer, and I know I've heard from Karen's answer. The choice of the word shall as opposed to may, I didn't know if that was a specific choice or whether it should be may in terms of giving some discretion if there are other vendors, maybe the confidence level is not quite so high or any issue comes up where you want the ability to not automatically qualify, or whether you want the shall.
Can you direct us to the shall, please?
Sure. A person certified as an independent testing lab pursuant to 205 CMR 144 shall be authorized by the commission to provide testing services of sports wagering devices. I didn't know if may or shall is the better choice there, may being giving the discretion, obviously, to whether they don't want to certify for some reason or whether everyone is comfortable with shall.
I'm struggling, I'm sorry. I'm looking at the memo. Oh, on the reg itself, my apologies. At the shall.
It's packet page 8, Madam Chair.
I found it, yeah, I'm looking now. I wondered if she was looking at a motion. All right,
No, the text of this of the
Yeah.
reg.
yeah.
And I would ask Todd whether this is this language mirrors 144.06. Is the shall in that regulation?
No, this is entirely different in that obviously in 144, there's a process laid out for the labs to become certified. Here, we're just saying essentially if they've already become certified, they shall be deemed certified under the sports wagering space. So the language is different. It's the same general subject matter, which is why it's in 244.06, but it is different.
Got
Don't
it.
we want it to be shall? I mean, don't we want them to?
So the shall would remove any discretion on the agency's part if there's other concerns. So I know at present with the two we're talking about, no one has concerns. My question is, does staff feel comfortable with not having that discretion going forward to the extent that other vendors may come forward, approved on the slot side, but maybe you don't feel comfortable with them on a sports wagering device?
Commissioner O'Brien, if I can jump in just momentarily, I think your concern might be allayed in part by some of the other language in this paragraph before you that kind of brings over some of the reporting and other obligations from 144 over to 244 and makes them applicable, so that if there were a problem with either of them, we could take whatever action would be necessary.
I guess it's not to I'm sorry, I'm just trying to move the line. That's not my concern. My concern is that you have an entity that is not as versed in sports wagering equipment as these two companies are, but who would nonetheless qualify under slots. So not something that would necessarily be a notification requirement that's covered in this current reg, but whether staff needs the ability to say, I get it, but you know what? You actually weren't who we were contemplating when we put shall in there.
I understand. I understand. I get you.
Because the rest of it, I'm fine with that. That's just the one word I'm looking for a little more discussion or assurance on.
Understanding, Commissioner O'Brien, is that if you had another entity that wanted to be a certified independent test lab, really for casino gaming, there's an automatic
right
in the future.
Right.
So that really ties into that process on the sort of on the front end. I hear what you're saying.
Right. So I'm always loath to write regs or statutes based on something at present that's not fixed and static. You know, thinking about, well, what happens if you have another entry into the market and we don't feel as comfortable with the shall?
I have a follow-up question, Commissioner O'Brien, because I have the same concern. Does 205 CMR 144, would that allow, can we use that tool to bring in a new player into this game if they do pop up? I mean, there is a real issue here about saying, well, we're just going with who we know when there's other players in the game across the country and could pop up across the country.
Yeah, I think that is, it is certainly a possibility. I think practically speaking, there are only two companies that do this. It's not to say that there never could be another one. So your concerns are certainly well-grounded. And maybe Katrina can speak to this a little bit more clearly, but as a practical matter, I think we're probably on fairly solid ground. But.
Well, my thinking is that if there's a process in 205 CMR 144, to add someone in that may take care of this. But I'm, that was my opinion.
And the other issue, Commissioner Jordan, is as Carrie may have briefed the commissioners in advance, the expectation is that as this is sort of an initial threshold reg, but that we would go back and come before the commission with more detail on 244.06, which may address those concerns, say in the next 6 months, within the next 6 months. So I think Todd is correct. It's not necessarily a practical issue, but a legitimate call on the exact language, as Commissioner O'Brien pointed out.
So I guess my question, to move forward is there a downside to saying may, which would alleviate my concerns and maybe, Commissioner Maynard's, as opposed to needing the shall? Does the may get you where you want to go and allay the concerns that I've just expressed?
Does it make it more lenient? I guess maybe I'm reading it wrong. Does it?
It makes it more flexible. It makes it more flexible for the commission.
It gives the commission more authority to withhold approval if for some reason you have this new player in the market who may pop up that qualifies under slots, but we don't feel comfortable with under sports wagering.
Yes.
Darcy Lennon had a comment on this because he's been working on this with us as well.
So, yes, thank you. So we addressed all of.
Yeah, I've got to. I heard somebody speaking and I couldn't identify who that was. Was that Katrina who was speaking?
No, I believe that was CFO Lennon.
Derek, I think.
No, beforehand, right before Derek.
Karen.
Madam Chair, right before Derek.
Commissioner Skinner, thank you. Could you
I just commented, I just gave an answer or tried to in response to your question.
That would be helpful for me to hear. Thank you.
Well, it's only my opinion, but may, using the word may just gives the commission more flexibility in its decision.
Yeah, such may be subject to the same and continued obligations outlined in, okay. I guess I just wonder if it's is a strong of them being unnoticed, but that's fine. May could work. Derek, you wanted to chime in. Hello, good morning.
Hello. So all these concerns that you are talking about, we addressed. And I think, and we addressed it behind the scenes, and it's probably not here in the public meeting as staff came out. We do plan on changing this reg to allow for specific testing regarding sports wagering qualifications. That being said, we need someone to come in and help us draft those regs for the sports wagering regulations. So we need this reg to certify the current independent test labs that we know are doing this in other jurisdictions. Another lab may come up. The process under 144, not 244, for certifying would not allow another lab to be present because it's similar to a entity qualifier or a vendor primary qualifier prior to us getting these regs established and permanent. So we do understand that there may be someone that comes in that is just a gaming lab, but not good for sports wagering, but the feasibility of that actually happening before we can get the regular regs written for sports wagering are next to zero. I'm not going to say zero, but next to zero. The may does not hamper us one bit versus a shall. The shall just requires that there are two, and it gives our operators the ability to use one that they would prefer versus the other and not be tied into one. But I'm sure Katrina and team intent is to allow both BMM and GLI to do this testing and let the operators choose who they'd like to go to. So it doesn't change one way or another, and I think it does add some flexibility. But we did think about all the issues you're bringing up, and in order for us to get to that place to make it really solid, we need this temporary or this emergency reg, and it helps to expedite the timeline.
Okay, so if we were to amend the shall to may, could we have a motion? I know we probably want to discuss the emergency versus standard am I hearing from you, Director Wells, that it's your recommendation on the case-by-case analysis that you would like this to be an emergency reg? Could you say that?
Correct. Sorry, my
Yeah.
audio's not that great.
Thank you. Any discussion?
Time for another question.
Yeah, yes, absolutely.
So, in terms of the actual devices that will be tested, is there much difference in the sports wagering world versus the gaming world? And can you just give a couple of examples of the kinds of devices that are contemplated here for testing?
So
Katrina or
I can field that one, Commissioner Skinner. So there are a variety of devices that are similar to our gaming side, to the sports wagering side. So for example, a kiosk or a card reader or a, some other mechanism for patron management that works with our retail operators or our land-based casinos that are doing sports wagering. When you start getting into the sports wagering centric world of online, there are systems, there are different platforms, there are different components to each of these. And, for example, there's geofencing. That's usually the most popular one we talk about is, if you're going to authorize online betting, you need to have a geofencing capability to ensure that any transactions executed into the jurisdiction is done within the jurisdiction borders, within the parameters. If there were additional locations that were prohibited for any reason, that would also be taken into account. So that type of technology would have to be tested and certified. And that's where these labs really come in handy as a very simple example. It's not a simple example, but as one example to demonstrate the differences between our traditional casino gaming versus online sports wagering.
and does the word devices capture technology too? Or do you need to have that language expanded a little bit to include the geofencing technology, for instance?
I believe that, and again, to CFO Lennon's point, we are coming back to this reg and it will be written a little bit more robustly and a little bit more all-encompassing than what it is right now. The goal of this is really to authorize the existing 2 independent test labs. And just as an anecdotal note, they are the only certified independent test labs in the continental United States. There are a couple other ones, but they only deal with tribal organizations. And they are the most commonly adopted by all of the manufacturers and operators as well. So this is why we felt pretty confident taking this route with doing this emergency reg for allowing them to be the named certified independent test labs for sports wagering. So I believe more exhaustive parameters will be in the later iteration of 205. 205, I don't know what the number is, 244.06. So there will be more language around that. But for now, I think some devices would suffice for what we're trying to get accomplished today.
Thanks, Katrina.
I think that's a really important point for you to make, Katrina. Thank you for noting that. In our, we all hope for newcomers to every industry, but in our time frame right now, these are the 2. Okay, other questions for Katrina? Again, Executive Director Wells, you've indicated a desire on this respect to this reg that you would like to be able to move forward, that this is an initial step necessary for us to continue to do other work. Derek, thank you for your input. And without this reg in place, the work will be stalled. Is that my understanding? If we don't act today.
It expedites the process on both the tech end and the reg end.
Okay, do I have a motion or do I have other questions?
I have another
Are
question.
we talking about the emergency part of this or the substantive?
Well, I was actually addressing the emergency. We just heard from the executive director that if we don't act today, it will stall work. I think Derek Lennon just made it clear that this is an initial step that needs to be put in place. It is the executive
So
director.
if I could, Madam Chair, I guess I'm just looking for a little more particularity and clarity on the statement by staff in terms of why the expediting this is necessary. And I've heard some of it, but if someone could articulate for me the need for expediting this past the normal process and how that plays into staff's ability to prepare as this is unfolding and all the other requirements in the statute, I think it would be helpful for the record and for me.
Great, thank you.
Why don't I take a stab at that? I may need support from the rest of the team.
Karen,
So-
if yeah,
I know,
you're
Amy,
here.
you
Just
hear me?
a little
When you
bit.
sit back, it's hard to hear.
Okay, yeah, I'm
Thank
standing.
you.
So I think the simplest way to describe it is that overall, there is an enormous amount of technical requirements involved in regulating sports wagering. And if you go back to the conversation at the earlier part of the meeting about, why can't we do this in 3 weeks? There is a huge component of setting up regulatory standards for tech and also checking that. And that's really important for the integrity of the operations. So the reason that we are asking to move this reg forward, why we have it as your first reg on the first day we're doing regs and have some sort of urgency, is because we know that these 2 labs are the ones that do this in the United States, if we can move forward with a procurement that limits it to certified independent test labs, we can get them on contract more quickly. And if we can get them on contract more quickly, they can give us the technical expertise not only in Katrina's side of the house, but also assist with the regulation promulgation in the legal side of the house. So that's why we're doing this and why we're sort of carving that out as something somewhat urgent. Because if we have to wait and do a more fulsome procurement process, it could be a long time before we can get the services that we need. And these are really specific services that we know through our staff's expertise are going to be critical to implementing sports wagering. So that's the landscape. I don't know if Derek or Katrina or Todd want to chime in, but that's my understanding.
Yes, I think Todd can chime in on this as well, because he was actually part of the drafting of 144 and that whole series. So GLI standards are very technical to begin with. Then they have to take our statute and see if there are any contradictions to their standards, and then write those into our regulations so that when a manufacturer comes forward or an operator comes forward with their product, they know what we're testing to, and they know that it has to meet that baseline code. So, we have a lot of responsible gaming in our statute that's probably not in a lot of GLI's standards for every jurisdiction across the continental US. That has to be written in, and the operators have to know what GLI is going to be testing to. So that's an area that could probably take one of our attorneys or an outside counsel months, weeks to draft, or with the assistance of GLI, since they know the standards, or BMM, since they know the standards and they test to them every day, they could help to draft those really quickly and get us up and running and get the operators and the licensees who are coming forward knowing what their systems have to do. Katrina or Todd, if you'd like to add to that.
Yeah, no, I think that's spot on. And I think Karen already said this, but just to reiterate, if we're to distill why the regulation is important, without it, we're unable to establish that these entities are uniquely positioned to do this work, which would likely mean that we have to put together an RFR. We have to post it for, I'm sorry, is it 60 or 90 days? I don't even recall off the top of my head. And then work through the formal procurement process, as opposed to being able to establish that these are the only entities that can do this work, in which case we believe we can directly contract with them. So that's kind of the long and short of the urgency of the situation. At the moment, I think that's accurate. Anyone can feel free to correct that.
And if I just may add one more thing, this also will be directly related with item G on the agenda. As we set up the regulations, as we create the platform requirements, the compliance pieces that need to go to all of the operators and their understanding of what their adherence needs to be, any equipment that's shipped into the jurisdiction would have to be certified and approved. And this allows us to help speed some of that process up. If we delay that, or there's any delay in approving, the primary 2 labs in assisting the Gaming Commission in doing this work, that's definitely going to affect the timeline of when the operators that are working through application processes, if they're trying to ship in any equipment, systems, platforms, devices, etc., they would be prohibited.
So can I ask you a finer point in terms of the procurement interplay? Is it a fair statement to say that absent the emergency treatment of these, any engagement of these particular vendors could potentially then, in a following procurement process, create issues with contracting with them if they communicated with us outside the process? Meaning, absent this, if we or our staff try to communicate with them to get their technical expertise to draft regs, would it create potential conflict and procurement issues going forward? Does this emergency implementation solve that issue, or is it a non-issue?
Ask that question again, just so that I can.
Sure. So
absorb it really well.
Traditionally, if you are going to do a procurement, communicating with a potential vendor before you put out the procurement could create issues contracting with that vendor under the procurement process, right?
Well, it could. and
It could, right?
not. It could and it could not. So if you look at the current SSS process, so the sourcing certificate process that OSD puts out, they actually look at that as a best practice to go out to all of the vendors and get advice on what we should be doing. Now, if
Well, but
what we
advice
came
on what
up
we're
with
doing
was
in
so
detail.
narrow, yeah, if we came up
Right.
with something that's so narrow that only 1 or 2 vendors could respond to it, you're absolutely right. That is a huge flaw. And this is what we're saying. We think that
Right.
these are the 2 vendors that can really help us with this. So
So I guess this is the point for me, struggling with the emergency request. What I'm asking is whether the finer point on this does in fact relate to the procurement in terms of, is there a risk of not being able to get their expertise moving forward in drafting the regs that we need to draft, particularly as you point out, the responsible gaming side?
yes, if we started engaging with them, but we haven't started engaging with them.
No,
all
I
we've
understand
done
that.
is
I'm
ask
just
is-
talking about
yes.
the emergency process.
Yes, the emergency process is
mitigate
very
that.
helpful. Now, we can go the typical route, as Karen pointed out, and as Todd pointed out, it would be, we'd probably have to do the 40-day World Trade Organization posting, and then we'd have a full-blown procurement. We'd pull a procurement team together. We'd review all the responses, and we're looking at, and I know that there are members on the commission that likes to speed it up as much as possible, so we'd cut down on all kinds of areas of negotiations and just draft the procurement really strong. And we have some good people on our team, right? We've got 3 people with a sourcing certificate through OSD. So we could probably cut it down to 2 to 3 months of the actual procurement before we'd have someone in to hit the ground and start helping us draft.
No one on the commission would compromise the integrity of the procurement.
No, not one bit of the integrity. I'm just saying, cutting down the timeline, we do a lot more pre-work so that
That's
we
right.
didn't have the negotiations on the back end with the vendors. They'd know exactly what their requirements are up front.
Right, I appreciate that, Derek, very much.
Yes.
And thank you for reminding us that we do have those 3 certifications now.
Yes.
Are there other questions on the proceeding with the recommendation to go forward with the emergency basis with the understanding the alternative?
Just one final question from me, I think. The emergency procurement rules don't apply here, right? So if we did not promulgate the emergency reg or the reg under the emergency provisions, we couldn't rely on any emergency procurement provisions that OST has in place, right?
I do not see any life, limb, or property on the line here.
Yeah. And that's my struggle with promulgating an emergency reg. I mean, I completely respect what the team is saying I
We have
completely-
but we do have a statute in front of us, Commissioner Skinner, and I think that that's why we just had the analysis in front of us from Councilor Kovic. So I think if you were looking for OSP's guidance from that, no, but I don't think that the request for the emergency to use the emergency reg tool today is done in any kind of a arbitrary fashion by our team.
That's not what I'm suggesting at all.
Sorry, no. I just want to make sure if I understood it. The OSD doesn't provide, but we have other. Is that what you were saying?
Well,
I know
I
what
was
you're
saying
trying
it's
for a
un-
link, right?
It's essentially the same criteria, a threat to public safety, public health, or, general welfare. And, I'm struggling with that. So I think, it's a good segue into the emergency versus regular promulgation discussion.
Well, I was actually ready for us, I thought we had concluded it. I thought we would move on to it, whether there's a motion that reflects what the team has come to us for today. I'll reiterate my argument. Nothing is going to compromise the integrity of the industry that we plan to stand up. But today we had from council and from our general counsel's office advice that told us the various reasons why we can use this emergency tool responsibly and reasonably and defensively. In other words, that it would serve a public interest. The legislature notes in the statute, we may use the emergency regulatory tool. We would have loved, we always want legislative language to be a little clearer, but that's okay. It also mentions that, general welfare is at stake. I led with the idea in my earlier discussion that we have folks who are at risk right now because of the new law in place. We have very viable arguments and interests here. And our team is coming to us to start the work. We can stall it, but I would like for everyone to consider what's the long-term plan here? What's the long-term plan? This is a very initial step we need to take in order for the team to move forward on very important technical regulations. GLI and VM are, as Katrina knows better than anyone, I've had the privilege of visiting the lab, so I'm very familiar with it. Any of us can visit it, and I encourage all of you to do that. But there are other players in town right now that we know of. Is that fair, Katrina? Am I overstating that? There's no other alternative.
There isn't a competitor that is widely accepted as GLI and BMM amongst the regulatory bodies as well as the manufacturers and operators. There are smaller independent test labs that work in the tribal market, which we are not in. But BMM and GLI are the two foremost and the only ones, other than I think one other test lab that I know of that works in tribal, like I said, that do what they do in the continental US.
So with respect to commercial casinos, which is what we, okay, thank you. I make that argument and indicate my comfort level to use this tool so that we otherwise, our alternative is, of course, what we're familiar with. We're also familiar with doing emergency regs. We have certainly done them in the past. We have certainly done emergency regs in the past with respect to our casino business. I'm very appreciative of today's presentation.
So turning once again to legal counsel, are we to interpret the emergency regulation provision in 23N as authorizing the commission to promulgate emergency regulations without regard to the recognized standard, so long as we follow the appropriate procedures?
No,
I don't know.
I wouldn't say that. What I would say, though, is that Chapter 30A sets out the standard for the emergency adoption of regulations. And for our purposes, it essentially says you have to find that it's necessary for the preservation of the general welfare. To your point, there is language in, as Mr. Povich discussed earlier, in Chapter 23N, and all it says, and this is what the chair was just, I think, referencing, is that the commission may promulgate emergency rules and regulations in accordance with applicable procedures for the promulgation of emergency rules and regulations. The issue with that is it's very non-specific. It doesn't really address what the standard would be. But I think the reason why the council has gained comfort in presenting this to you in this fashion is that we have to read some utility into the fact that the language was included in 23N and assign it some meaning, even though on its face, it doesn't really provide much guidance. Because if the language wasn't there, then the 30A standard, the general welfare standard, would just be the standard. So what do you make of the fact that the legislature and the governor included language in 23N about it? Well, the sense is that it was generally designed to afford the commission even more discretion than 30A offers it. That's one interpretation of it, but it does not in any way suggest that we can disregard what Chapter 30A says. But that's just a holistic review of both sections together.
I mean, for what it's worth, I did not interpret it, Commissioner Skinner, as to obviate the need to look at 30A for guidance in terms of emergency regs. That's certainly not how I'm going forward with this question. And I am struggling with it somewhat as you are in this particular circumstance, given the interplay between being able to need the technical expertise to make sure that the regs protect the citizenry. I have a comfort level with this that I may not have in other regs going forward. But that I feel, staff, given the procurement requirements in the Commonwealth and the need to go forward on this particular issue, I feel okay with the emergency request on this particular reg. But it is going to be a reg by reg question for me.
Yeah, and I'm that's exactly where I'm trying to get, trying to get my comfort level.
Right.
So thank you for providing your perspective.
I was like, I'd like everybody to pause and take a breath. And I understand everyone's argument. I'd like to call the question, but I think that I'd like to have Director Wells give a little bit of a last word. If this was the very first item on the agenda for today, and that was purposeful, I imagine. Can you explain what the implications are if we now, on this reg, and this is the particular reg, Commissioner O'Brien has said she's struggling with this particular reg. I think it's being connected to procurement and there's a lot of conflated issues and I want to make sure we sort those out so that everyone is comfortable. But Commissioner Wells, just exactly what will happen if we don't pass, Commissioner Wells, there we go. Director. You can come.
It'll be so nice to have.
Come over to my office,
right?
And sit right here, right? I'll happily have you take it over. Karen, if you could just remind everybody, because I actually need a refresher. What would be the next steps we would have to do if we don't adopt, as you had asked us, the approach for an emergency regulation?
So we would have to go back and do a timeline analysis because I think the team here, we're trying to do this as quickly as possible. We recognize there's great public interest in doing this as quickly as possible. So we'd have to do an analysis. We can certainly get the services much more quickly if we do if this reg is passed. We would then have to do an analysis of whether going through a standard procurement process without the reg, which is going to take longer, doing the standard procurement process without the reg, or waiting for the reg to be promulgated through the normal procurement process and then doing what we need to do. I'd probably defer to Derek on which is faster, but they both add weeks, if not months, to the timeline.
Well, let me just help. That's no shorter than 60 to 90 days, correct, Derek?
Yeah, that's best
No
case
shorter than
scenario.
60 to 90 days. So is there work what will be the impact of not having this done? As this
That potentially impacts having expert advice on regulations regarding technology for both brick and mortar and online wagering, which is of critical importance. And then also impacts our ability to stand up operations for the regulation of such online and brick and mortar technical components of sports wagering. Katrina might be able to elaborate a little bit further, but these are germane to what we do. So much of sports wagering is the technical compliance and making sure that these operators are doing what they need to do. So much of the regulatory job that we have is ensuring that these platforms are legitimate. And without that in place, we would not be doing our jobs. So we really need this piece of things to move forward quickly. Otherwise, we're just waiting. And so I am concerned about the timeline.
Attorney Povich, can you help us assess the risk here for the Gaming Commission? Is there any risk analysis that you're able to help on?
Sure. I mean, obviously, no lawyer is ever going to tell you that there's no risk, but picking up on what Attorney Grossman said about the language around emergency regulations and picking up the theme from the bill, which begins with the temporary licensing sections, there is clearly an imperative to go forward. The general welfare would seem most protected, and the public safety in a broad context would be most protected if you go forward subject to appropriate regulation. It seems as if this technology piece is a gating issue, and in order to move expeditiously, most important on this piece, and again, as Commissioners O'Brien and Skinner say, taking the regulations one at a time, but looking at this one first, viewing it as a gating issue in the context of getting this system up and running, given the realities of the procurement system and the OSD rules and the like, and the regulatory process, which has a public hearing first. Taking that all together, it would seem, my opinion would be that it would be prudent if the commission were to move forward in this way, and certainly within the commission's discretion, and therefore very defendable if in the unlikely event, I think it was challenged.
Madam Chair, can I ask a follow-up?
Absolutely.
Attorney Povich, is this something that can be accomplished via an internal policy, or does this have to be accomplished through the emergency promulgation process? I mean, it just in drawing.
Yeah, that's a very good question, but you're just saying regulation versus policy, and granted, I'm relatively new to the commission, but as I understand it, this type of thing has been done by regulation in the past. Is that correct?
Yeah, just drawing on the memo. Right. I'm just wondering.
Right. I mean, it would, if the impact is on outside parties, you would think that these vendors would qualify as outside parties, and that's where the impact would be also on the parties whose technology they would be testing and opining on our outside policies, as opposed to internal operation.
It would be, but it would be their expertise that the commission would be relying on in drafting regulations. There would still be regulations promulgated that speak to the more public-facing process. But just strictly with respect to what Executive Director Wells is saying, the work that she's saying needs to move forward, I guess I'm wondering if this could be accomplished through an internal policy. I mean, I won't belabor it.
I would see the risk of doing this through emergency regulation slightly less than the risk of doing it through internal policy.
Okay.
Because the internal policy case is only this one case from the SJC from a couple of years ago, which is extremely broad. There are lots of people who'd like to see more who work in this area, who'd like to see more interpretation of this case. But taking that case at its broad language, I would find that a more troubling place to go, although a good idea, but a more troubling place to go than going by way of emergency reg. But, as the commission wants, we could do and we could defend, but the emergency reg seems to have little risk, and with the policy the risk is probably not substantial, but the language of that case is extremely, the DOC case is extremely broad.
Okay.
Idea though, Commissioner Skinner, good idea.
Well, yeah, I mean, I'm trying to get to,
Yeah.
yeah, and just one other issue, and then I'll relieve the staff and my fellow commissioners of the agony. Just how quickly can we get these regulations out for public comment? How quickly can we hold the public hearing? Should we proceed it on an emergency basis? That's going to be important to me.
We always advise, the process takes between 60 and 90 days. If we run it really tight and are able, and the dates happen to work out with the secretary's filing schedule and what have you, we can do it in about 60 days.
Is that
Under the emergency, though, is the question.
Oh, the emergency, that would come into effect immediately.
No, I think she's
Well,
asking
within-
how quick we get public input, even though they become effective, but I'm hearing, and I think it's a really important point from both Commissioner Skinner and Commissioner Bryan, that it's important for us to hear the public input as soon as possible, because we could pivot, correct? We could pivot and change our reg if all of a sudden we heard that we made a mistake. Is that correct?
Absolutely. Oh, if I'm understanding your question correctly now, we can schedule public comment next week.
Yes.
That would be my request.
And so I think that that's an important piece of the consideration, Director Wells, when you come forward with a recommendation to have something promulgated by emergency reg, perhaps a little bit of a timeline on how we're going to get the really important public input on them, despite our using that tool of expedition. And I'm respectful of the bandwidth. I'm sure that Caitlin and Carrie and Judy are going, oh my, but the reality is that it's not such a formal process to get that public input that we couldn't be nimble.
And I think as Lon mentioned, it has to be done anyway because the reg expires. So you have to do the work anyway. I'm not too concerned about that.
Lon expires in three months, at the conclusion of 3 months?
Yes.
Okay.
And you have to be mindful of again, as Todd said, you have to be mindful of the secretary's publication schedule if you want to change it. But if you can't change it on the, whatever that would be, the 89th day, you have to get that process rolling somewhere between 60 and 90 days. But, we'd have to think about how much notice we need to do a public hearing as well, right?
Yeah, so just to pick up on that theme, if we were to schedule a public comment period for next week, that would not satisfy the statutory public hearing requirements. That would have, well, it would actually, practically speaking, be more like 2 months, because the notice has to appear in the newspaper and has to be in the mass register, and there are a few other filings that need to be made. So you can't just schedule the public hearing, for next week. That would just be an opportunity to gather public comment that doesn't satisfy the statutory requirement. But as a practical matter, you would know whether there is any input.
This was some of the duplicative resources comment I was making earlier, that there is a trade-off in that regard to move this way, because you would still have to do the formal notice to get the comment after if you switched over. So, but to Commissioner Skinner's point, you could still substantively seek comment.
Or you could seek comment
earlier.
now, and you could seek, that's the same point, said a different way. You could seek comment now, and you can vote at a subsequent meeting, which could be as soon as you schedule it. I don't know what the timeline is, and I don't want to slow the process down, and I continue to be comfortable with seeing this as an emergency, but you can declare it could be an emergency 6 or 7 days from now, or 2 days from now, or today.
Okay. We have in front of us a matter, and I know that our team is looking for us to vote on it. If there are no further questions or comments, is anyone willing to make a motion?
I am.
Great, thank you, Commissioner Hill.
I would move that the commission approve the small business, excuse me. Is that the right one?
Yes.
Yep. I move that the commission approve the small business impact statement and the draft 205 CMR 244.06 as reflected in the commissioner's packet and discussed here today. And further, that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency, and thereafter to begin the regulation promulgation process. I further move that staff shall be authorized to modify chapter or section numbers or titles to file additional regulation sections as reserved, or to make any other administrative changes as necessary to execute the regulation promulgation process.
I have a second.
I have a question on that last bit of language. I understand the numeration part of it. But to file additional regulation sections as reserved or administrative changes, are these ministerial changes, Todd?
Yes, so as you'll see in the reg that we're going to talk about next, that since this is 244.06, they may require that we file 01, 02, 03, and 04 as just reserved. And that's what that part means.
Okay. Madam Chair, my only request would be that the motion specifically say that the first shall in the proposed regulation be changed to may for the record.
Thank you. So
And I'm okay with that.
you amend your motion to reflect that the regulation with the amendment discussed today? Do you want to, Brad?
Yep, I'm just reading it here.
I was just specifying the as discussed here today means that the first shall becomes a may.
Especially today with shall become may. I guess I was saying the amendment, but do we want to say shall? Yeah. May? You want to reread it with that in mind?
I'm
The only,
Are you asking,
well, here, can I?
asking me or Commissioner Hill?
Commissioner Hill.
I'm just trying to find that. I'm trying
language.
to find that language, so bear with me.
I can, if it would be helpful, I can share what that would look like. And the only other point I would make while Commissioner Hill is looking is that this would seemingly require them to be brought back before the commission for approval under this section, since it's a may and it's not an automatic certification. And that's not a problem at all, but that's, I think, procedurally speaking, what we will need to do. Unless you want to authorize that, the two labs now, but I just wanted to mention that.
Would you like me to read the entire motion again?
Can we just hold on one thing? Does that slow us down in a way that they can't get going, or we can just move on in a future meeting? Is that what you're saying, Todd?
Yes, I don't think it significantly slows anything down. It just requires, I think, one additional step that will likely be able to be taken care of fairly quickly.
I think that's what I was sort of struggling with before. I wasn't able to articulate it. Thank you. Okay, Commissioner Hill.
So we're just changing from shall to may. Is that accurate?
Mm-hmm.
Okay, so take what I said before, get rid of that. I move that the commission approve the small business impact statement and the draft 205 CMR 244.06 as reflected in the commissioner's packet and discussed here today. And further, that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency, and thereafter to begin the regulation promulgation process. I further move that staff may be authorized to modify chapter or section numbers or titles to file additional regulation sections as
my apologies, we weren't really clear. So that part is fine. I think we just wanted to have the change where it says and discussed here today. We're recalling the way back, it's already been a long morning, where Commissioner O'Brien wanted to shift the language in the regulation from shall to may. So we're really, the regulation is on page 8, that language. So we're losing,
so it's adding the phrase and specifically that the first shall in the draft regulation shall be changed to may. That phrase just has to come in after the and discussed here today part of the motion.
And discuss here today, changing the shall to may.
Right.
Good thing you have that radio background, Brad. Reread it for the third time.
It gets better each time.
So I'm just putting this, so as reflected in the commissioner's packet and discussed here today, and further that staff so right
I would
after,
say,
And specifically that the first shall in the regulation shall be replaced with the word may.
want to make sure it's the first shall, right?
Yeah, it's the first line.
Okay, good.
and we would put that
Thank
under after the commissioner's packet and discussed. Where would you want that?
Right after and discussed here today.
That's in the third sentence, the third line.
Yeah.
Okay.
We'll try it again.
Let's do it.
Okay. I move that the commission approve the small business impact statement and the draft 205 CMR 244.06 as reflected in the commissioner's packet. And specifically that the first shall in the first sentence of the regulation be changed to may. And further, that staff be authorized to take the steps necessary to file the required documentation with the Secretary of the Commonwealth by emergency and thereafter to begin the regulation promulgation process. I further move that the staff shall be authorized to modify chapter or section numbers or titles to file additional regulation sections as reserved or to make any other administrative changes as necessary to execute the regulation promulgation process.
Do I have a second?
I second the motion.
Any further questions, discussion? Okay, I'll take a roll call vote. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner.
Abstain.
Did you say abstain or same? Abstain.
Abstain.
Okay, and Commissioner Maynard.
Aye.
Okay, so I hear, and I vote yes. So 4 ayes and 1 abstention. All right. It is, I'm looking at the clock, 12:06. Crystal, please accept our sincere apologies because we are way off your well-lined timeline. I can only say it worked that we canceled our what had been an anticipated second meeting today. I think it makes sense that we continue on to item 3B. So I'll turn back to Councilor Grossman. Thank you.
Thank you, Madam Chair. Momentarily, I'll be pleased to introduce our Associate General Counsel, Judy Young, who along with Burke Kane and Sterl Carpenter will discuss a draft set of regulations governing House rules. Just by way of quick introduction, it's important just to recognize how this fits into the overall construct of Chapter 23N and why it's being brought before you today. And that is when you look at Chapter 23N, it's Section 6C. That's the section that talks about temporary licensing, which of course the Commission will address in the coming week or weeks. But as part of that process, the law specifically says in Section C3 that all sports wagering conducted under the authority of a temporary license shall comply with the House rules adopted under Section 10. So this is a necessary component to any temporary licensing that may come about if when the Commission reviews that process. So I just wanted to set the stage as to why you're looking at this today. And with that, I'd like to turn things over to Attorney Young to take it from here.
Thanks, Todd. Good afternoon, Madam Chair. Good afternoon, Commissioners.
Good afternoon, Judy. Good to see you. And it is afternoon.
It is. All right, so the legal division in partnership with the IEB has drafted 205 CMR 238 subsection 3 house rules, and we've provided a memo and a small business impact in the meeting packet for your review today. I think before we start, it's best to kind of ground ourselves in a definition of what house rules usually are, the research that's come into this regulation, and then also a few notes, and then we can kind of walk through the regulation together, taking time to pause at each section and answer some questions. But going back to the beginning, house rules are best defined as the policies that guide and govern transactions, between a sports wagering operator and their patrons. They're aimed at providing guidance, clarity, support, notice to patrons who will place wagers within an authorized in-person facility or also within a mobile digital platform. Nearly every jurisdiction that regulates sports wagering has these regulations pertaining to house rules, albeit some are different than others, and some jurisdictions have more extensive requirements for licensees. Our legal team, as well as the IAB, has done an extensive amount of research, comparative research, in drafting our reg and including specific requirements for operators within the Commonwealth in accordance with the provisions of 23N. While an operator's house rules will be unique to each entity that will operate within the Commonwealth and that the Commission will ultimately regulate, as they could have different offerings and programmings, accept different wagers, the things that we'll talk about later on in the presentation, it's ultimately the Commission that will have the authority and the ability to prescribe what policies, procedures, and notices will appear in an operator's house rules, and then ultimately the Commission will approve them before operations can commence. I do want to add that in addition to these house rules, however, the Commission will also develop additional regulations that further protect, guide licensees and interactions with patrons, including player wagering accounts, as the Treasurer mentioned earlier this morning, self-exclusion, responsible gambling, advertising, problem gambling supports and the problem gambling support hotline, and additional provisions of 23M. So with all that, I will walk you through the regulation section by section. We'll discuss it. I also just want to add briefly that we've had some internal discussions after the reg was submitted into the packet today. And so as we walk through, I will point out those changes to you. And then at the end of the presentation, if everyone's amendable, I can show you the red line changes that we've made before you ultimately make your vote. Is that okay? So good. Okay, I'm seeing nods. Okay, so
Yes,
starting
absolutely.
with fabulous. Starting with our regulation, and just to kind of expand on what Attorney Grossman said previously, we have gone ahead and reserved section 238.01. That is the definition section of chapter 238, the uniform standards of accounting procedures and internal controls as pertaining to sports wagering. So very similar to the previous regulation that the Commission walked through, this will sit in the 200s within the regulations of the Commission. And we've gone ahead and reserved sections 01 and sections 02 prior to house rules appearing, so that ultimately when we do file, the Secretary will know that we're going to go back and file these things. Any questions on that, or the numbers and reserves, or any codification before we get into the reg specifically?
No helpful, Julie.
Okay, fabulous. So these first three sections are procedurally modeled, after 205 CMR 138.02, a licensee system of internal controls. It follows the submission, the approval, and amendment process, and lays them out in sections 1 through 3. Starting first at the scope, as General Counsel Grossman, mentioned, we are discussing the approval of house rules as they pertain to temporary licensees, and also the approval of house rules more generally as they pertain to sports wagering operators within sections 6 and 10. So you'll note that dual addition there within section 1. This section also goes on to state clearly, and again later on within the section, that an operator shall not conduct sports wagering in a manner inconsistent with its approved house rules, but it also shall not commence operations until its house rules are ultimately approved by the Commission.
So Judy, I have a question about the language choice
Absolutely.
there. the second sentence, an operator should not conduct sports wagering until the commission has approved the house rules. Even as you described it, you said their house rules. So don't we need to say the operator's house rules? Because right now it just almost implies once we approve this house rules reg. You know,
No, I think that's an
becomes moot.
excellent, I think that's an excellent distinction. We could make that change to their house rules, as it is going to be an entity specific, submission.
Right, so it either has to say there or the operators, either one of those, yeah.
I'll get that, Judy. You can keep going.
Awesome, thank you, Deb. Okay, so next we have our submission protocol. Ultimately, a sports wagering operator, and that includes a temporary licensee, will submit to the commission its proposed rules. And again, not commence operations until they are approved with what's laid out in subsection 3. So if there's no questions, I think we could get into the more expansive process within section 3, but I can pause here as well.
I do have a question.
Sure.
Go ahead, Commissioner.
The sentence that says, a sports wagering operator shall not commence operations until its submission is approved in accordance with 205 CMR 238.02(3). Is that citation accurate? And if it is, what is the rationale for bringing this particular regulation forward, 238.03, without 238.02? If an operator wouldn't be allowed to proceed without their without approval of their internal controls.
Sorry, Commissioner, can you repeat that one more time for me? I'm trying to see exactly where you are.
Yeah, so in order for an operator to commence operations, the commission needs to approve the internal controls. And that's just according to the sentence that I just read. But we don't, I mean, so I guess I'm asking, why are we taking this set of regs, 238.03 in isolation from 238.02.3? Like, doesn't it make sense that they come together as a companion?
I see. I think ultimately that is a typographical error. I think it should be referring to 238.03 subsection 3, the approval process below. However, this section was modeled after 138.02 that pertains to the submission of internal controls. And so I think when we moved this over, ultimately it kind of modeled the submission of internal controls. Whereas in these 200 level regs, we have house rules going first, given the fact that the statute directly cites to house rules needing to be approved. And then ultimately the submission process that will be laid out in 238.02 once it is drafted and ultimately brought before the commissioners will likely be very, very similar.
Okay, so the citation in the second sentence should be 238.02. I'm sorry, 238.033.
Subsection 3, that's correct, yes.
So I'll make that change as well.
Yes.
Should it be both 023 or just 033?
Well, currently the section isn't that we could add to this regulation isn't currently enacted. So we cannot cite, the secretary will not allow us to cite to a regulation, even if it's on reserve. So we could come back to it later on and add it during like a regulatory review process, but not currently.
Well, can I ask a question then to follow up on Commissioner Skinner's question, which is if historically we have done this so that it has to be done consistent with their internal controls and we're mirroring the process, are we losing something in terms of integrity by not having 0.02 ready to go?
What if we were to do just a practical solution and say, in accordance with
its internal controls?
Well,
Yeah, because I don't want to lose that.
Regulatory, if that makes sense.
Or Todd's leaning forward.
Yeah, I don't think, I'm sorry. I was just getting a little anxious.
Yeah.
Okay.
I like it. Thank you.
I think what you'll see is that actually 03, the section and that follows that Judy's about to discuss is actually nearly identical to the section you're talking about. So we
What,
have captured it.
38.2?
Yes, we have not, we're not lowering the standards or lessening the controls in any way. It's just, that was a typo. I think the proper citation is to 238.033. And what you'll see, I hope, when we look at 033 is that that is basically the same process we use for the internal control. So we'll have this standalone procedure for House rules that should give the commission the ability to make the same judgments it does with internal controls.
And I guess my point speaks to more of the emergency nature of these regs, is if an operator won't be allowed to commence until the commission has approved the internal controls, doesn't that defeat the purpose of putting this forward on an emergency basis? When we don't have 238.02 before us?
Yeah, I think that one of the next series of regulations that we will present to the commission, and I don't have an exact timeline on it, but in the very near future, will likely relate to some sections of the internal controls. So it is entirely possible that 138.02 will be brought before you, but I'm not 100% certain of that at the moment. So I don't think that that needs to necessarily stand in the way of this section moving forward. I think this can be looked at on its own, and the process here kind of will withstand the type of scrutiny I think you're all interested in seeing, and sets up its own process for House rules that will likely be parallel to those that you'll look at when it comes to internal controls. But it's also fair to, I think, establish this process now so everyone is aware of what the future holds with House rules.
And then Judy, just a general comment. House rules at times is capitalized, other times it's not. Same thing with sports wagering operator, just throughout the document. So
Okay.
Just flagging that for you.
Thank you. Shall we proceed, or does anybody else have additional questions on section 2?
All set, everyone?
All right.
Thank you. Yes, Judy.
Okay, so moving into section 3, subsections A through D. This guides and is very, very similar to 138.02 to the submission of internal controls again. It ultimately dictates what the executive director, or how the executive director shall review the submission and to what standard of compliance. So we have listed there 23N and relevant provisions of 205 CMR 238 subsection 5. So below that is the actual listing of the House rules that the commission will ultimately decide to approve, review, or modify. It discusses in which case when the commission and the executive director will review or ultimately approve the submission, or go back and advise a sports wagering operator in writing of any deficiencies and provide them an opportunity to make the required changes as necessary. At the very bottom of paragraph A, it also lists how a sports wagering operator can dispute a determination or recommendation made by the executive director to the commission, and how to ultimately resolve the issue.
So,
and in what
Judy,
form their issue should be resolved. Sorry, go ahead.
So I guess the way that sentence reads, though, it implies that the operator may dispute any determination or recommendation made, which shall resolve the issue. So is the fact of raising the dispute determinative? It kind of, as opposed to what is the resolution? What's the act that resolves it? Is it the ED who then resolves it?
At that stage, right?
Yes.
Right. So I think that needs clarity in the language, though.
It may be missing a comma or what have you, but I think the point is that the ED flags any issues and that the operator can then essentially appeal directly to the commission, which shall resolve the issue. So that's the way it is.
But it doesn't really say that. So how do we rewrite it to say that? It just says which shall resolve the issue. It doesn't say,
Yeah.
and the commission shall resolve it or the ED shall solve it.
it may have
I'm having some pause here with
Yeah, I
some
actually
of the
paused
edits
too.
we're catching here as we go on this one, because it's a pretty important reg.
And I mean, I did struggle on that and I kind of reconciled it in my mind what it meant. So let's just go through that language.
Yeah.
Judy, if you could read it to us
Ultimately,
again.
yes. So starting with the sentence, and section A, the sports wagering operator may dispute any determination or recommendation made by the executive director to the commission, which shall resolve the issue. Upon the recommendation of the executive director, the commission shall review the submission for approval at a public meeting. So ultimately, we could add some clarifying language in there of how the executive director would resolve the issue and what standard of review could be utilized by the commission at a public meeting if it's helpful.
The sportsman may, how about may appeal? I mean, is
Period.
appeal too strong? Is appeal too
I mean, yeah,
strong?
what is the process they would have?
Any determination made by the executive to the commission. So you really did want, I had thought, well, perhaps it was an informal back and forth between the director that you were getting at. It kind of resolved that in my mind, because ultimately I saw that the commission does have the right to revisit any issue. But if it really is that if there's a dispute, then we should clarify that they have the direct right to come to us. So the sports wagering operator may. Is this an adjudicatory? Is it an appeal?
No, at this point,
No.
I don't think so.
I don't think so either.
I think,
Is
what
it-
if you just remove that one comma, would that clarify the sentence?
No, because I think the to the commission isn't,
No.
may dispute, may to the commission, dispute to the commission is a little,
Yeah, I mean, what does dispute mean, really?
yeah.
To your
dispute.
Kathy,
to
is
the
it
commission.
appeal? Is it complain? Is it, what does that mean
May
procedurally?
challenge any determination before the commission. I mean, I think there's just a little bit of a wordsmithing. It really is a wordsmithing, but for resolution of the issue, hopeful resolution of the issue. Is that, and I assume that means that it's final resolution with us.
Yes, I think we could add some language in that final sentence about the commission having the final, if there is a disagreement process initiated, that the commission would have the final say at that public meeting that's mentioned in the final sentence.
And is it final under 30A or is there anything else?
Not to my knowledge. I think that it would be final.
Can't go to court. Okay. I would may challenge any determination or recommendation made by the before the commission in order to resolve the issue. Is that too soft? I mean, upon the recommendation, the executive commission shall review the submission for approval.
Yeah, I guess I'm having trouble reconciling those two sentences also. I mean, because.
Yeah, I did. I think I reread them twice, 3 times.
Yeah,
so.
and if I'm struggling with it, I worry about operators trying to figure out what the process is. I feel like this needs to be reworked. But maybe we should table this and go through the rest and then circle back.
Okay,
so we
yes,
keep it
absolutely.
moving,
Yeah.
or-
I think that's a good idea. I do think it's more, we don't need to complicate it. I think it's more wordsmithing. As long as you know in your mind, Todd, and Judy, what the process actually is. Executive director, and we'll just say X meets with operator X. Executive director recommends something, operator says no. The operator can comfortably say, thank you, I'd like to go before the commission.
Okay, give us a chance to see if we can rework some of that language.
Yeah, but
I'm
then, and
confident
then
we
even the
can.
second, Judy, as you're doing that too, so the meaning of that last sentence in terms of, I'm not really sure what that means. Upon recommendation of the ED, commission shall review the submission for approval of public meeting. I'm a little confused what that means, because are we supposed to then lay approval to something the ED did and it's not final till we approve it? Or is it,
We still have
if they're already
discretion.
coming to us to complain, then there's no role for that? Like, I'm not really sure where that fits into the process.
Could I possibly help? Good afternoon, Chair.
Good
Stein.
afternoon, Cyril. Nice to see you.
Nice to see you as well. Commissioners, Executive Director Wells. If I could be possibly helpful here, this process is, what it's doing is mirroring what process we do for all the casinos that we do right now. And it's 13802 subsection 2. If I could read that subsection 2, because that's already accepted, and this is what Karen does on monthly, yearly changes to all of our submissions. So the commission shall refer the proposal submitted in accordance with 205 CMR 13802 subsection 1 to the executive director, who shall review the submission for compliance with MGL C 23K 205 CMR 138 and other applicable sections of 205 CMR. Upon completion of review, the executive director shall either approve the submission or advise the gaming licensee in writing of any deficiency, and may include any other recommendations and or required changes intended to ensure that the robust system of internal controls is implemented. The gaming licensee may either accept the recommendation or require change in writing, or advise the executive director in writing as to the reason for its disagreement. The gaming licensee may dispute any determination or recommendation made by the executive director to the commission, which shall resolve the issue. So they're saying that you as the commission will resolve the issue between the executive director's decision and the licensees, and you will determine.
Yeah, the problem, if you look at that though, that also, to go back to Commissioner Skinner's earlier point about the internal control section, that incorporates and is part of that section. And the detail is not in this reg that's in front of us.
When we're looking at these regs, we have to look at it singularly. The internal controls and the operators will not be allowed to be in operation until the internal controls are given, and that these house rules are approved and their internal controls are approved. So I believe what we're doing here is we're just getting these house rules first. The internal controls are going to take, I mean, we usually have 90 days they're supposed to be given to us prior for just the casinos. I'm assuming we're going to mirror it in such a way where sports wagering, there's going to be a great deal of information. So they're just trying to start this process. I don't know if that's helpful or not. I hope I've helped.
No, I got that part. It's more but we have this reg in front of us in isolation. And so we have to look at it. Does it make sense to us? And the language, and I had pulled that up as well, Sterl. Thank you for reading it. There is more detail and specificity in that than is what is in front of us.
Yes.
Can you remind me of that next sentence, the last sentence, upon the recommendation of the executive commission shall review? That's in there as well. Review the submission for approval at a public meeting. Yeah.
Was that to me?
No, yes, Joel, it is included, correct, in yours? In the outstanding, upon the recommendation of the executive commission shall review the submission for approval at a public meeting. Or it's not. No,
Yeah, I don't think it is.
It's not in 138.
I think allows it for 23K.
I stopped at where you guys decide. There is a little more. There's the commission or the executive director may revisit any provision of the internal controls at the time and direct adjustment as necessary. So that's after the process. So that's why. I
Yeah,
didn't read that. That's where
we
it
have
is.
that in the reg in front of us, so that's helpful.
Okay.
But I think it's the additional sentences included because I think the difference between 23K and 23N, right? So you needed to bring it back to the commission. All right.
Yeah, and on the gaming side, the ED is authorized to just approve the internal controls by
Right,
regulation.
that's what
But
I'm
the
saying.
statute-
Here, we
yeah,
have to
the
come back to
statute
us.
requires the commission to do it.
Correct.
Right. Yeah.
So that's why that line does not appear in the language.
That's
code.
what I thought. Yeah, okay. So I did struggle with the combo, but it was helpful to go through the exercise. So upon the recommendation of the executive director, the commission shall review the submission for approval at a public meeting. That's not necessarily with one that's just in dispute. That's with respect to all of them.
That's correct. And that sentence is also mentioned prior to the highlighted section that we're going to go back and rework. So upon completion of review, we can stick that language for approval at a public meeting next to the sentence regarding submission, if you don't think it would be, too long of a run-on sentence.
I mean, I hate to say this, but I think I'm going to want to see a red line version of this.
Oh,
to
absolutely.
Be able to process.
And if I could get clarity, is it the intention that the commission approve the House rule submissions? That's how I read this.
I
We
think the
have
statute-
to by statute. We have
Okay.
to by
The
statute.
statute says we have to, yeah.
Thank you.
So that's the difference. Under 23K, the executive director has authority to do the internal control process. That's why we get those regularly in our emails. So there's a little distinction between the two. So I just am struggling a little bit with the last language, but I'm sure that you can get clarity on that, Todd and Judy.
Definitely.
Let's continue.
Okay.
So B explains, you're on subsection B, 3B, Judy?
Yes, thank you. So again, picking up where Sterl mentioned, we have subsection B that's also found in 138.02. The commission or the executive director may revisit any provision of the previously approved House rules and require adjustment if necessary and provide for a 30-day implementation period. So this implementation period mirrors the current implementation period within 138.02. And also I should add that 138.02 is a part of the reg review process that we are also modifying to include that 30-day implementation period. So these two regulations will continue to model each other. We've also gone ahead and added language, and I'm happy to show this to you via red line, to also give the commission or its designee the authority to direct immediate change if it's determined that a licensee is not following the House rules as prescribed by the commission, or if there's something in their House rules that's in direct conflict with 23N or 205 CMR. I'm happy to screen share that with you if you'd like.
Because I couldn't follow that, Judy.
Sure.
I'm sorry. So
No, it's okay.
Really
Give me one moment and I'll just pull it up for you.
I'm hoping somebody silently joins me in being a little bit challenged right now. So thank you.
Just 1 second and I'll find.
I'm not going to silently join you. I'm going to openly join you and say, I'm probably going to need time to process this before a vote, just with what's going on.
Yeah.
Okay.
I understand. Okay, we'll just need that a little bit bigger.
No problem. How's that?
That's better for me. There, okay. So this is section 3, and you've added new language that's not in the packet?
Yes, I apologize. After some internal discussions, we realized that we needed to add a little bit more language here to give the commissioners additional discretion and authority to direct immediate changes. So we have that 30-day implementation period of which a change or an amendment can be made and implemented by a licensee, but also we wanted to cover instances of direct conflict with the statute or other regulations that would require immediate change. So that's that red line language right here.
Can you make it a little bigger, Judy?
Certainly.
Okay, questions on this? I have a couple.
How's that, Commissioner Hill? Bigger or smaller?
If you could just expand the whole screen, I think that would be helpful. Thank
There
you.
we go.
You're welcome.
So under the statute, the commission must approve the House rules by statute. Is that correct?
Yes.
It doesn't say the commission or its designee. It says the commission, correct?
That is correct.
Yeah. Caitlin, I'm a little bit concerned about a delegation of a statutory authority. So I understand the need to be nimble, but I'm wondering if there's something that's in direct conflict with the statute, I think it should be brought to the commission's attention anyway, so we could address it. I understand there's probably the expediency issue, but.
So removing the reference to designee and giving the sole authority to the commission would be something Madam Chair was more comfortable with.
I don't think it's giving it to us. I think.
You're correct. You're right.
Yeah. Because I'll give away that. I think we've been.
That was a poor turn of phrase. I apologize.
For the authority. Right. Thank you. And again, that's just me being cautious because of a recent SJC decision.
Absolutely.
And so Caitlin, just note, because I brought it up to Caitlin, and I, just as a note, we can revisit it if we feel that there is room, right?
Absolutely.
Okay, thank you. All righty. So you know what, Judy, because I'm not sure if we're all seeing the same thing. I'm seeing just the bottom portion of B. So were there any other red lines above?
No, I've just highlighted this area that we've discussed previously, just as a reminder to go back and rework that language and then bring it back to the commissioners. I can also stop the share. This is within section C, this added red language here. And if the proposed amendment does not lessen the applicable administrative or substantive provision. So subsection C covers the amendments to House rules that are ultimately submitted to the executive director and discusses how they're approved if they're in compliance with 23N, specific sections of this House rules regulation and other sections of 205 CMR, but then also codifies to be sure that the proposed amendment does not lessen any sort of applicable administrative or substantive provision.
So that says amendments to House shall be submitted to the executive and approved. So that's giving the approval to the executive director there.
So yes, that goes, it kind of returns these amendments to House rules to the executive director for approval, but we could easily tailor that so that it mirrors how ultimately rules are submitted and approved by the commission if the commissioners agreed on such.
So this is the distinction between 23N and 23K, Judy, if I understand it correctly.
That's correct.
23K, she has full authority to do that for the internal controls. House rules, it comes back to us ultimately, right?
That's correct. So I think it's worth discussing amongst the commissioners for expediency's sake, given the amount of different licensees, if you all wish to have the amendments brought forward to you to figure out if they're in compliance, but it's an easy change to make by the legal department.
Well, yeah, so my question for the legal department, and then I'll stop on this point, is if we're required to approve House rules by statute, then I assume we would be required to approve an amendment to the House rules under the statute. And so I'm, given this recent SJC decision, I'm concerned about, and actually prior to that decision would be concerned about delegating statutory responsibility. So, but I could
Absolutely.
Be.
Yeah,
Commissioner. Is that, I mean, okay, now we can.
Yeah, it's me. It's Eileen. I agree with you, Kathy.
Oh, okay, good. I'm not way off. Commissioner Skinner, I see also you have your name on down.
I agree.
Okay,
I had that down as one of my comments, Madam Chair.
I'm just going to stop share so I can see folks while we go through comments, but I will make that change and then I can reshare the document if folks are comfortable.
Judy, I think there also needs to be some adjusted language relative to the approval, because the way it reads, whether it's the executive director or the commission, shall be submitted and shall be approved. I think we need to build in some language that gives us the discretion to approve or deny.
Yeah. That's just where the language is not, just a little bit needs to be tweaked a little bit.
Yeah.
Commissioner Skinner, if I'm understanding you, you're in section 3A, where it talks about approval or the modification process. You'd like to see language regarding denial outright?
This is C.
Okay, I see.
That first sentence implies that as long as it's submitted, it shall be approved. And I don't think that's the way we want that to read.
Understood.
I do see the process as Karen does all the work and then
Okay, I see Todd making changes to the document, but then I'll reshare it after he's done. So then moving on to section D, if everyone is comfortable, it discusses the commission or its designee performing inspection necessary to ensure compliance. I recognize that we previously changed that language or its designee in the above provision. I'm open to discussion regarding it, removing it from there as well.
yeah, I think it just, yeah. Right? Any inspection necessary to ensure compliance. Maybe I'm wrong on that. We can designate inspection, right?
Done by the IAB and the licensing division?
Yeah.
Okay, we'll leave
I
it.
mean,
I don't believe there's a statutory requirement for inspection by the commission.
not at all, no.
No.
Yeah, okay.
So next, moving down to section 4, we have the placement and the accessibility of house rules. This is statutory language. They shall be accessible to patrons, prominently displayed within an authorized in-person wagering facility. That phrase, authorized in-person wagering facility, is how the legal department and the IAB will refer to in-person sports betting facilities. I think the colloquial term is retail facility, but just for the sake of transparency and ease, an authorized in-person wagering facility is the term that we use within our regulations and will continue to use unless the commission deems otherwise.
Thank you for that.
Absolutely. And also the second portion of that regulation discusses prominent feature within a sports wagering operator's website or mobile platform. So making those house rules available on either sort of instance. Commissioner Ryan?
Judy, is that language that's taken from other jurisdictions language? Where does that, because I'm wondering what I'd like to know, what does that mean exactly? Like, is someone going to put small print on the opening page, but then once you leave, it disappeared? Like, what does it mean?
We can tell you in the retail sports book, Karen can tell you what it looks like. She went and got the house.
No, I'm not. I'm talking about the online.
Online, I think it's, yeah.
Or mobile application. It's like, well, what does that mean on the platform and or the mobile app?
So I've seen different things in different jurisdictions during my research. And I mean, I welcome the input of General Counsel Grossman and Sterl and Burke on this, but some platforms allow patrons to click through and saying, and agreeing to certain provisions. I am, the legal age to place a wager in this particular state. I am currently within the geo confines of this state. And I have, read and been made aware that the house rules are available. And then there's a hyperlink within those 3 to 4 provisions that you click through that ultimately allows you to launch onto a separate page that pops up and you can view the house rules, almost like terms and conditions on other websites not related to sports wagering. I've also seen mobile skins or mobile platforms in my research that simply just have you indicate that you are the legal age to place a wager and that you are in the state that allows you to place that wager. That's it. And then simply has terms and conditions or otherwise house rules within a clickable link displayed on the upper right-hand side or lower left-hand side of the page or under the contact us provision. I think ultimately the commission can really define what prominent display means to us.
That's I guess that's my question is,
Yeah.
Are there other jurisdictions about prominently featured, or is that a definition that we're going to have to come up with for this section?
I have not seen many definitions, if any, I'll be honest, pertaining to prominent display and what it ultimately means. But I do think the commission, has that discretion to outright define what prominent display means, especially for something as various as a mobile platform.
If I may.
Sure, Cyril.
So in my research from other jurisdictions, they leave it open for interpretation by their commissioners or their review, their either executive director. But what is normally performed is that the house rules have to be accessible on their main page. So what they mean by that prominently displayed means it's part of that menu. Like some people have like little lines on the side of their apps, but as part of that drop-down menu, prominently one of those features has to be written house rules. So it's easily accessible so that they know when placing a wager, all of the rules that they are accepting between the licensee and the patron.
And Sterl, not to put you on the spot, but are you familiar with any cases where people have tried to say, yeah, that's good enough, and another jurisdiction has said that's not prominently enough?
Yeah, well, it depends on the jurisdiction. So, exactly. So just for knowledge, Missouri, they usually have the toughest, right? And so they don't have sports wagering yet. So I'm sure Missouri would state, prominently means, and they'd go into detail what prominently means.
Right.
You as the commission, as I read the statute, can decide all of these features on what you decide is prominent is up to you.
But do you have any anecdotal information in terms of another jurisdiction that's launched where they've been found to be not satisfying that prominently displayed, prominently featured requirement?
I have not. I'm not knowledge of those, but I am knowledgeable of. I've accessed a couple of apps, and like in Rhode Island, the drop down has house rules immediately accessible. So it's pretty prominent throughout the industry that those house rules are displayed very upfront with all their customers.
Okay. Thanks.
Judy?
Yes.
Back to the reference to an authorized in-person wagering facility. That's getting at the retail facilities.
Yes.
I think you said. But the sports wagering operator speaks to both mobile and retail. Correct?
That is correct, yes.
Thanks.
And I will just add that sports wagering operator is defined within 23N.
Precisely my point. Thank you.
I've looked up a couple of other jurisdictions, Commissioner O'Brien, and it looks like in some of the language I've seen, all it says is that they have to put it on their website. Doesn't say specifically where they have to put it on the website.
Right. I guess I'm contemplating, I don't want to see workarounds where, people have a tab and they can just jump past that.
Right.
I'd like it to be sort of prominently displayed or featured. I'm trying to figure out what that means. I was just wondering if other jurisdictions had some language on that.
I can continue my research. I'm happy to. It does seem that it definitely varies based on the jurisdiction that the mobile operator, a great majority of these are mobile jurisdictions that only have mobile sports wagering. It seems up to the regulatory body and what they ultimately provide for.
So to Judy's point, hello, everyone.
Hi, Bert. Good afternoon.
Oftentimes when we're reviewing submissions at the casino, we will always ask for additional details. And when they give us the details, we will guide them and help them to get to a point where we're happy with those additional details also. So I would think that, prominently displayed, we could ask for them to define that a little better. And if we weren't necessarily happy with it, the commission could ask for more details about how they do that.
Yeah. I'm just wondering if going as a jumping off point, do we want to have a threshold? Saying at a minimum,
Just to be sure I'm understanding you correctly, Commissioner O'Brien, placing like a minimum within section 4 would be something that you're interested in, like a spatial requirement of some kind?
Well, that's what I'm trying to understand, whether this is going to be in a definition in the beginning. I mean, we have a placeholder for definitions for this reg. So is it going to go there, or is this going to go within the body of, 23803?
Speaking just personally, I think that it would be better for the term to be ultimately defined within 238 subsection 01, as I anticipate that prominent display will guide other regulations, or other regulations that ultimately come forward will be used within them. So I'm thinking about the problem gambling hotline and other things that need to be properly and prominently displayed.
Yeah, I know. This speaks to the struggle that we're having, or I am having,
moving things differently, and
having one in front of us where the first part of the reg is not done yet. So
I completely empathize. Yeah.
And just to be clear, it's prominently displayed and prominently featured. So
yes,
right.
Well, let's.
Yeah.
We can kind of narrow it down to one.
Figure out what the term of art we want to use.
But I think we want to be careful to not assume, what that means because of the technology. Could be asking for something that is just extraordinarily expensive or not even workable without knowing it. For an operator, all of a sudden we said, change it up. So the truth of the matter is that house rules are, the adoption of house rules, our approval of house rules is really a critical step in the application process.
Eileen, just for informational, I pulled up a couple of other jurisdictions, and it looks like they display their the house rules and things of that sort in their terms and conditions.
Yeah.
So you'd go looking for it in the terms and conditions of when you're wagering on a mobile application or an internet site.
Judy did say it's like terms and conditions, right, when you're doing any kind of online engagement. When you go to a sports book in retail, that it's not as though the rules scroll in big font across. They're hung on the wall, and I can't remember if there was some kind of a electronic. I can't remember if they had an electronic scrolling on the side. Loretta and Karen and Nikisha, but I have never seen it on the mobile device. I don't know.
Yeah, I'm concerned more with the mobile application than
right. I understand,
mortar.
but of course it can't stay there permanently because they wouldn't be able to see their screen. So, and it's also pages.
No, but can also access to it can be easy or it can be difficult or fleeting. So that's
maybe that's the idea. It's not necessarily permanently featured, but rather easily accessible. I mean, maybe that's what you're getting at, right? Because it can't be always on the screen, otherwise the screen would be unusable. So
yeah, but I'd hate to see a circumstance like all of us that just say, okay, the cookies to move on. Or, as opposed to knowing that you can get access to go look it up if you want to know what it is. I agree with you. I'm assuming it's in a menu of some sort. Rules and all the items that are necessary. Loretta, if you have any input on this, Loretta?
I recall the in-person rules being like literally on pieces of paper on the board, marked and available, plenty of copies available. I have seen some of the mobile, usually on a link on the home page. As I recall, it's been called house rules and not terms and conditions, but that's my recollection.
That's fine. Okay. So we'll revisit that language. It is now 1 o'clock. I don't think I've ever been this off on running the meeting, but I think it's been a really important discussion. And we're making some headway. I guess that we had thought that we would be done by 11:15 on this issue. It's 1 o'clock. I think that we need to take a break. We're just going in now to the next part of the House rule discussion. Karen, what's your recommendation? I would think we could take a half-hour break and then we would move to finish up with Judy. And then we need to get to, I don't know if there's any prioritization for us to think about. Maybe we can do that at lunchtime.
Okay. The only thing I'm wondering is, do we have an outside speaker?
We do, and I'm taking that into consideration. I know that Dr. Wahlberg was very generous.
Yeah, whether we take something out of order.
No, she said she would be flexible with us.
Oh, good, okay.
I want to honor that. Flexibility may not have been
right
after dinner.
Right.
So
right.
We'll just check in on that.
Madam Chair, if we could consider prioritizing the budget matter, I think that's something.
My goal is not to minimize anything. My goal is to be mindful of time as we go forward. But so the financial is next after Judy, Lakeisha. Okay. So I think that I agree with you. So we've got that. And then it's kind of anything that needs to be voted on. I would like to make sure that we keep everyone, and then we'll check in on Dr. Goldberg. So it could be worse, right? We've made some good headway. So Judy, thank you for hanging in with us, and we'll break now 1 to 1:30 for lunch. Stretch our legs. Everybody take some good breaths, and we'll come back renewed and revived, and finish up on this matter, figure out the plans for this matter, and then we'll turn to Derek PT and Commissioner Skinner. All right. And does that work for everyone? Commissioner Maynard, we are extremely appreciative here.
I will say, Madam Chair, that I did say to Crystal that I think we'll be done by 3:30 Mountain Time.
And that translates to 5:30 or 6:30 here. 5:30.
Yeah.
Yeah. Well, I'm not far off on the dinner thing. I think I'll text my husband. Okay, everyone. Thank you for this time.
Thank you.
We'll be back at 1:30.
I was sad to see the Queen died.
I just saw that. It just came across my screen. End of an era.
Huh?
Yeah. I said end of an era. My gosh,
Yes, for
70 years
sure.
on the throne.
Someone who had a tough job and did the best she could, you think,
Yeah.
Not perfect, but that's a shame.
It's amazing that she greeted the new prime minister. What was that, yesterday or the day before?
Yesterday.
Yesterday.
Yeah.
Or no, Tuesday. It would have been Tuesday.
Wow.
They've had enough time to do succession planning, but we'll have to see how it goes.
Mm.
I'm embarrassed to ask this, but who's next?
Charles.
It is
Prince
Charles.
Charles. Yeah.
The longest waiting in history.
73 years he's been the heir.
Yeah. I am struck by looking at the line of succession. The odds of a female reigning over that country in my lifetime are almost zero.
Right.
So, she had that, that long term, and now, it's a lot of male heirs. So it is the end of an era for sure.
Commissioner Maynard, this is Mina from Anderson Krieger. The good news there is, or maybe not good news, but the same could have been said when she became queen. That the chances of her, or when she was younger, the chances of her becoming queen or any female queen were a pretty long shot then too.
Yeah.
Take some serious turns.
We can think
She didn't have
Wallace
a long
Simpson.
period of decline. Say that.
Wallace Simpson can be thanked for the Queen's reign.
Now he's the king now, like that.
Mm-hmm.
"15 prime ministers. It's pretty something.
So what does this make Camilla? Is she queen, or is she having some other title?
Queen consort. Queen consort.
Queen consort. Oh.
Oh, was there news? Was there news?
Yeah, she passed away. Queen Elizabeth passed away.
Really?
Yeah.
Yes. I didn't get notice of it.
I just got an alert on my iPad as we were sitting there.
Yeah, it's less than 8 minutes ago. The BBC it out.
You're on the second day's call list, Kathy. Sorry. You're not on the first call.
Say again?
You're on the second call list. You didn't make the first call list.
Queen died.
You're in good company, Kathy. I didn't get noticed either.
Yeah.
No, I got it.
It just popped up.
I read away the Wall Street Journal. I knew that I had heard the news coming into work. Oh.
You know me, Kathy, I try and bring up a subject matter while we're waiting, and this was the one I brought up.
Well, I'll tell you, Karen and I didn't have a chance to even look at anything like that, and Crystal said, but we did get a plan. So I think, Dave, we're all set. I don't know if that was probably all part of our live streaming. We're people first. That's very sad news. Very sad news. But what a life lived, right?
Mm-hmm.
Okay. We'll just pause for a second. See if everyone is here. Okay. So we did have a chance to think about our agenda. I first need to, because we're meeting virtually, Gaming Commission's reconvening, and we're going to go through a roll call. Commissioner O'Brien,
I am here.
Commissioner Hill,
Present.
Commissioner Skinner,
I'm here.
and Commissioner Jordan Maynard.
I'm here, Madam Chair.
Thank you. And notably, Commissioner Maynard had a long time vacation planned, beautiful West, and he has donated as a longtime public servant today's time. So we thank your spouse first, and we thank you second. So
Happy to do it.
we'll keep on moving along. All right, so and just in recognition that we did all receive the sad news of the passing of England's longtime monarch, Queen Elizabeth, and it is a mark in history. So thank you for updating me on that news. We'll move on then to where we were. We have decided that it probably makes sense on Thursday, September 15th. One topic we have not addressed really publicly, but we have certainly been reviewing it, is the provisions regarding temporary licensure. As any piece of legislation, there's always complexities attached to various parts, and there are complexities that will arise in that discussion. We will have, so we thought it would make sense to really focus on temporary licensure next Thursday. In order, the House rules are really combined as part of the temporary licensure process. So it seems to me, Judy, that probably be most efficient for particularly Commissioner Skinner and Commissioner O'Brien, to bring any further edits to you. Of course, Commissioner Hill and Commissioner Maynard will do the same on the House Rule Reg. And then you could revisit your portion of the House rules, and we could combine that into next Thursday's meeting.
Certainly.
How does that feel to you? I want to make sure that everybody understands that, and particularly Judy, the work that's being done right now is real-time work. And Judy, I appreciate your being able to be so flexible to incorporate all thoughts and thinking. So thank you. And then
My pleasure.
And then we'll work on that piece. Todd, does that feel good to you on the House rules for next Thursday?
Absolutely. I think we will definitely make that.
Okay, and so then that automatically turns to the next subsection 3B. So we will ask Derek to go forward, but I wanted to also excuse Director Lilios. I know that there was a little bit of a change anyway with respect to your presentation, so I knew you wanted to pivot. We'll work with you to figure out how best to incorporate your ask into our future meetings. And then we'll go to Director Wells on the important, well, they're all important discussions on criteria for the application process under F and G. And then we'll turn it to our R&G discussions, and we are hoping that's around 3:30. And I know that Crystal's reaching out to Dr. Wolford and Dr. Williams. Okay. So thank you, and thank you again to the legal team and all of its good work, and particularly Judy. We really appreciate it. All right. And then I see John Scully has joined us. Thank you. Good afternoon, Derek, and thank you for your helpful input earlier.
Good afternoon, Madam Chair and Commissioners. Thank you for having me. I'm going to apologize ahead of time if I go into a coughing fit. I have a sinus infection or something going on that I'm on antibiotics, and it's usually short-lived. So maybe I'll just put like my presentation up on the screen and read along. No, I'm joking.
Derek, thank you for being here when you're not feeling well. It
Absolutely.
doesn't surprise me that you did that, so thank you.
Thank you. I'm joined by Douglas O'Donnell and John Scully today, and I want to give a lot of credit to Commissioner Skinner for the drafting of this memo, simplifying it down so that we don't get caught in the weeds while trying to make a very important vote here today. We're here to request an initial budget for sports wagering. Chapter 173 of the Acts of 2022, an act regulating sports wagering, created Mass General Law, Chapter 23. This statute enables the commission to implement and regulate sports wagering. No startup funds via a direct appropriation were provided in this. So we're here today to look for statutorily provided fees and assessments to fund the startup of the agency. In order to do this, in the future, we plan to come before you and draft for the commission's review and promulgation regulations as mentioned in the beginning of your packet. Don't want to get caught up on those because that's not the main point of this, but it's just part of the process for going forward. We feel that by drafting these regulations, we'll be able to get funds into the Sports Wagering Control Fund for both the initial suitability reviews as well as the administrative and regulatory responsibilities of establishing the sports regulating industry in the Commonwealth. Section 15 of Chapter 23N creates the Sports Wagering Control Fund. The Sports Wagering Control Fund is the vehicle the Commission would utilize to carry out its regulatory oversight and activities related to sports wagering. The Commission is the trustee of the fund. Initial funding for the Sports Wagering Control Fund will rely mainly on application fees and background investigation costs. In addition, we will be looking to create an overhead rate, which will be coming forward in a future regulation to assess to the direct application and suitability review costs. Once the commission is awarded category 1, 2, and 3 licenses, developing an annual sports wagering budget will be a very straightforward process, utilizing an assessment tool very similar to how we developed the budget for our gaming control fund. Now that we've provided a general overview, and it is a general overview, so I don't want to glaze over things, but we will come forward with more details in the future of how we'd fund both the investigative as well as the regulatory startup costs. I'll get into the point of the actual item. We're requesting an approximate $2.2 million preliminary budget for the Sports Wagering Control Fund. I want to emphasize that this will be an iterative process and will change as the commission continues to make decisions, review and authorize regulations, and start building a timeline for the implementation of this chapter. Our preliminary request is for 12 FTEs, 6 contract civilian investigators, and legal and financial consultants. The majority of these costs are dealing with the suitability reviews and investigations. The costs that are not directly related to the suitability or investigative costs, we would fund through an overhead rate applied to all direct investigatory costs. At this point, I'll pause for any questions or comments. I do want to point out again, I want to thank Nikisha, Commissioner Skinner, for really helping us to get out of the weeds on this and bring it back up to what the actual request was.
Commissioner Skinner, do you want to comment?
I thank you, Derek. But I really can't take all the credit. As always, you and the rest of the finance team do a phenomenal job communicating exactly what you need from this commission. I also want to make the other commissioners aware that the financial overview that Derek spoke about earlier, as they relate to the regulations, that will come before us at a later time. So we haven't completely gotten away from the original form of the memo. You'll see that at another meeting. I also want to say that the staffing request is not absolute. Some of the hires may not be realized depending on the various decisions that the commission makes. For instance, around vendor licensing, there may not be a need to have the additional 2 licensed specialists or the additional 2 legal counsel. Again, it's a fluid request. What Karen and the team are seeking is, the discretion really to utilize the initial budget funds in accordance with developments as we move forward. Is that fair, Derek and Karen?
That's completely fair and spot on. And that's why I tried to emphasize it's going to be iterative. And as the commission makes decisions, we'll continue to come back to you and give you updates on what we think we need to do. I mean, a hiring process, as the HR team will tell you, takes a while. So even if we have a position posted and the commission makes a decision, we can always pull down that posting. The contract civilian investigators are a little quicker process, and that's in the outside CPA consultants. John already has a posting up with the language in that we may not do this depending on what the commission decides to do going forward. But those will be quicker timelines once the commission starts to get regulations in place for the actual application, the fees for applications, and suitability reviews. And those can be executed much quicker.
Questions for Derek and Commissioner Skinner?
Maybe it's a comment more than a question. I saw this number and I was a little concerned that it was quite high. The request of almost $2 million, not really knowing exactly what we needed for FTEs and some of the other issues that were brought before us. I guess I need to be convinced a little more why it's 2.1 and really not half that, because you can come back to us at any time. And I know you're going to say to me probably, if we have the money in the bank, we can do these things, very, very quickly. And of course, that's something that I would support. But it just seems like it's an eye-popping number to me. So I think we just need to discuss it a little bit more, and maybe I can hear from my fellow commissioners why we would do that much today when they could come back to us at any point and ask for an increase with what they truly need at some point in the near future.
Anyone want to respond to Commissioner Hill, Commissioner Skinner?
Oh, I'm happy to defer to Executive Director Wells. I think that this is what the team perceives as the necessary resources to move forward on this initial basis. Again, as decisions are made, I mentioned vendor licensing. If there's a decision by the commission not to license vendors, that cuts out a lot of the resource necessity right there. But I'll let Karen and Derek speak to your question in greater detail.
I'll start out, Derek, if you could back me up afterwards on any details that you have. Commissioner Hill, the request actually, I would suggest, is actually sort of the starting point. We may need more than this, but this is sort of our best estimate of what we would need. And as Commissioner Skinner and CFO Lennon noted, we don't have to make all these hires depending on the positions. We could just go ahead. But if you break it down as it's identified in the memo, the commission already authorized the chief of the sports wagering division. The only ask is that there be 2 support personnel at this point to support that. And given the number of applicants that we have and the potential number of licensees, because I know if sports wagering, goes forward as we see it through the statute, we could go from having 3 licensees to having an additional, I think it is 16 licensees. Once all the final licenses are granted, that doesn't even include what we'd be doing or the situation with temporary licenses. So the amount of contact that we have to have with licensees is going to exponentially grow. So that part of that position, the chief of the sports wagering division, is the interface with all those licensees. So to have some support there is definitely important. The IEB, the 4 FTEs, 2 financial investigators, and 2 enforcement counsel. Given the number of licensees we're going to have, the background investigations and the financial component, part of the analysis on the suitability of these applicants is to ensure not only their financial integrity, but also their stability. They're going to potentially be owing a lot of money to the people of the Commonwealth. So their financial stability is critically important to make sure that there are consumer protections in place. At the licensing division, as Commissioner Skinner pointed out, we did put in for 2 FTEs. If we do license if we go through the licensing process and the suitability process for all of these applicants, I think, we had some number of, I think around 50 of the notice of intent. The amount of forms that will come in, you have to have an increase in the licensing division to process those forms. Now, if we're cutting that down because we're not licensing vendors, then that may reduce the need for the work in licensing, but I think 2 licensing specialists may actually be conservative. And at this point, we're only asking for 2 FTEs, a sports wagering systems analyst and information security and privacy analyst for the IT department. There is more of an ask in the IT department that we expect to be coming in front of you later. So given the technical aspects of the monitoring of the online platforms, I think those are more than justified. And then the other contract services, the civilian investigators, the CPA consultants, legal, and then the incidentals, those really are the short-term asks because of the suitability investigations and then legal for all the regulations that need to be stood up. So that's why. I know it seems like a big number. I remember when we were doing the startup for investigations back when we stood up casino licensing. One investigation, we had consultants come in, one investigation for one licensee. There were some of them that cost $2 million each just for one investigation. So we're trying to be a little more fiscally responsible here by doing it in-house and figuring out the ways in which we can leverage our contacts against civilian investigators and that kind of thing. And then the other thing is that we will be prorating it. Derek can explain this a little bit more, but it's not like each of them is going to get a $2 million bill. I think if you divide it by, the 19 or whatever number we end up having, I think the share was like $115K per licensee per year once all of them are up and running, which given the amount of volume of increase in work does not seem unreasonable to me personally, but we'll defer to however the commission wants to handle this and operate accordingly.
That was very helpful. Thank you.
Commissioner Hill, just to follow up on the regulation.
Wait a second. Hold on. I've got a lot of people leaning in right now. Who goes next?
I would like to I want to just add on to what Karen mentioned, particularly around the regulations piece. We've got over 200 that we anticipate coming before the commission. If today's discussion around, the independent certification and the House rules is any indication, there's going to be some hefty, significant discussion. And I think, that's where the legal resources will come into play, keeping track of the emergency regulation process, if that's the way it goes, or the regular process, tracking the deadlines. Legal's going to need some assistance there in particular.
Okay, and I think I saw next Director Lilios and then Commissioner Maynard. Okay, Director Lilios?
Yeah. Hi, good afternoon. And Derek may be well poised to address this, but I did want to address that there may be the conception that for any one operator license, we're talking about one operator license, but 23N requires us to identify any individuals or entities that have certain ownership interests or control abilities in those companies. So any one operator license is comprised of license applications from multiple entities and multiple individuals. So that's part of where our numbers come from.
Yeah, and we did scrub this with both the licensing as well as the IAB division for just entities for the gaming side. There are usually about 10 affiliated entities with the primary parent company, as well as 15 individuals that need to be reviewed and have deep dives onto. For vendors, if we end up doing the vendors, the average would be 2 affiliated entities per vendor and 4 to 5 deep dives on individuals. So that starts adding up when you have a notice of intent of over 40 of over 40 companies. Now, whether all 40 come through or not, we don't know, right? Once a $200,000 fee comes down, that's a whole nother discussion. But say you get half of those, we'd have $4 million anticipated without doing any additional billings. And as Karen said, when we did this the first time through, the average for a suitability and then a review of the application was over $1 million. Now that was all outside costs, and we think we've gotten much better at this. When we look at a vendor now, we're closer to 20, 25,000. So we hope we're much better at this for the prime entities and their affiliates at this point. But and the other point that I want to say is that $2 million of those positions, that's not the full year cost. A lot of those positions are scheduled, some of them are right away as soon as possible, and others aren't until like a revenue accountant isn't until December or January, when we could hopefully bring someone in if we have temporary licenses up and running and we have to collect revenue. So we can pare it down. We could go through that exercise. Now, if you take a look at the CPA consultant costs and the legal consultant costs, I'm sure there are other people that say that's way too low. And those are just estimates at this point. So by giving us a bigger budget of the 2.2 million, which is far less than any of the application fees that we even would likely see come in from the onset, it gives some flexibility to come forward to you and say, we'd like to shift money from this area to here versus increasing it. So that was part of the thought process. But we can pare it down if that's what the commission wants to do. There is room in there to do that.
I'd like to turn to Commissioner Maynard then. Thanks.
So thank you, Derek. And actually, I'm one of the ones that took a look at the initial numbers and said, is this enough, Derek? And, I do believe, Commissioner Hill, that we do have to be good stewards of public money. And I think it sounds like there's an opportunity for us to look at this on the back end if the needs change. But I would rather build the ark and the flood not come. And so, I'm one of these that look at this and say, let's make sure that we have the resources on the ground. Let's make sure that we're ready for this. Let's make sure we can execute. And then if we have to adjust on the back end, I think that's something that all of us are willing to do to be good stewards of public dollars.
Further questions or comments? I love that we had instant chatter all at once. Commissioner O'Brien.
Just to say that I can respect everyone's views. You see the numbers for the first time and they can be eye-popping. I wasn't here back when the casinos launched. I was in the AG's office, but I do remember the legislature appropriating monies to get everything up and running. We're not in that situation right now. I think they've done a tremendous job working with what they have to get us going. I don't think I fell where Commissioner Maynard did. I was somewhere in between Commissioner Hill and Commissioner Maynard, but I sort of went through the numbers and feel comfortable with the ask that's in front of us right now.
So thank you, everyone, for your input. Is there any other further discussion? I'm very comfortable with this, Derek. Thank you, and Commissioner Skinner and Karen and team. You do need I lost the motion page, but we do want to take action on this today, right? Sorry.
Yes, Madam Chair, and I'm happy to move.
Yeah, thank you, Commissioner.
I did make some adjustments to the motion. Hopefully you all will indulge. It's just a slight tweak. I move that the commission authorize an initial budget of $2,193,429.86 for sports wagering operations, including the hiring of additional positions and consultant spending as necessary, as included in the packet and discussed here today.
I second that motion as amended.
I think you don't have to say as amended because it was just moved. This is just draft language for us.
Exactly.
Yep. Okay. Anything further? Any further discussion? So as presented by Commissioner Skinner and seconded by Commissioner Maynard. Commissioner O'Brien.
Aye.
Commissioner Hill.
Aye.
Commissioner Skinner.
Aye.
Commissioner Maynard.
Aye.
And I vote yes. So 5-0. Great, thank you. And I'm really hoping that that you get all the help you need, because you not only have been doing your full-time jobs, but you have a whole lot more work on your plates. And for that, we extend our appreciation, and I'm hoping you get just the right help. We'll move on to, again, Director Lilios, thank you for being patient as we shift to Director Wells. Item 3F.
So this item, Madam Chair, members of the commission, is critically important as we go forward. We have on the agenda today a discussion for commission input into what is the criteria for evaluation of the final operator licenses. So I'm not talking today about temporary licensure. This is the criteria and the process for awarding the final operator license. And as you know from the statute, that includes Category 1, Category 2, and Category 3 licenses. So what the team here has done, and many thanks to particularly, Flynn and Derek, who really helped me sort of pare this down. The recommendation is that the commission discuss these proposed criteria, and that we can take the input from the commissioners and then go back and work on some kind of draft application for your consideration. This is going to be really important because, as you know, we have numerous applicants potentially for these operator licenses. So evaluation criteria and doing it in a way that's fair and transparent is going to be really important. There's going to be a lot of scrutiny over the process, and it's important that we all come together with an understanding of what's really important to you as the commission, because you will be making the decision about who gets these licenses. So the recommendation here is that similar to the process for casinos, there be two parts to the application and two parts to the evaluation. One is required by 23N Section CD, and that's the suitability portion. So that's the investigation, that the application would be information that is required by the Investigations and Enforcement Bureau to do a real suitability deep dive into these applicants to ensure integrity and to protect the citizens of the Commonwealth that are sports wagering. So the process that we're recommending is very similar on that piece to what we've done before, where the applicant would undergo a scoping process, which identifies those qualifiers, which Director Lilios just described. So as she said, it's not as if company XYZ just comes in and they just investigate company XYZ. They're investigating company XYZ, the entities that are subsidiaries or parent companies, and then numerous individuals, of personal evaluation of individual suitability for members of the board of directors, the CEO, CFO, people that have ownership and control over the operation. So the recommendation is that the applicants for licensure submit a business entity disclosure form, which is what we've used and many jurisdictions use in the US for entity investigations in the casino business. As you may know from the history of gaming, is that a while back, it used to be that entities that were applying for licensure in multiple jurisdictions had different forms for every different jurisdiction they were applying to. So there was an ask by the industry to regulators, can you all come up with one type of form so we don't have to be submitting different forms every time we go for licensure and go for relicensure. So the recommendation is that we use the business entity disclosure form, which was created as a result of that initiative, and the multi-jurisdictional personal history disclosure form, which was part of that initiative for individual qualifiers. We're also recommending the Massachusetts supplemental form, which provides additional information in Massachusetts. We want to recognize that certain entities and individuals associated with an applicant have already been found suitable by the commission. And I think there's support in that in 23N, section 6C, which talks about the commission using information obtained from the applicant through their 23K suitability investigation. So we don't think that it's required that if you've already been through suitability and already been found suitable, that you'd have to apply all over again and submit those forms. But that we also recommend that the IEB be given the authority to request any supplemental information that they deem appropriate. So that's sort of the thinking on the suitability investigation and what we'd be looking for. The second piece of the evaluation is the evaluation of the proposal itself to be a sports wagering operator. So this is where we'd really like some additional commission input and see where you are in this, because we've never had the opportunity to discuss this with you all together. So the suggestion is that there be certain criteria. You can have as many, oh, Kathy, did you have a question?
I just wondered, before you got into the evaluation, should we just pause for any questions about?
Okay.
Do you think that's okay?
Yeah.
Because I do hear you. I know you really want the input on the evaluation, but are there any questions or input on what the framework Karen has presented? Perfect.
So on the proposal evaluation, as you know, in the first commission meeting we had after the legislation was passed, which was that first week, we submitted a compilation of potential information that could be in a sports wagering application. Thank you to Jacqueline Neck for putting that all together. She did a lot of research in other jurisdictions. So that was sort of a broad brush approach, just so you are educated on what other jurisdictions look at when they're looking at sports wagering and giving out licenses. So what we did internally is we had a group meeting and discussed, okay, if we were going to make recommendations to the commission about, how to do this, we did go back to the fact that the commission, when they did the operator licenses for the casinos, that they sort of had 5 different buckets of criteria, and that seemed a good way to organize what they were looking at, and it worked well in the evaluation process, because they would evaluate specific criteria individually. So we put together some suggestions for the commission of if you wanted to mirror that approach, what the criteria would look like. So I've got some recommendations, but the commission is free to discard the recommendations, come up with other criteria, modify certain things within a criteria, or just discard 1 or 2 and add another 1 or 2, or however you'd like to do it. But we had to start somewhere. So we thought it may be helpful to you to have at least something in writing and something to work off of. So the suggestions are that one of the first thing we look at, aside from the suitability investigation, which is kind of a yes or no. You're either suitable or you're not suitable. And if you're not suitable, you're out. You cannot operate in the Commonwealth if you're an unsuitable company. But what might be helpful to the commission is that during the process of that suitability investigation, there may be information that would be helpful to the commission in ranking different proposals. And one of the areas I'd suggest might be helpful is we could look at the applicant's history of compliance with regulators in other jurisdictions, or their litigation history, or some other areas where you might be able to differentiate between applicants who are suitable, but they may have differing levels of compliance with their regulators, or some evidence one way or the other of initiatives on corporate integrity. You may have a company that just has some positive, outstanding things that they do for corporate governance and may want to value that in the evaluation, or you may have an applicant that is somewhat problematic in that area, and although suitable, you may want to weigh that as part of your criteria. So that's number one. The second item is the sports wagering experience and expertise. You may want to compare applicants or even be, I want to be careful that some of these applicants is going to be a competitive process. And some of these applicants, for example, category 1, category 2, and the category 3s that are tied to the casinos or the simulcast facilities won't necessarily be competing against each other for a certain license. But similar to what we did in Region B with MGM, there's still an evaluation process on the proposal to see, do you want to even give them a license? So this criteria would work for both of those facets of the evaluations. So just bear that in mind as you're looking at this. So the sports wagering experience and expertise, that may be, what kind of offerings do they have to the customer? And what kind of experience does the customer have with their product? What is their demonstrated successful experience in other jurisdictions? What is their expertise in particular aspects of sports wagering operations? You may have an entity that has a particular area of expertise that you highly value. You may want to score that highly. Overall competence as an operator in other jurisdictions, or an ability to successfully innovate. These are just suggestions on questions that we could ask for evaluation criteria. The third area is economic impact to the Commonwealth. This is something that we looked at with the casinos and think was very effective and really helpful for the commission in making the decision. So areas where you may want to inquire in that area are how many jobs is this going to provide for Massachusetts residents? What is the projected revenue of a particular operation? What is their local construction spend? How are local businesses in the construction field going to benefit? What is their diversity hiring and spend? And what's their local vendor spend? We have placed a great deal of value on diversity hiring and spend in our casino operations. It probably makes sense to continue that with our sports wagering licensees. And you may come up with some other criteria, but that's an area that we strongly recommend you consider the impact to the Commonwealth. And then the fifth area is responsible gaming. And we would suggest that the applicant's commitment to responsible gaming and their ability to implement operations that will protect the consumer and protect the most vulnerable should potentially be a criteria for you to consider. We could indicate in the application that they must demonstrate how they successfully exclude self-identified problem gamblers, or what are their mechanisms for putting that in place? What's their approach to monitoring patron spend? Have them describe to you what their responsible gaming initiatives are, and also their advertising plans. I know advertising has been quite the topic of conversation in the sports wagering industry, so that would be an area where you could consider advertising. And then the final area is technology. As I mentioned earlier, technology is a critical component to online gaming and online sports wagering. So it would be helpful, I would suggest, that including inquiries regarding technical competence from the applicants would be helpful for determining licensure issuance. If the company does not have the tech capabilities to run a successful operation, we are going to have some issues in the Commonwealth. So addressing that on the front end through the application process, I suggest would be helpful. So that could include demonstrated reliability of their platform. What are their geofencing capabilities or plans for geofencing? What is their know your customer technology? What is their accuracy of payouts? What's their history? So those are just the examples that we've put together for these different criteria. So at this point, just hoping there's a robust discussion on what the commission thinks of these suggestions and how would you like us to go forward so that we can produce something for you which will help you in evaluating who gets licenses in the Commonwealth of Massachusetts for sports wagering. So I'm happy to answer any questions, and I do have members of the team that worked on all this available, so we can have an ability to answer any questions you may have.
Excellent outline and presentation, Karen. Okay, commissioners, ideas or thoughts with respect to Karen's presentation, I see Commissioner O'Brien's leaning in.
Yeah, thank you, Karen, for this. Really, the biggest question or comment that I have is it's in here already, but I just want to make sure that however it's written up, it's clear to the applicants that you've got the section on sports wagering experience expertise, and then you have the technical component. But just to make sure that when the applicant's filling out the sports wagering experience expertise, that it's not restricted to the retail experience, that they specify, so that we're not getting a vendor that, you know, maybe is fine in retail, but not, maybe they don't have that level of success in their mobile experience yet. And so not lumping it all together, but also making sure it doesn't get lost when just asking about their tech experience, their tech expertise.
Yeah, so I think, you know, to your point, we're planning on using one application for category 1, category, and category 3. So the category 1 and 2, that's for retail operations, even though they have a connected online operation. But the connected online operator has to be licensed as a category 3. So they'll have to fill out the application as well. So it may be, you know, what I'm thinking in my head is there may be questions in there that are relevant to retail, but they could put NA if they're not applicable to the category 3 applicants, and the reverse. There may be something that's, you know, for example, the geofencing issues. That's going to be very relevant to mobile operators, but not so much, obviously, to the category 1 and 2.
Right, but if they have the experience, I'd still want to know about it in terms of, I don't want to find somebody who's got a bad rap sheet, so to speak, on their mobile experience, or maybe their retail, but not, you know, I want to get the whole picture, even if they're only putting in for a category 3. Most of these, I realize a lot of category 3s are only mobile, but not everybody.
Yeah, we may find out more as we get to know who these applicants are and figure out how this works. But I think you're correct in that more is better, and the breadth of information we can get to the commissioners is the most helpful.
Good. Right. Well, particularly as to 3, where they're discretionary as opposed to mandatory for the 3. I think it's really critical to get as much information as we can.
Good. Other input.
If we could just go back. Yep, thank you, Madam Chair. And to talk about the economic impact to the Commonwealth. And these are absolute 5 of the bullet points you put up. I hope we can include them, and I think everybody would probably agree. What I would also like to see, and I'm not sure how we would word it, being that they would be a mobile app instead of a brick and mortar or retail operation. But I love what I see when we get our quarterly updates regarding community engagement. Okay. And even though these companies are you know, running off your phones or the computer, they're going to be doing business here. And I would love for somehow to know how they might be community partners in regards to you know, food banks and all the good things that we've heard from our retail operators, what they might, you know, propose. I'd like to see that as part of the application.
Yeah, absolutely.
Commissioner Hill, if I could just add to that, when you said it's different for mobile, we often will say that a license in this gaming world is a peerless privilege. And so if they have a license in Massachusetts, they really are our peer. And so they can engage in the community. I think that's a wonderful idea. All right. Great. Another idea? Commissioner Skinner, are you moving or not yet?
I wasn't, but you know, I'm good to stand on the recommendation that comes from Karen and the team, while reserving the right to, you know, comment and give suggestions along the way as they get started on a draft. I do have a question. The evaluation criteria that you've laid out, is that for the permanent licenses?
Yes. Yes.
Not temporary, and I know we've got that discussion scheduled for the 15th. Is there going to be recommendations on for evaluation criteria on the temporary licensure side of it before the 15th?
We're going to have to discuss next week. So
Okay.
there's a threshold question about the temporary licensure, which needs to be answered first.
Yeah.
And then we will give you your options based on the answering of that threshold question.
Thank you. I think this is great work in terms of what you've put forward thus far.
Okay, Commissioner Maynard, do you have input on the criterion? People can be thinking about, this is the chance to have Karen hear our thoughts. Commissioner Maynard.
Karen and I had an opportunity to talk about this when it was in draft form, and I think this is perfect. I, of course, can see where we may need to get additional information as we go, but this is a really great starting point.
I agree. I think it's a great starting point, and it made me really think about a few things, Karen, and Derek. I know that when we worked on an earlier selection process, it was a very meaningful distinction in terms of a very competitive selection process, and that's just the issue of diversity, equity, and inclusion as perhaps its own separate criterion. And so I might want to elevate that. I love the idea, of course, of diverse hiring and spend, and I'd also include the supply chain, which is actually part of sort of procurement in Massachusetts anyway. But I'd also challenge them to perhaps consider an MBE, a minority-owned business, as a joint partner or joint venture. Bring that partnership to the table, and I think elevating this. We can talk about how to do that well, but I think elevating that. Remember, this is not necessarily, all of the suggestions I'm making aren't necessarily musts or they're shoulds. And when I think about the procurement world, but I wouldn't mind separating out that topic altogether and we could build it out. On the technology, I'm not even sure if it's supposed to be in technology, but I don't know better. I've learned a little bit more about kiosks, and there are compliance issues with kiosks, or challenges, I should say. And I see, thank you, Katrina, for chiming in. So I wonder if we could learn a little bit more about their plans for, this is on the retail side, right? Only. So that challenge, and Katrina, maybe, I don't know if you want to chime in. I don't know how we frame it, but it would be almost kiosk compliance history is what I was thinking.
And you're absolutely right, Madam Chair. So the kiosks would fall under the devices. We used the term earlier as devices, platform systems. So that would fall under the technology realm. I think what you're referring to is a particular area where there was a specific issue with a specific brand of kiosks. And so that is something we would work with if allowed, the certified independent test labs to ensure that those specific kiosks are run through the gambit of tests and compliance and auditing. And that's one of the benefits of working with those specific test labs and making sure some of the, and this is why, when working with Executive Director Wells on the technology component of the criteria, I voiced my opinion of the importance of including this, because to exactly this point, the certified independent test labs only do it in that instance. They substantiate that it's able to do what it does, its compliance, its performance, et cetera. But it is up to the properties and the manufacturers to ensure that these specific type of devices or equipment are kept up to par with any security patches or updates that are needed. And that's where the competency comes in from their adherence to compliance and industry standards. So that is an iterative process that the operators and the manufacturers typically work with the independent test labs. And there's a lot of efforts that go into that. And so that's where that, again, to reiterate, the competency of the entity really comes into play to ensure their compliance and their commitment to ensuring that they're kept up with technological and security trends and changes, especially in the market that we're in today.
So that's part A, and thank you, because I could never have articulated it that way. And this is Katrina still only like at her 88% recovery here. We kind of like her at 88%. That was really, really helpful. In terms of part B, so the compliance on the integrity of the machine, as Katrina mentioned. Then there's also the compliance issues of that you don't have the same control over knowing your client or customer KYC through the use of kiosks as you get even at the sports book or obviously in the sports on a mobile device. And we touched on this in our roundtable, and I've learned a little bit more, is that you know, you don't really, I don't think you have to swipe your ID or anything to get in, to put into an account number. And I don't know if that's up-to-date information, if there are kiosks in the future that are going to be better, but I just wondered if we should be evaluating, and it might be at least to learn some kiosk history for those who are going to be doing retail. On technology too, and Katrina, I turn to you. Would it be helpful to understand their history of data use, and like for instance, using official data, you know, because we do have that tier 1, tier 2 distinction in our in 23N. So data used and then data security, anything like that. Is that correct? Or did I miss that? Is that in here somewhere?
Well, so I believe we came up with some abbreviated examples. It is not a comprehensive list. Right. All the things that we will be looking at for competency with criteria. That would be rolled in with the assessment of their information security plans as well. So yes, that is something we have, you know, checked off as an item that we would include as part of the process.
Yeah, I think it might be helpful for us to know who has experience, you know, with respect to using the official data use. Then up to responsible gaming, and I know this is again a skeletal list, but if advertising plans, I guess I'd love for them to talk about youth and vulnerable populations. And then I also think probably, is this the place where we talk about promo, the whole issue that came up? Do we ask them about how they're planning on? Is that too precise?
Yeah, I'm not sure that would be in the application. That would probably be for the commission direction before they would launch.
Okay. All right. And then two final things, and then a process question for once we get through the categories. We have a report from Treasurer Goldberg. We are including here issues around diversity, hiring, and spend, which I think we all really feel is so critical, and it came in through 23K, but we don't really, do we have direction under 23N precisely on those issues? Because I'm wondering if we should be talking about anything that they would be willing to do for the lottery mitigation impact. Can we put that as if we need to speak with legal about that?
So, yeah, why don't we coordinate with legal about any requirements specifically in 23N? And I'm not sure how you're connecting DEI and the lottery bill.
No, I was just wondering in terms of topics that are outside the statute, you know, are they comparable? I don't know. And then finally, we haven't talked about esports, and I know.
You just want to see your head explode today?
I don't really know what we're going to do about esports. Can we put it in the parking lot and not forget it? Or do we put, you know, I just don't know if that's a separate application process or not. Right? I know I've heard all of different reactions, and many of which were consistent with your expressions just now. All right. And then my final thing is a little bit on as I said, it's more on process. So I don't know if anybody has any more input on the buckets.
The only one I was going to add, and I don't know where you put it in or even if you can, but given the research that we like to do and some that we've been tasked with, whether they can speak to any experience they have dealing with researchers, with scrubbing data, their capacity to do it, I think would be helpful to know.
So my process question, and maybe we're going to get to it, but I first off have to thank Jacqueline for a ton, but for this precise assignment, it's such an excellent job. And she does put in, I know it's just a draft and an example or a sample drafting sheet. This is where I think it's going to be a huge challenge to get the scorecard right. If we end up with a large pool that we have to bring down to 0 to 7, right? So I've done enough procurements to know I am no expert. And I also know there's mathematics involved in how you do it and make sure it's fair and equitable. But my thinking, of course, is that we have to have enough leeway to be able to be fair, equitable, and precise enough to be able to distinguish. And so I'm very interested in the criteria, and I'm also very interested in how will we actually evaluate these once this comes in front of us. So I don't know if there are any thoughts for that today. And if you're planning on that to come before us, Karen, in more of a nuanced fashion.
That's really helpful, Madam Chair, because that is a question for the commission ultimately. How do you want to make these decisions? So when we did the casinos, it's not as if there was a point scoring system, but you could do a point scoring system, and that may be helpful, particularly where we're in a situation that's very different from the casino licensees where we've got a lot. And so to your point, differentiating within a large group is very difficult. And we really do want to be fair and transparent and as objective as possible. So I think we can look at some models, but if any of the commissioners have any insight into how you would like to evaluate or how you would like to make your decisions, it would be helpful for me to hear that now so I can sort of get going and do some research on best practices for whatever approach you want to end up taking.
I don't know if there are other jurisdictions that would be making a similar kind of reduction in their final application process, but that might be helpful too. But anyway, I'm wrestling with that in my mind. I think we've got the criteria buckets are really well defined. So next steps, but it was on my mind anyway, and then Jacqueline's good sample made me realize that I could bring it up today because it did include that scorecard. So, commissioners, what do you think? Is there anything further you want from Karen on this matter? I'm seeing no's. All set? Okay.
Excellent job, Karen. Excellent.
Thank you to my team because I give them all the credit.
Well, that's definitely teamwork. All right. Then we're turning then to discussion of process for approval for use of sports wagering systems and devices. Here we are.
Yeah, so I am going to ask our CIO to help me out here because she is the expert here. But the bottom line is we're looking for some commission direction here, not necessarily, obviously, we don't have a reg in front of you now. We're just looking for some that preliminary direction. We would go back and write regulations and then bring them forward to you for final approval. But the bottom line is we're looking for some direction on how we're going to approach technical testing. So Katrina already gave you some information about that, but in this context, we had a discussion several months ago before sports wagering was passed about this issue. I think the staff's position now, because we're dealing with it post implementation of the statute, is that we're sort of adjusting our recommendation.
Karen?
Yes.
Madam Chair, I'm sorry for the interruption. Do we not need to take a vote on the evaluation criteria?
No, I just needed some direction. We reserved that in case there was an issue.
Okay.
Oh, okay. Yes.
Thank you.
Okay. So the best practices for regulation of particularly online wagering is to make sure that everything works properly and is in compliance with regulations and laws. There are different approaches we can take to making sure that that happens. One is requiring the licensees to contract with the certified independent testing lab to provide testing and then provide us with the results. We then have the option to audit those results to ensure compliance, competency, and accuracy. The other issue is to allow them to initially submit. And then the other option is to allow them to initially submit certification that their platform, equipment, and software is in compliance with another jurisdiction's technical standards, and then they submit the results of technical testing to Massachusetts standards as identified in what I first described. So the first one would be they contract with a certified independent testing lab. That independent testing lab certifies that their platform is in compliance with all Massachusetts laws and regulations. Second option is they give us a letter they already have because they were tested in another jurisdiction, and we let them go forward for, say, 30 days, or Katrina may be able to give you the standard operating procedure for that method. And then they have to test to Massachusetts standards within a period of time. This is something that came up at the roundtable. I believe North talked about it when you were speaking with the licensees. So those are the two options if we have the licensees contract. We could also theoretically hire personnel to conduct all the testing in-house at the MGC. There are jurisdictions that have a robust program to do that. I would recommend against that for the following reason. It's very hard to get IT personnel right now. And it's also going to take a long time to get personnel, get them trained, get them up to speed, and then do the testing. So for efficiency purposes, that's probably not the best move for Massachusetts right now. And then the other option is for us to contract with third-party vendors to conduct all the testing directly for us. So initially, we had thought that may be a good option if we were able to do the contract months ago. But given that we didn't do it months ago in the time frame, our recommendation is that we go ahead and recommend that we utilize the approach where they contract with an outside vendor, they submit their jurisdictional platform is in compliance with whatever regulations they have in place in another jurisdiction, and then they'd be required within the, say, 30 days to submit that they're in compliance with Massachusetts regulations. So that's sort of an overview. Katrina, did I miss anything there? Because I know that's a lot of technology stuff, and you're certainly more of an expert than I am.
No, Karen, you covered it pretty well. I do want to add a couple clarifying pieces for your consideration as well. There can be a vast difference on allowing an operator to launch in a timely fashion. So if we select to ensure that they are compliant with the Massachusetts standards and that they will contract with the independent certified testing labs that will do this testing against the Mass regs, which obviously needs to be drafted and promulgated and approved, that's obviously going to add a significant amount of timeline to the back end of that. The recommendation that we did propose was to begin with approach number 2, migrating to approach number 1 as we go from a temporary licensee to a fully licensed operator. And the reason for that is expediency to market. And there are a couple caveats that we did outline in those, but regardless of what option we choose, as an example, geofencing would have to be something we test for, whether we do it internally or externally. And so, we're really just looking for that guidance to help us move in a specific direction.
And my apologies, I failed to mention there is a theoretical fifth option of using a hybrid model where we do some of it in-house and contract some of it out. But for the same reasons that hiring staff would delay the process, we're not thinking that is particularly practical at this point.
So Katrina, I posed this question to Karen and I pose it to you in terms of option 2, which is that option to me is only as good as our trust in the other jurisdiction's technical standard requirements. So do we want to restrict it to any particular jurisdictions, which I know gets more complicated given our licensees, particularly the MGM, WIN that only operates in 2, or are there certain that we want to exclude?
So that's a really good point. So in our analysis, when we recommended one approach over the other, in our cons section, we would absolutely, and it would be my strong recommendation, that we do select jurisdictions that are very similar to Massachusetts, especially with our policies, our laws, et cetera, that we would most likely, have in our regulations. I think they would be the best jurisdictions to accept certifications from.
Okay. And then in terms of the thought of this being a temporary process, is this something, you talked about temp license versus regular, et cetera, and it seems to me this is a process that the process itself should become not necessary. So rather than linking to type, are we talking about a sunset provision in terms of the regs? Like, are we asking for this request such that it expires after a year, whatever it is? You know what I mean?
Referring to the out of Massachusetts GLI matter?
Correct.
Yeah, I think that's correct. Yeah.
Okay.
Yeah.
Just to number 1, right?
Right.
Yes.
Exactly.
No, it's number 2, to be able to refer to a different
2 to 1.
jurisdiction.
Right.
Right, but once we migrate to 1, option 2 would have a sunset and become not available anymore, right?
Yeah. And that's why we're talking about launch purposes and
Right.
option 2. It's not anything.
But I guess my preference in terms of going back and thinking about reg writing would be that it would be a sunset provision, not, an option that would key into a type of application or license, but would rather be a sunset provision keying into the launch of our regulation of sports wagering.
Yeah, so we could put, a 6-month sunset provision on that, something like that. I agree with
Right.
that.
Right.
Your audio is a little off, I think, and you might be standing, and so just the
I'm standing.
Oh, good for you.
Your speaker is just a little bit off.
Sure,
But, yeah, I think Commissioner O'Brien's point is for Todd and for regulation drafting is to make sure that we don't have to revisit it or anything. That it should have a sunset provision, right, Eileen?
Yeah.
That's a good point. Okay. Any other questions on this? We had thought about this earlier. And of course, you remember North Groundsville brought this up during the roundtable, this topic as to the benefits of being able to tie it to another jurisdiction. Katrina, did you say that you would end up prescribing a list of acceptable jurisdictions?
Yes.
And that would be in regulation itself?
Karen?
I guess you could defer to Todd and how we do it. We could put it straight in the regulation, or we could have the regulation refer to a policy or something like that. But I'll defer to legal on this one to do that.
I think there's some value in maybe having it in a side letter.
I think that's probably right. We can take a look at it. We'll start putting it together and see how it fleshes out. But I think we understand the direction that we'd like to go.
Appreciate it. Okay. And then I think the only question I have, I know, Katrina, is like during this time, do we have any auditing functions?
We would have some, it wouldn't be as extensive or comprehensive as when we migrate to option one. Again, option two was really to try to get, that window of, so for a simple example, I think this really speaks to North's question as well, allowing a device or a piece of equipment or a software or platform into the jurisdiction. Right now, they can't. Right now, they couldn't. We can't certify.
Short window of time.
Correct. And so that allows them to expedite their timeline for being able to launch, to move forward. So there will be, again, accepting the other jurisdictions, GLI or BMM letters that adheres to the standards we adopt off of the authorized list, plus our own internal compliance, again, goes back to that initial request earlier this morning, working with the certified independent test labs to be able to help substantiate some of that. It will take a burden off of the staff. Otherwise, we would have to hire quite a few folks in order to do that internally. So it really does have a domino effect, both ways in some of these proposals today.
So I would just note, if for any reason it doesn't sound like it's a practical concern, that number two, where we're starting, it goes into an extended period of time that we have some audit function. Before it's just in one, but it sounds as though it really is a compressed time period.
It is, and again, we would have some audit functions. Exactly what that looks like right now, I'm not sure until we start, digging into the standards.
Okay, great, thank you. Any other questions? So you don't need a vote because there's a next.
I guess my question is there consensus that we should draft a regulation that goes with option two and would include a sunset provision? Is that what? That's what I'm hearing. I just want to make sure I have some consensus.
We could do a vote on that so that you could move ahead for a regulation, or is it, or do we have a consensus? I mean,
If it's a consensus you're looking for, I'm okay with moving forward.
Yeah.
Yep.
Then we can get into the details with the draft reg.
okay.
Yep.
Commissioner Maynard, you're all set as well, I see, nodding
I'm
your
all
head.
set. Yep.
Thank you all so much.
Okay. All right, Carrie, are you all set then?
I am, thank you.
All right, so we're now turning to our responsible gaming portion, research and responsible gaming portion. Director Vandal. Good afternoon.
Madam Chair, sorry, can I ask for just a 5-minute break before we move into the next?
Okay. No, I'm teasing. Of course, why don't we come back at 3:05? And then Mark, that will give you 25 minutes. I think Dr. Goldberg is coming on around 3:30. If you're done earlier, I'm sure she's tuning in. Okay, we'll take a little bit of a break. 3:05, thank you.
I'm getting ahead.
Thanks, Dave. Okay, we're returning to Gaming Commission's public meeting number 390 after a short break. I'll do a roll call. Commissioner O'Brien.
I am still here.
And Commissioner Hill.
Alive and kicking.
That's a good thing. Commissioner Skinner.
I'm here.
Commissioner Maynard.
I'm here, Madam Chair.
Great, thank you so much. And particularly Jordan, again, thank you so much. All right, Mark, I'll turn to you. Thank you. Thank you for your patience today.
I'm in it for the long haul, Chair.
Wait, say
Good
it again?
afternoon. I said I'm in it for the long haul, so.
Yeah, well, you're not alone.
Well, good afternoon, Chair. Good afternoon, Commissioners. I'm going to bring to you first a discussion on efforts from the Research and Responsible Gaming crew on the implementation of the Sports Wagering Act. I'm going to combine H and I on your agenda into just one piece before we pivot and turn to the ad hoc sports wagering report, which is number 4 on your agenda. So the Research and Responsible Gaming team reviewed the act regulating sports wagering. Generally, we're pleased to see that the legislature and governor expressed a continued commitment to studying sports wagering impacts with a keen focus on preventing and mitigating gambling-related harm. Embedded in the new law are many specific responsible gaming requirements, and we feel confident that we're prepared to implement each one of those. The good news is that we're not starting from scratch. Since the passage of the Expanded Gaming Act in 2011, the MGC has successfully implemented a number of measures intended to promote positive play and reduce gambling-related harms. Much of this work, or not all of this work, is really built on a responsible gaming framework, which aims to create a sustainable, socially responsible, and accountable approach to gambling in the Commonwealth. We believe that with some adaptation of this framework, that it's well suited and can be used in our approach to sports wagering as well. As you're aware, we've also produced 2 white papers in the past year or so that are intended to inform measures related to sports wagering. The first, which was released last June, just over a year ago, was a white papering on responsible gaming considerations for responsible gaming policy and practice. And the second was a white paper on responsible gaming considerations for advertising that was produced and released just a few months ago. And not least of which, and coming up just next week, we'll be hosting a sports wagering roundtable that will focus on responsible gaming, where we will be inviting a number of experts in this field to come and share their thoughts, opinions, ideas, and expertise on the implementation of sports wagering, especially in a digital space. So we've identified 3 responsible game requirements in the new law that really build on existing efforts. In Section 13 of the new law, there's voluntary self-exclusion, as well as self-imposed limitations. Section 4 includes operator-employee training on responsible gaming and problem gambling. And so while there are efforts in each of these areas, the Commission will certainly want to consider what changes in these measures should be made to accommodate sports wagering, especially in this digital and online platform. So for example, I think a key issue that's being discussed is when we think about voluntary self-exclusion, are we talking about one overarching list that would incorporate sports wagering and casino gambling, or are we talking about two separate lists? Or another example would be the requirement of self-imposed limitations. How should this how should the Commission execute this? Should we look at a model that's very much like Play My Way, Or should we look at branching out and more broadly understanding what play limitations mean? I think this will include a conversation with some experts in the field, a literature review, and possibly understanding also what technology is available for us to implement such a measure. There are other responsible game requirements outlined in the new law that we'll need to implement. And certainly where possible, we'll, as I mentioned, we'll turn to the framework. We'll look at models in other jurisdictions, and if possible, look at best practices in the specific area. So for example, advertising, credit prohibition, or consumer access to account history and details, all of which are included in this bill. The Commission will need to draft regulations to support. And certainly last but not least is the question about how to adapt the GameSense program to sports wagering in a digital format. GameSense has been a cornerstone of the Gaming Commission's responsible gaming approach now for a number of years. And I recommend that the Commission take a very close look at how we can continue to advance GameSense into this space. And it has been done. For example, the British Columbia Lottery Corporation uses GameSense in a variety of ways that I think that the Gaming Commission should consider. There may be other jurisdictions as well that would shed some light on this area. Turning to, are there any, before I turn to research, are there any questions just about the responsible gaming and requirements and how to approach it?
Commissioners, questions for Mark at this stage? All set?
Great.
Okay, thank you.
Okay. So turning to the research agenda, we're pleased to see that the Sports Wagering Act also has specific requirements related to research. And I don't take this lightly. I think that Massachusetts and the Expanded Gaming Act, and again with this, is unique. We have a commitment to research that pretty much no other state has. And this commitment is, as I interpret it, is really there to inform the Commission, to inform other stakeholders on how to proceed. How do we maximize the benefits of gaming in the Commonwealth? And equally important, how do we mitigate harms which may come from it? And this can and should be driven by our research agenda. There are 3 specific requirements related to research outlined in the law. Section 23 of it is a requirement basically that directs the Commission to align the objectives of the sports wagering research agenda with the existing research agenda that's outlined in Section 71 of 23K. And the underpinnings of this section require the Commission to conduct research to understand the social and economic effects of gaming in the Commonwealth and obtain information relative to neuroscience, psychology, sociology, epidemiology, and etiology of gambling. The Sports Wagering Act also directs the Commission to integrate 2 studies, Section 20 and 25, to the existing research agenda that will help understand the impacts of sports wagering in the Commonwealth and provide recommendations to the legislature. Study 1 is a study examining the feasibility of allowing retail locations in the Commonwealth to operate sports wagering kiosks. This was mentioned earlier today in our discussion with Treasurer Goldberg. The second study is a study on the participation by minority business enterprises, women business enterprises, and veteran business enterprises in the sports wagering industry in the Commonwealth. So we've begun to scope out each of these studies, and have been discussions with the SIGMA team to explore options of perhaps amending their ISA to include one or both of these studies in the existing ISA for our research agenda. Well, we'll pivot to the new requirements of this law. You can see that actually we've been examining sports wagering for quite some time, sports wagering behavior specifically. many of the studies posted on the Gaming Commission's research agenda, the Gaming Commission's website, the research agenda page includes a number of studies that include an examination of sports wagering behavior. This has been important, will continue to be important, because we recognize that understanding sports wagering behavior doesn't work in a vacuum, that it's really understanding gambling behavior more generally that gives a better picture of where we need to go in our mitigation efforts. So this information you'll see in the coming agenda item has been used already and will be included in the study that Dr. Bolder and Dr. Williams will be discussing with you. So just to conclude, there's a lot of work to be done. There's a lot to consider. And while we have somewhat of a roadmap on how to proceed here, there's still a lot that is unknown. Sports wagering is new, and it's very, very new in the world of responsible gaming.
Mark, could I follow up on the research, and I'll turn it over to my fellow commissioners? I know that there's a very aggressive deadline, and there's a way to get a study done of the right scale, and that deadline in December. And then I know we have resources to be able to, maybe flesh out the research more down the road. You mentioned that you're speaking with Dr. Goldberg's team.
Correct.
Is that because there is room on her current contract to include these two without additional or expansion of the cost of the contract?
There would be an additional cost within the contract.
Okay, so
but we believe it's the exploration is, does this fit within the original scope that's outlined within the original RFR and the existing contract?
I'm wondering if there's an opportunity here for some, if this is where would there be an opportunity to I'm thinking about both, because I think both studies impact people in communities of color. I would love to see on the research team a diverse team, and I guess I would, we're literally going to be talking about, I know both spells out the statute, the impacts on MBEs. So can you give that some thought, whether there's a partner for Dr. Goldberg or whether it gets procured out? These are just, it's an opportunity here. And, we have a statement of purpose that we follow where we prioritize intentionally around these issues. So
we can certainly consider that. There's the bind is one, if this is well suited for the Sigma team, it's within their sort of scope of expertise. That is important information. Two is,
are you saying is it, or that it's
I believe it is within their scope of expertise.
Confirmed it is, okay.
And next, making sure that it's within the scope of the RFR that we're allowed to do so. And then finally, it is the very, very tight timeline of trying to move these two projects, research projects forward. And
perhaps there's someone at UMass that she can think about in terms of bringing to her team of color, at the very least. I think it just would be an opportunity for that voice to be heard. So, but I don't want to, I didn't mean to jump in. I just have to have that on my mind. Other questions from Mark on these issues? Either the research or the RG part. I'm really interested in learning a little bit more about the game sense piece, Mark, and the mobile. I didn't realize that British Columbia's lottery was doing something, so I'd like, or maybe I forgot, so I don't know what it really looks like.
I'll need to get more information as well.
Okay, good. I'm not so behind then. But Karen, I think on the diversity issue, maybe there's an opportunity here. I don't want to pass it by if there's an opportunity.
And I think your suggestion of being creative and maybe within the contract, I think that the thinking behind using the existing contract is because the parameters of time are so.
Right, I'm aware of that.
So I think that's a good idea to explore.
Well, and there's also, if we think about it, it's almost, we do some kind of a report for that time frame. If we do in fact move forward, then maybe there we really flesh it out. But again, to the extent that Dr. Bolberg is, I don't know if she's hearing me now, and maybe she'll, if she comes on, but I do think it would be, there she is, just perhaps an opportunity. Dr. Bolberg, were you listening in?
Yes, Madam Chair, I was. Can you hear me?
I can. I wondered if you wanted to comment.
Well, I would like to comment. First of all, our research team is not entirely devoid of diversity.
Good.
We have, for example, a PhD student. His name is Alvaro Castro Rivadeneira. He has been working with us since 2018, I believe, when he started in the graduate program at the Department of Epidemiology. He's actually going to be doing his dissertation using our data. And he has been responsible for managing a good chunk of our key informant interviews and focus groups that we conducted the last 2 years, or in a broken way, in Springfield back in 2019, and then in Everett and surrounding communities more recently. So we do have someone on our team who is fluent in Spanish. He's originally Ecuadorian, and he has, at this point, quite a lot of gambling research experience as well. The other thought that I have is I could approach a group that I've been working with sort of informally over the last 2 years at the University of Massachusetts Center for Community Health Equity Research, where there are a number of investigators. They are not focused on gambling at all, but they do have very good connections in both the Everett and surrounding communities, as well as even more so, I would say, in Springfield and Holyoke and surrounding communities.
That's those resources are included. I'm glad that you did hear me, because I knew that there'd be a good answer. But I just wanted to be sensitive to that and also create it as a true opportunity, Dr. Bolberg. I know that you are aligned with that priority as well, so thank you. Mark, are you all done with your report? And then
yes, yes, I am.
Okay.
Madam Chair?
Yes.
I've been sitting here, and obviously the law that was passed dictated some dates for these studies to be done. I think I'm going to offer my historical knowledge of the legislature here for a moment, so bear with me. When the House first took up sports betting, we put in dates that we thought would be appropriate, because we thought the bill was going to pass sooner than it did. And those dates were the very same dates that were put in at the end of this bill that was signed into law. And I think the intent of the legislature would have been to give the Mass Gaming Commission more time to do these studies. 1.5 years, in fact, if you look at when we passed it compared to when it was ultimately passed. So I'm bringing that up for informational purposes, that I am not totally sure that the intent of the legislature was to have this study done in such a short amount of time. And when you look at the piece of legislation, and I shouldn't say this, but I'm going to say it because I think there are some who may be worried that we need to get this done as soon as possible. I'm arguing we don't. That when you're doing these pieces of legislation and you have 2 different bills, you have 2 different dates, and then they just cut and paste. and they weren't aware that they were giving a very short amount of time for the Mass Gaming Commission. And there's no language in there that says if we're not done by a certain date, that something bad happens to the Mass Gaming Commission. So I think as one commissioner, I want Mark to know and staff to know, you folks do spectacular work when it comes to the papers that you do and the reports that you do and the groups that you work with. And you do that because you're given a fair amount of time to do them. This is not a fair amount of time to do what we think. I think what the intention of the legislature was, I don't think they're giving you enough time. And I think it was done by accident. I don't think it was done on purpose. As we all know, it was put together early morning of the last day of the session. And sometimes when you're going through a big piece of legislation like this one, you sometimes miss things like dates from the previous bills that were passed in the House and in the Senate. So I, as one commissioner, and I hope maybe my fellow commissioners feel the same way, I don't want you to rush any report, any white paper, because of something that I perceive to be a mistake that maybe could be rectified later by the legislature. But I want people to know that that date has been around for over a year and a half. And it was, I think, just an oversight when they were putting the bill together, that they didn't change that to 23 instead of 22. I just want to put that out there, Madam Chair, for people to understand. And Mark, I know that you feel very strongly that this is what the law said and that you need to get it done. And I don't think I'm as concerned that we need to have this done by that certain date in the legislation. And I want to make sure that it's done right. So, Madam Chair, I'll just leave it at that.
Madam Chair, may I just say one quick thing? Any research project we have has certain steps that need to be taken before we even begin the research, and that's the scope, a thorough scope of understanding a timeline, what it entails, what is the methodology, what does analysis look like, and we're very committed to that piece of it and making sure that we hold to those research principles and process to create a report that the commission can stand behind.
Okay. I've given a little guidance. I think all of us have been subject to study dates and bills and laws for a long time. Brad, we've been on the other end. And, you know, when you are operating under statute, you meet the deadlines, but I mean, my guidance to Mark is you just give what you can that's reasonable for the deadline. And I would say that we're very fortunate to have a framework, research framework and resources that would allow them to really accomplish what we probably what should have been set out for the adequate time. But there's something that can be submitted to meet that deadline and then say appropriately more to come, of course. You know, today we heard from Treasurer Goldberg and she's very interested in this study. So it does need to be the quality that we come to expect from Dr. Goldberg and team and from Mark and all the researchers who support the work of the Gaming Commission. So I think we're all probably aligned. But I think former Rep. Hill, you should know that, you know, generally folks do take those dates seriously. And I think that's a good thing, right? But I do think you're right. It might have been just an error. Right? Because
Yes.
these are significant studies, really important. And not only significant in terms of the quantity of work that will be associated with them, but they're really important. So
I think they are, yes.
yes, they really are. So that's why I guess I wanted to make sure this is an opportunity, and Dr. Goldberg, I appreciate your outlining the community-based resources that you use. These two studies just speak for making sure that we have community voices involved and making sure that we don't somehow impact the communities of color in a way that we didn't mean to because of lack of representation. So I'll let you guys figure that out. But Mark, will we get a report on that and what the next steps are? Are you just planning on proceeding now? I don't know what the procedures are, Karen, honestly, on these matters, these studies. So it doesn't come before us. We'll just.
Yeah, not necessarily. I mean, my expectation, we give an update as an agenda item, but I don't think there's any commission action necessary, at least at this point.
Yeah. Okay. Should we turn to the next matter then, Mark? You want to tee it up?
Sure, I would be glad to tee it up. Dr. Volberg and Dr. Williams, one thing before we launch into the ad hoc sports wagering paper, just a quick clarification of their affiliations. On the agenda, it affiliates them with the UMass Donahue Institute. The UMass Donahue Institute is an important partner in our research agenda, and they are a subcontractor for this Sigma project, but Dr. Volberg nor Dr. Williams has a direct affiliation with them. So Dr. Williams is professor, faculty of health sciences, and coordinator of the Alberta Gambling Research Institute at the University of Lethbridge in Lethbridge, Alberta, Canada. Dr. Rachel Volberg is a research professor at the School of Public Health and Health Sciences at the University of Massachusetts Amherst. Together, they are the co-principal investigators for the Sigma project, which is the social and economic impacts of gaming in Massachusetts. So just a quick clarification on their titles. I hope I got that right, Dr. Volberg, Dr. Williams. So it's been well over a year. The Gaming Commission saw an incredible likelihood that sports wagering would be coming to the Commonwealth, and therefore wish to begin to do lay some groundwork to understand it. The white paper that I mentioned in my last piece, looking at the responsible gaming framework and looking at how it may be applied to sports wagering, was a step in that process. The report coming to you today is another step in that process, the ad hoc sports wagering report. So last fiscal year, we had a few reports, one or two, where the Gaming Commission could define exactly kind of in sort of mid-stride, mid-fiscal year, a topic that they felt would be worth taking a very close look at. The Gaming Commission in November of last year said it would be really important for us to take a close look at sports wagering and understand the impacts that may occur with the introduction of the legal sports betting in the Commonwealth. So the report that's coming to you today is the final product of that ad hoc report. So they didn't have a lot to work with, quite honestly. But what they did do is they examined the current status of legalized sports betting in the US. They did a thorough, comprehensive literature review on demographic and behaviors of sports bettors, attitudes about sports betting, harms associated with sports betting. And then finally, and certainly probably most importantly, they took a look at what research was already done in Massachusetts to examine sports betting behaviors, as well as the NCPG, National Council on Problem Gambling, had done two different studies, one in 2018, one in 2022, that did a national survey of sports betting. And so together with those pieces of information, they bring to you the report today. So I will turn it over without any further explanation to Dr. Wolberg and Dr. Williams. Thank you.
Thank you, Mark. So I'm going to hopefully be able to share my screen with my slides. If I'm not able to do that, I'm going to have to lean on you and ask you to share your screen and advance your slides, or perhaps Marie Claire can do that. So let me do this. Oops, sorry. Let me.
Hi, nice family.
That's my my father, my daughter, and my niece from a couple of Christmases ago. So
Dr. Bulberg, it's reminding me, one time during your presentation, you had the entire parade go by your head, and do you remember that?
I'm sorry?
Do you remember when you had? It's reminding me, one time you had a parade go by your office.
Oh, yes. Yes, that was early in the pandemic.
It was.
And they were protesting something, and I happened to live on the same street as one of our city council members. So they did a drive-by protest right in the middle of some presentation that I was giving. Hopefully that won't happen today.
That was a pandemic moment that I wish we had caught on tape. You know, we probably do have it on tape somewhere.
Yeah, it probably is on tape somewhere.
Yeah, exactly. Yeah, thank you.
So can you just confirm that you're seeing my screen?
We can. We're all set.
Okay. All right. I just want to start by saying that you're mostly going to be hearing from me. The reason I asked Rob Williams to join us is because he is deeply knowledgeable about both sports betting and online gambling, as those have rolled out internationally. And so I thought, rather than just taking questions myself, that if anything came up that I felt was more appropriately answered by him, that I would just put him on the spot. So I'm going to present the slides, and then hopefully we'll have a little bit of time for questions. So in March of 2013, the Gaming Commission selected our research team based at the University of Massachusetts Amherst to carry out the study, the social and economic impacts of gambling in Massachusetts. It included a comprehensive baseline survey of gambling behavior and problem gambling prevalence that was conducted in 2013 and 2014, well before any of the new casinos became operational. But since 2013, we have been collecting and analyzing a wide array of primary and secondary data. In 2019, the Gaming Commission re-procured the study and selected us to continue it until, I believe, mid-2025. So this slide provides an overview of the structure of the report that we have submitted. In the interest of time today, I will not be discussing the history of sports betting in the US. When we get to identified outcomes, I will be focusing only on the substantial amount of data that we have on sports betting behavior here in Massachusetts. But there is a tremendous amount of additional information in the report on national trends, as well as a review of the scholarly literature that is primarily focused on jurisdictions outside the US. So this is a slide showing the methods that we use to collect the data on sports betting legalization, regulation, and operations, as well as some of the social and economic impacts. And you've already heard a little bit from Mark about what we did, so I won't go into any detail here. Sports betting has been widespread but not legal throughout the United States since the 1950s. And as I'm sure you all know, in 1992, Congress passed the Professional and Amateur Sports Protection Act, which prohibited states from sanctioning or sponsoring sports gambling. But despite the legal prohibition, sports gambling continued to be popular. And in 2011, New Jersey passed legislation to legalize sports betting and was immediately sued by the major professional sports leagues as well as the NCAA. 7 years later, in 2018, the Supreme Court ruled that the federal government could not prohibit states from allowing sports betting, and the race was on. So this slide shows, it's taken from the American Gaming Association's website. We accessed it, I believe, on May 16th. But this legend here serves as a helpful synopsis of the development of sports betting across the United States. This table presents information about the types of sports betting operations that are permitted in the states that had legalized sports betting as of May 2022. It shows that 2/3 of the states passed legislation that permitted both land-based and online sports betting operations, while nearly another quarter of the states passed legislation that permitted only land-based operations. 3 states elected to pass legislation permitting only online sports betting. And while it's not shown on this table, there are 4 states that elected to provide sports betting only through amendments of state tribal compacts to allow sports betting at tribal casinos or on tribal land. In addition to the variation in permitted types of sports betting, there is tremendous variation in tax rates, in licensing fees, in the types of wagers that are permitted, in acceptable forms of payment, in the data that's used to establish odds, et cetera, et cetera, et cetera. So we were only able to identify 16 states of the more than 30 that we looked at that allocated funds to provide services for people experiencing gambling problems. 6 of the states that do not provide funding up there in this group here, 6 of these states have sports betting only at tribal casinos or on tribal land. And the states that do provide funding have either specified specific amounts to be expended annually or a percentage of tax revenues generated by sports betting in that jurisdiction. So in conducting our review, I was interested to see that each state has had to balance the demands of existing gambling operators, including casinos, lotteries, racetracks, and tribes, with other stakeholders that would like to offer sports betting as an adjunct to other retail services, including bars and restaurants, but also sports arenas. There is substantial variation, as this slide shows, in the government agencies that have been given responsibility for licensing and or operating sports betting. But the most common approach has been to designate the casino regulator, which is certainly the case here in Massachusetts with the legislation that passed here. The next most common approach is to designate either the state lottery commission or the agency that operates the lottery. There's another approach is to include sports betting in compacts with tribes already operating Class 3 gaming, as I mentioned before. The number of licenses also varies. More variation in whether states will require licensing fees, both either upfront or as renewal fees. About half of the states require license fees. There are restrictions placed on the types of bets. This is primarily focused on whether or not to allow betting on collegiate sports. The one area where there is great consistency, however, is in the age limit set for sports betting, with only 7 of the 31 jurisdictions, the 30 states and the District of Columbia, allowing people aged 18 and over to participate. The rest of these jurisdictions require the bettors to be 21. So turning now to operations, the main direct economic effects of legalized sports betting we anticipate will be jobs and income derived from people obtaining employment in the new sports betting industry. There are going to be indirect economic effects. These include business-to-business purchases needed to provide sports betting. And then there will be induced effects, which are generated by people who are employed in this new industry, spending their income in the states to purchase goods and services. However, as we note on the slide, these indirect and induced impacts will not be entirely new, since the majority of these impacts already occur due to the illegal market. So I just want to sort of underline for you that the anticipated revenues from sports betting in Massachusetts really are much smaller than the revenues that are already being generated by the Massachusetts casinos and by the Massachusetts lottery. So even in the best of scenarios where sports betting generates a little over $60 million a year in tax revenue, that represents only about 5% of the revenues generated for the state by the Massachusetts lottery, and about 35% of the revenues generated by the casinos. So I want to turn the focus now to Massachusetts specifically and present some information from the variety of studies that we have conducted as part of SIGMA. So you can see here a list of the surveys that we have done. The baseline general population survey and baseline online panel survey were done quite early on. We had targeted surveys done in Plainville and in Springfield 1 year after each of the casinos in those cities opened. We completed earlier this year a follow-up online panel survey at the same time that we were in the field with our follow-up general population survey. And then last but not least, the Massachusetts Gambling Impact Cohort Study was underway in Massachusetts from 2013 to 2019. So in practical terms, the existence of SIGMA means that we actually have a very substantial amount of information about sports betting in Massachusetts prior to 2018, when PASPA was overturned. However, only the general population surveys, the baseline and follow-up, yield data that is representative of the Massachusetts adult population. The online panel surveys and the cohort study provide important clues to what was happening with sports betting in Massachusetts since 2013, but those data cannot be generalized confidently to the population as a whole. So this graph is from the baseline general population survey and shows the frequency of past year participation in different types of gambling in Massachusetts back in 2013, 2014. And you can see that the lottery was clearly the most popular form of gambling, followed by raffles and then out-of-state casino gambling. So although sports betting was illegal in Massachusetts, as were casinos at that time, or I guess casinos had been legalized, but they were not operational, the past year rate of sports betting in our baseline survey was actually 12.6%. The other information that we have about sports betting in Massachusetts from that early date relates to the demographics of sports bettors. So we identified that men were twice as likely to have bet on sports in the past year compared to women, that sports betting was most popular among adults aged 25 to 54, as well as among those with college or graduate degrees compared to those with less education, or actually also to individuals with higher education at the doctorate level. And finally, respondents with annual incomes of $100,000 or more were more likely to have bet on sports compared to those making less than 50,000. So that's just a little peek at what we found out about sports betting back in 2013 and 2014. It aligns very well with what we know from the international literature on the demographics of sports betting as well. This table presents information about gambling participation from the baseline general population survey compared with the baseline online panel survey. And I just want to draw your attention to the fact that these are unweighted data. So this is not representative of the population. But what it does show you is that past year participation in sports betting was higher among the online panel respondents compared to the general population respondents for every type of gambling except raffles. So these were all quite significant differences. They were entirely expected because we know that online panels tend to include large proportions of heavy gamblers. This table provides a comparison between the baseline online panel survey that was carried out in 2013-14 and the follow-up online panel, which the survey was completed in April of this year. And you can see that the rate of sports betting was significantly higher in 2022, while the rate of pathological gambling, which is the most severe category of our typology of gambling, was also significantly higher in 2022. Now, the differences between these two surveys, in addition to time, these differences can be partly explained by differences in the wording of the questions we used about sports betting in general. Another potential reason for these differences is the use of different survey companies for the two surveys. And some of the difference likely reflects the introduction of legal fantasy sports betting in Massachusetts, which occurred in 2016. So the question of whether these differences are real or not will be very much informed by the analysis that we'll be doing over the next 6 months or so of the follow-up general population survey. This chart focuses on data from the 2022 follow-up online panel survey, and it shows that problem gambling rates, so this is problem gambling rates amongst people who are engaged in specific types of gambling, but controlling for the number of other types of gambling that they're doing. So we know that sports bettors tend to be heavy gamblers, and the question is whether it's a particularly risky type of gambling in and of itself, or if the higher rate of gambling problems among sports bettors has more to do with the other types of gambling that they're also doing. So going across, this graph shows problem gambling prevalence, so that's the percent, among people engaged with a particular format. So for this would be table games, and sports betting is this red dotted line here. And you can see that the rates clearly converge when people are engaged with 5 or more types of gambling. But what really stands out is that casino table games clearly represent a risky form of gambling even when people are not involved with other forms of gambling, whereas sports betting is much more in the middle of the pack. Finally, I have some data on gambling participation across the 5 waves of the cohort study that was conducted from 2013 to 2019. Again, while it's not representative of the population, the results do provide insight into sports betting behavior over this time period. So we started with a cohort of 3,139 Massachusetts residents. They were selected from the baseline general population survey and stratified and selected on the basis of their gambling behavior with oversampling of risky gambling. So this chart is actually not based on the full cohort, but it's based on the gambling behavior of the 2,087 individuals who participated in all 5 assessments. So this is lottery participation by the same people over 5 assessments between 2013 and 2019. What you can see is that lottery participation and sports betting, so lottery participation and sports betting here, remained pretty stable amongst these individuals, whereas out-of-state casino betting, gambling, dropped after the opening of Plainridge Park Casino, while Massachusetts casino gambling, so these are our new casinos, increased, particularly in 2018, excuse me, after the opening of MGM Springfield. And this is also an interesting change here, although it's small, online gambling did rise amongst our cohort members in starting in 2016 when daily fantasy sports were legalized.
Dr. Goldberg, could we go back to just that distinction?
Yeah.
On sports betting versus online gambling.
Yes.
Any overlaps there in that definition of online gaming?
No,
the definitions that this is always a little bit confusing when we say iGaming, sports betting.
Yeah, there is a significant amount of overlap between sports betting and online gambling. But in this case, and Rob, I'm going to ask you to clarify here because you're a little bit more familiar with the questionnaire than I am. I don't think
the casino play online, and that would be illegal in Massachusetts, but casino. Is it casino play online? Is it casino games online?
Yeah, in my recollection, I believe we asked about casino games played online. We also, I think we asked about esports.
Esports, okay.
Yeah.
We actually, it's Rob Williams here. We actually asked about any type of online gambling, sports betting, online casinos, online instant scratch tickets, online horse racing, any type of online gambling. So I was a bit puzzled by the increase in 2016, but it may simply be coincident with the general increase in online gambling that's occurring throughout the Western world in the last several years.
So it's okay. So it's a whole gamut. All right, that's really helpful. Thank you. But it is a weird increase, isn't it? Oh, thanks.
I wouldn't say it's weird. It's certainly discontinuous. I mean, those rates are now much more similar to what you would expect in other North American jurisdictions. The jump from 2 to 7 is a bit unusual for sure, and I'm not sure what accounts for that.
Thanks. Sorry to interrupt.
Okay, I just want to make sure we have time for a few questions. So when we look specifically at economic and social outcomes in the literature, the outcomes identified to date with respect to economic outcomes, there does seem to be mixed evidence regarding the question of substitution or cannibalization of other types of gambling. Although I have to say I was even more struck by the notable lack of research that exists on any economic impacts of sports betting. We literally only found 2 articles related to substitution or cannibalization, and nothing on any of these other economic impacts, which we believe would be very important to understand in Massachusetts. Job creation, recapturing gambling dollars from the illegal sports market or from neighboring jurisdictions that have already legalized sports betting. All of those are empirical questions for which we have no data at this time. And Another sort of caveat that we included in our review of the economic impacts is that there is a potential for economic harm in Massachusetts if sports betting does cause high rates of problem gambling, or if a significant portion of revenue from sports betting operations leaves Massachusetts. Turning to social outcomes, there is a very singular focus in the social research on problem gambling as the main negative impact arising from the legalization of sports betting. So at this point, we are estimating that sports betting participation in Massachusetts, based on the baseline general population survey, is somewhere between 13 and 20%. Of course, and as I've mentioned, we know that, or we'll know more precisely what that is once we have analyzed the data from the follow-up general population survey over the next few months. But we were able to compare Massachusetts state data from the Engage survey that was conducted by the National Council on Problem Gambling to both the national data from that survey, as well as a number of other states where sports betting has been operational. And we were quite struck by the evidence that sports betting in Massachusetts in 2018 and in 2022, that rate looks quite similar to what's happening at the national level. In terms of the national surveys, Don Feeney and Keith White gave a presentation at a webinar back, I think it was in March, where they discussed the fact that there was some evidence of increase in gambling harms in their national data. And we have noted that problem gambling rate is higher amongst sports bettors than it is among other types of gamblers, but that primarily seems to be because sports bettors tend to be involved with quite a number of other gambling activities. So there is the potential that legalized sports betting in Massachusetts could lead to an increase in rates of gambling harm more broadly, as well as problem gambling. But we think there's an opportunity here to, as we had with the casinos, to try to minimize and mitigate based on information that we have already available to us in Massachusetts. So getting to the end, the maximum economic benefits, which are different from revenue maximization, but maximum economic benefits for Massachusetts will depend on the sports licensees in Massachusetts capturing a substantial proportion of the illegal sports betting market. There is also the potential for some job creation, and of course there are tax revenues. So we believe that the benefits will be obtained by recapturing money that is either leaving Massachusetts because people are betting on sports illegally, or in neighboring jurisdictions. And the benefits are most likely to occur if we can generate substantial Massachusetts-based jobs and, of course, the tax revenues. So just to finish up here, there is a significantly higher rate of gambling, problem gambling and at-risk gambling amongst sports bettors in Massachusetts based on all of our Sigma data. However, the relationship between sports betting and problem gambling is not straightforward. And again, this is because sports bettors tend to be such enthusiastic gamblers on a variety of other things. So that said, there are groups in the population that are of particular concern as state-sanctioned sports betting becomes available in Massachusetts. And we have specifically identified adolescents, emerging adults, women, immigrants, college athletes, and individuals in recovery from gambling problems as groups that are of particular concern here in Massachusetts, based on a broader international literature. So there are quite a lot of recommendations included in the report, but I want to focus my final remarks today on our recommendations related to research and responsible gambling. We do think it will be important for operators to be required to provide player data to the Gaming Commission to allow a full assessment of the impacts of legal sports betting in Massachusetts. Another advantage to having access to player data is that this could potentially provide early warning signs of emerging issues. And it is very much our experience over the years that the Gaming Commission has much better success than we as researchers do in getting the licensees and operators to provide that level of information. There is good international evidence that in-play betting is disproportionately utilized by problem gamblers, and we believe the Gaming Commission would be wise to give careful consideration to whether and how to permit this type of betting in Massachusetts. And then finally, with respect to responsible gambling, we do think it will be important to require operators to provide RG features on all of the online sports betting sites in Massachusetts. I know this is not a very popular position, but we believe that these RG features should be opt-out rather than opt-in. They should include limits on deposits, losses, and time spent betting. There should be readily available information on cumulative money losses and time spent on websites. Automated alerts for patterns of betting that predict future self-exclusions. This is a type of study that's been done in a number of different international jurisdictions and seems to have provided some interesting information, but we'd like to very much see if those patterns of betting also predict self-exclusion in Massachusetts. Another idea we have that is a little bit innovative is to provide bonuses and rewards for responsible gambling actions rather than or in addition to rewards for increasing expenditure. And finally, we think it would be wise to restrict sports betting advertising and celebrity endorsements to the extent possible in order to prevent youth in particular and emerging adults from getting into difficulties. And that is all I have. Thank you. And this is, in addition to the Gaming Commission's research web page, we also have all of our reports posted, and you're welcome to come explore and be in touch with us if you have questions. Thank you.
Questions for Dr. Goldberg?
I guess that recommendation, first of all, thank you very much. This is, I mean, it's like voraciously taking in any information on sports betting. So it was great to get this in one spot. And I like a lot of the ideas, but some of them I wonder how we implement. So something like banning celebrity endorsements. I mean, I'm watching TV last night and, a New Hampshire thing comes on and they've got all sorts of ads for stuff. So do you know of any other jurisdiction that has implemented that kind of thing or how they did it?
Rob, correct me if I'm wrong, but I believe Australia and is it Italy have actually banned advertising? Is it just during playing time, or is it more general?
I can't remember the details, but certain jurisdictions have banned advertising altogether, and other jurisdictions have banned celebrity endorsements. Those are mostly European countries. I don't know logistics of how they do that, but they have done it.
Okay. And then your idea about the sort of getting the benefit for doing the responsible gaming. What's the model for who pays for that? I mean, is that an incentive that you get the licensees to buy into, or is that who would pay for that kind of incentive?
Well, I think it would be it would be incumbent on the licensees or the operators to provide those incentives. But there's so much that is provided as incentives to individuals to bet more or to bet longer. And Rob and I have had this discussion about, how could you incentivize people to, to behave, in ways that are sort of more aligned with what they may want to do. To be honest, I haven't really thought about how that would be paid for, but perhaps it could be a partnership between the operators and the Gaming Commission. And I'm sure that Mark could probably come up with some good ideas as well.
If I could, thanks, Rachel.
Under the bus, but doom.
We incentivize enrollment in Play My Way, which is a responsible gaming tool, as you know. So that is incentivizing use of a responsible gaming tool. We have kicked around and would love to explore ways that we would incentivize that going forward. Obviously, you'd need to be careful about what structure that takes. And I'm not putting any of our licensees, current or future, on the line, but there is a commitment to responsible gaming that I've seen, and I think new and innovative ideas are always on the table to accomplish that. Commissioner O'Brien, I was also, there's even the American Gaming Association on their responsible gaming code of conduct calls out celebrity endorsements or entertainments that would specifically appeal to youth. And so that is a pretty commonly accepted practice. However, how it's employed and to what degree with what success, I think, is a different question. But I think generally speaking, that is common and that is a good practice.
No, I mean, I like the idea of it, but when we have a market that, people were talking about billboards, you have the other out-of-state casinos not subject to the same rules in terms of what goes on a billboard, even in the Commonwealth. And now you've got potentially ads with celebrity endorsements coming in from out of state. It might be hard to do, but I like the idea.
Other questions? All set?
Okay.
Oh,
Just want to say excellent report. Excellent report.
Thank you, Commissioner. Thank you.
So we have the report, and of course we received the report, the draft form, Dr. Volberg, and that we passed it on to the legislature right before they passed the bill, so they have the benefit of it. We'll continue to use it as a reference as we do our work, and I guess that our next, I'm not sure what is next for your projects for us, perhaps these two important studies are going to be priorities for you. So
yeah, well, at the just
the
prior
general
sorry,
the general population survey, I know that is on your.
Oh yeah. So we anticipate receiving the data from NORC, which collected the data. We were out of the field in, I believe, late March of 2022, but because of some spending issue or resource issues, we have not yet received the data. So we are in the process of amending their subcontract so that we can get the data. And then there's going to obviously be a period of cleaning the data and analyzing the data. We have a report on the follow-up general population survey as one of our deliverables in FY23. I believe it'll be coming to you in first draft somewhere around March or April, I believe. So that's very much in the front of our minds. We also have the data. You got a little taste of the follow-up online panel data that we collected in April of 2022. We have some more work to do with that, as well as a small technical report that we're going to be submitting to the commission in early 2023. And and then at the end of the fiscal year, we included a report for the commission on gambling advertising. So that's going to be coming up, but further down in the list of deliverables.
Excellent. Excellent. Well, thank you. Don't imagine that our lack of inquiry is anything but it's been a long day. But all of these topics that you've hit on are so critical, and we have been thinking about them, and this has been a great resource for us. So thank you. A long day for you too. I just want to express my appreciation for your patience today. The time frame shifted enormously, so thank you.
If I can just make one final comment, Madam Chair. Several of the commissioners are new to me.
I can introduce you. I'm sorry.
That's all right. But I just wanted to emphasize that, between us, Rob and I have about 80 years of gambling research under our belts. We are always interested in questions that the commission may have, and we will always do our very best to be responsive to questions that you might want to send us by email.
So let me formally introduce you. I don't know if you've met Commissioner Hill. My apologies. I feel as though you must have presented in front of Commissioner Hill. Then, of course, we have Commissioner Nikisha Skinner, who joined us in March. Right? My memory's right.
That's right. Correct. Correct.
And Commissioner Maynard just joined us on the day that the law was, the bill was passed, August 1st. Well, he was appointed officially then. So Dr. Volberg and Dr. Williams, my apologies.
Nice to virtually meet you, Drs. Volberg and Williams. And as the chair said, our lack of questions at this point is no indication of our lack of interest. It has been a really long day, and we are just about headed into the evening. So I, for one, I have, kind of mush for brains at this point.
Absolutely, I understand.
Commissioner Maynard.
Well, I also echo Commissioner Skinner. As far as it's a pleasure to meet you both. We did review the document that you just went over. And again, our lack of questions, I think, is no indication for how we're going to use this data when we make decisions going forward on this important matter. It is a pleasure to meet you both. And if there's anything that we can do, same, please reach out.
Absolutely. Thank you.
Okay, Mark. Thank you. Thank you, Dr. Williams. We didn't hear much from you, but you were right there. Thank you so much for all the work. And Dr. Volberg, it's always great to see you. Mark, anything else? And everything, right?
Anything and everything, but enough for right now. Thank you, Chair.
Yeah, thank you. All right, then, we just have a little bit of business done for the official record. I don't think I'm making any grand announcements to the public, but we do have, we've got plans for sports wagering roundtables coming up. And one is, suspect we may see Dr. Volberg or one of her representatives. That will be on the 12th. Correct me if I'm wrong on these. Oh, no. The 13th is the roundtable. Yeah, thank you, Rachel. Thank you, Crystal. That's on the 13th, and that's on responsible gaming. We'll have experts from the field who will be looking precisely at the statute and giving their thoughts. So I suspect we'll be hearing from our friends at UMass again and get even more clarity on these matters. And then we are looking forward to the roundtable that's yet to be scheduled for the mobile operators, and that will come later in this month. We'll just keep on monitoring our website if anyone is still on. Okay, is there anything I haven't addressed right now? September 15th, we have another public meeting. We have actually a public meeting on the 13th with respect to the horse racing application on the, oh, I'm sorry, I'm losing, I need the calendar.
Monday is the application for the horse.
And what day is that?
That's Monday.
Yeah, Monday, the 12th. Oh, so thank you. I thought I heard no. Sorry, it's 12. So that's the 12th. 13th is the roundtable. Then we have the 15th, which will be on temporary licensing. So we're keeping busy, everyone. Thank you. Anything else? Okay, can I?
Chair, just one thing. I wanted to give Mark an opportunity to mention the Play My Way on Monday.
Oh my goodness.
Thank you. Just one quick comment. Thank you. So on Monday, Play My Way, the slot machine based budgeting tool will go live at Encore Boston Harbor. It's been in place at Plain Ridge Park Casino since 2015, at MGM since earlier this year in March. And so having it launch at Encore Boston Harbor represents a significant milestone that at every casino there is a consistent budgeting tool for patrons to use. So thank you very much to all of our licensees really for their work, their partnership in creating this and offering it to patrons.
Are you having a kickoff, and if so, what time?
I can get you there will be a press release going out. There is an opportunity for anybody from the press to come take a look and test Play My Way. I believe that's around 10 o'clock, Commissioner.
Thank you.
And Commissioner Hill, there is a conflict for us because we have a meeting, and that was what happened with MGM. So Mark and I were lamenting that, but I don't know if everyone received, I think all of us received the video that was done by Encore Boston Harbor, and we look forward to their continued partnership and hope that they continue to, that they also join in promoting. But I know that Mills is working on the press release, and we will certainly lead a Mark on the 12th, our meeting, with a Play My Way update. Okay, if it's at 10 o'clock, then we can announce at that very time. So I have no problem adding that to our agenda informally. And if we wanted to amend our agenda, actually, Crystal, we could do that too tomorrow to put Play My Way at the beginning of our meeting on the 12th.
Certainly could.
Okay, for an announcement. Okay. Mark, you'll be over Encore, I assume?
I will be at Encore Monday morning at 7 o'clock.
Yeah, so we'll just make sure to get a coordinated statements from you and to Karen. Okay.
Yes.
All right. So our efforts will be going on announcing. We just can't be there with you. Okay?
I understand.
All right. Which is a rats. And by the way, Jordan and I got to see how the Play My Way works. At MGM. So next time you visit, one of the facilities that Burke can arrange to have that opened, have someone use their card to show you how it works. Pretty smooth. Nice job, Mark. Okay, again, this has been a long day focused on one subject matter. We've certainly done that before on under 23K, and now we own 23N. Here we are. I just appreciate everyone's efforts on all the work that we do every day and all the efforts on this new responsibility. So,
Move to adjourn, Madam Chair.
pardon me?
Move to adjourn.
Yeah, can I just say, Commissioner Maynard, please enjoy the rest of your day. Thank you. We're very.
It almost looks like the sun is set on you.
I have plenty of sunlight left in Park City, so that's one benefit to starting this meeting at 7:30 this time. So I plan on using it.
Good. Have a great rest of the day. There's a motion on the table.
Second.
Thank you. Commissioner O'Brien,
Aye.
Commissioner Hill,
Aye.
Commissioner Skinner,
Aye.
Commissioner Maynard,
Aye.
and I vote yes. Thank you, Karen. Thank you, Todd, and thank you all.